I'm trying to change that. You know.
Good morning. Good morning. It's so very nice to have you here today. My name is Ken Burke, and I'm clerk of the Circuit Court and Comptroller for Pinellas County, and have the honor of serving as chair of this task force. I wish to welcome all our guests who are here with us today from the public. It was certainly nice to have you here. We know it's an effort for you to be here. You probably don't normally come to this beautiful epicenter on a Wednesday morning, but we're glad to have you here and participating in this important task force. I think everyone here in this room is dedicated to making the system better. And that's the purpose of this task force, is to make legislative recommendations to improve the system and to safeguard the wards. So that's what our overall focus is as we get started here. And we'll go ahead and around the task force members and start with the introduction. Just introduce yourself. And again, you don't particularly represent your organization, you represent the perspectives of those organizations, because we're here as an individual member of the task force to speak on your own behalf.
I'm Mike Donovan. I work for Legal Services in North Florida.
I'm Tina Cribbin, and I work with the Office of the Public Guardian, and I'm representing the perspective of the Public Guardianship Coalition.
Thank you.
I'm Viviana Bonilla Lopez. I'm an attorney at Disability Rights Florida and representing the perspective of the practitioner.
J.D. Gark, I'm the clerk in County, Florida, and I'm representing the perspective of the role of the clerks in relation to guardianship.
Jose Ramon Rodriguez, retired judge from Orlando, position of Jose Rodriguez, judge in Miami.
But you're the good one.
I'm a little smarter. Better looking. I don't know that it buys that. But I am, as a retired judge, I've been in the trenches, so I can give some input as to what we suffer, what we go through. And I'm also a professor of law. I teach guardianship, curriculum that I develop at Barry University Law School, School.
Thank you.
I'm Jennifer Bradley. I'm a state senator from North Florida, and I hope to share a legislative perspective.
Good morning. I'm Anthony Palmieri. I'm the Deputy Inspector General and Chief Guardianship Investigator for the Clerk of the Circuit Court and Comptroller in Palm Beach County. I'm here as the Vice Chair, representing the perspective of the Statewide Investigation Alliance.
I'm Tom Paul. I'm a consultant with the FCCCC.
Good morning. I'm Karen Murillo. I'm with the Office of the Attorney General and Statewide Prosecution, and I'm representing the perspective of a prosecutor here in Florida who handles exploitation cases.
Good morning. I'm Sean Cadigan. I'm a magistrate in Hillsborough County, and I do guardianship and mental health, and also supervise the Elder Justice Center, which is one of our court programs.
I'm Shannon Miller. I'm here as a member of the Elder Law Section of the Florida Bar. I also serve as a guardian for a couple of cases and represent the guardianship attorney perspective as well.
Hello, I'm Crystal Kenzo. I'm the Clerk of Courts and Comptroller for Collier County, and so I too will be working on the clerk's perspective and what we do as process. Hi, I'm Linda Williams. I'm here for Bob Astales. He's our Deputy Executive Director, and he had another commitment for today. But we're very interested in guardianship matters because we have 6 state veterans nursing homes and 1 domiciliary in Florida, and we're about to open 2 new state veterans nursing homes. The demand for state veterans space in nursing homes is estimated to require over 30 homes based on population studies of the federal government. And very often when people reach a time in their lives when they may need a guardian, it's important to have good processes in place. In Chapter 744, Part 8, Florida statutes is dedicated to veterans guardianship. And I hope to share some information about how there may be some resources to help with that.
Thank you, ma'am.
Good morning. I'm Shantae Jones, the Executive Director of the Office of Public and Professional Guardians, representing the perspective of the Florida Department of Elder Affairs and Secretary Richard Pruden in his absence.
Thank you.
Good morning, everyone. My name is Hillary Hogue, and I am here on behalf of the victims and people, whether they're the elderly, the disabled, or minors with settlement, who are wards of the state of Florida. And I am giving their perspective proudly. Thank you.
Hi, and I'm Zane Smith with AARP. I'm an Associate State Director for Advocacy and here to represent AARP.
Great. Thank you so much. A meeting like this just doesn't happen. And so there's some thank yous I have to do, and it's proper and it's important because a lot of people put their effort into making this happen. I first of all want to thank St. Petersburg College and this beautiful facility for hosting us, and especially Becky Biglin, who's in the back there. She's a facilities person. She's been working with us the last 2 days to make all the logistical things happen here. Becky, I certainly appreciate your cooperation in making this facility available to us and helping us with all the logistical concerns. Also, I want to thank, of course, Tom Hall, our consultant, Sarah Sanders with the association, the Clerks Association, Beth Allman with the Clerks Association, Kimberly Resby with the Clerks Association, Patrick Menderfield with the Clerks Association, and their boss, Jason Harrell in the back, who allows them all to work on this project. Jason Harrell, we appreciate you and all the employees of the Florida Clerks Association for providing support for this task force. I also wish to recognize the good people I get the privilege of working with in the Pinellas Clerk's Office who've been helping with the planning for today. Karen Lamb, who took our notes from the meeting the other day, and these were sent out very promptly, if you noticed, and very thoroughly, and you have copies of those notes. Chris Short, who's been handling with the technical crew, making sure the YouTube works and the WebEx works and all the local things here work in coordination with the AV folks. Connie Daniels and Pam, who are make sure our lunches are arranged for today and the coffee. And so I want to thank them for their good assistance here today also. And then our wonderful sheriff from Pinellas County was kind enough to provide a deputy sheriff for today's, in case, Tom gets wild and crazy. We have a sheriff here to keep him in order. And that's Deputy Sheriff Perry Warner. We appreciate you being with us today. And also our folks who are making the YouTube work, Brian Harder and Justin Vasquez. Did I get close to there? Kind of. I got the Justin part, half right, Maybe Judge Rodriguez could help me with these names, But I want to thank all of you for your work to make this event possible. The executive director of the Florida Court Clerks and Comptrollers Association is the person I had to go to make sure that we had all this support. And he saw the great need for what we are doing here today and how important this is to the state of Florida. The clerks are very fortunate to have him as our executive director. He's a former legislator from Hillsborough County. Don't hold that against him. Either one, that he's from Hillsborough County as a former legislator. But he's all around great guy. Please welcome Chris Hart for some words of welcome.
Thank you, Ken. I always like to remind Clerk Burke that Pinellas County at one time was part of Hillsborough County, so I feel very much at home here in our home county. Again, my name is Chris Hart. I do have the honor and privilege of serving as the executive director for Florida's 68 clerks and comptrollers. They're all independently elected officials, constitutionally elected officials throughout the state. And when they come together, though, collectively, the 68 of them, they're always centered around a common mission, and that is that they are united statewide to protect the public trust. And as we started thinking about the issues that were surfacing in the guardianship program as a result of audits and conversations and discussions that clerks and comptrollers and their auditors were having, we started to ask ourselves the question, what's the best way for us to hold this conversation so that we can hopefully find some impactful solutions? And
oftentimes you look inwardly. We all do, right? I mean, that's where you start. So within our own organization, what could we do? Do we need to form a work group, or you'll find this, Senator Bradley, another subcommittee? And the answer really became no, because we quickly realized as we were talking through some of these matters that it was much, much bigger than us as an association. Yes, clerks, comptrollers, auditors, major players in this with all of you. However, they knew that they needed to do something else. So the conversation then led us to talking about, well, then what do we do? And that's what brought us to this task force. The task force, as you all well know, I think our chairman has done a good job, an extraordinary job actually, of explaining how this will work. But this is not us, the Florida Court Clerks and Comptrollers. This is not our association. We are very pleased, and Chairman Burke actually introduced a number of our team members. We're pleased to support you, but this is your task force. You all are assembled as a task force to bring forward your collective decision-making, your collective priorities, your collective solutions. And we're going to do everything that we can to help support you in that. I'm going to tell you, I was telling Senator Bradley, I actually met her husband years ago because he and I served on another task force. In my previous life, I've had an opportunity to chair 3 statewide task forces. What you all are doing here is not easy. But as I went around and introduced myself to a few of you, I think the way I was categorizing it is, this is really a historic moment in time. And I was listening to all of you last week as you were explaining your backgrounds and experiences and perspectives, really kind of giving us your living bios. It was so evident that this is the right assembly of the right people at the right time to tackle the big issues that we have here in the state before us. We thank you on behalf of all 68 of our members. We thank you for dedicating your time, your talent, your resources. We believe that as you bring forward the priorities through your report, that it will undoubtedly receive a lot of traction within the public. And I would imagine that it's going to garner significant conversation at the executive and legislative levels as well. So not to put too much on you, but y'all are kind of a big deal. So with that, I'd like to turn this over to all of you and your capable chair, Ken Burke. Thanks, sir.
Thank you, Chris. And although we didn't rehearse this, it's a perfect segue into 2 additional items here. We did put great thought into the task force composition, and someone helped us get it right a little bit more at last meeting. But we would ask you, and obviously motions can be made, but really I think we have to finalize this task force as it is now, with this composition. Now, so I would ask that potentially no additional members be added, because I've heard from several that, oh, my side's underrepresented and we need to add a few here and a few here. But I think we got the perspectives that we need here. And, you know, hopefully we'll muddle through our work in a great fashion and have a great result. But that's, again, up to y'all as a task force, but that's something I'm expressing my opinion on early on, that I think the composition is right and we should leave it as it is. Sanchez, good to see you. Would you please introduce yourself? Good to see you.
Certainly. Thank you. I apologize. Sancha Brennan. I'm a real property, probate, and trust law, largely guardianship law practitioner from Central Florida, practicing in Lake, Orange, Osceola, and Seminole counties. I'm also on the leadership for the real property, probate, and trust law section of the Florida Bar. Thank you.
Thank you for being here today. The end result of our work is a report with legislative recommendations. And we can do great work and put together a great volume. And Tom Hall, and just so you know a little bit about Tom, he's an attorney. He's a former chair of the former clerk of the Supreme Court of the state. And I got to witness him at the Supreme Court building when he was clerk. And then he is practicing law now and is also a consultant with our association. Tom is going to be charged with writing the report, and we couldn't ask for a better person, more thoughtful person, a person with great extensive knowledge in how these reports should be worded and presented so they have the most effect. And so it's wonderful that we have this resource in Tom Hall. But getting to that point is we can have a great report, and unless it's received well by the legislature, and unless there is advocacy on a whole bunch of our parts after the report's done, it's really not very effective, because to make it effective, it needs legislative action. And Senator Bradley, you traveled a long way to be here today. That shows a tremendous commitment. Our other legislator, Representative Burton, just went through some knee surgery on Monday, so she has a darn good excuse for not being here today, and she really wanted to be part of this meeting. But Senator, we are so grateful for you being here. We're all equals in this task force, but maybe some are more equal than others when it comes to action that can happen afterwards. And you certainly, as a respected member of the Florida Senate, it's just vital that you're a part of this task force. And thank you for accepting being a part of it. And I would certainly appreciate, and I'm sure the task force members would appreciate your comments from the legislative perspective of the whole guardianship issue. Senator Bradley.
Thank you. Thank you, Ken. And I can't tell you how meaningful it is to me to be a part of such an esteemed group on such an incredibly important issue. When I think of the role of government, protecting our most vulnerable is right at the top. And it's not something, this issue has so many moving parts. It's not something you can bring one individual. So as I look out and I see perspectives from all across the spectrum coming together to have this meaningful dialogue, that is, this is going to be a really productive, fruitful task force. I look forward to the recommendations, to the input, to hearing from members, but also from the public, and really working together to craft some solutions. We don't need a good guardian system. We need the best guardian system. For the wards that the state is charged with taking care of. It's serious business. And I look forward to just doing a deep dive and making sure we have the information we need, we have the process we need, that we have the laws that we need to protect everyone and have the best system that Florida can possibly provide. So thank you.
Thank you, Senator Bradley. And that's our goal too. So we share that, and we, again, your presence here today and being part of this task force is so meaningful, and I thank you for that. And the good senator mentioned about hearing from citizens. So let's talk about our comment cards, because at the end of the meeting, we have approximately an hour set aside for public comment. And we're going to do it. Kimberly, would you stand up and wave at everyone? If you have a public comment card, please turn them in to Kimberly. She's going to mark them in the order that she receives them, and we will call you up in that order. We're going to give preference to the folks who've went through the trouble of being physically present here today. They get top priority. And if we have additional time beyond that, then we have a system of the folks who are watching on YouTube to participate in the public comment too, if time allows. But again, priority will be given to the folks who are in the room here, who made the effort and you're limited to 3 minutes. We're going to strictly enforce that. We're going to have a person there to help you to show when you have 30 seconds left and 10 seconds left, and when you have to stop your comments. And I will say to the task force, and some of you have been involved with public entities before. Some of you have not and may not be familiar with public comment. But the public comment time is for the public to comment and for us to listen. So it's not an engagement. We don't get in conversations with the members of the public who wish to make comments. That's their 3 minutes to make comments. And we sit, we listen, we take notes. I would also invite anyone on YouTube who's not able to be here today, but wishes to be heard through other means. Our website that we now have available does have a section in there for public comment. Anything I've been receiving, and people have been emailing me already, I've forwarded to our Patrick and to our staff at the association to put that onto the website. And I will assure you that the members of this task force will be receiving those postings and have a chance to review those and make note of those. So your input can be heard that way too, through the website and the public comment that's available there. We are very open to hearing from different folks. Remember though, in your public comment, and this, you can public comment, that's one of the beauties of public comment. Those of us who go to Board of County Commission meetings, know a person can go up there and speak about immigration, even though the county commission doesn't handle immigration. We allow any topic to be brought up during your 3 minutes. Here though, although you certainly have the right to talk about any topic you want, think about what the purpose of this task force is. And the purpose of this task force is legislative recommendations. And so if you think about it, if your comments probably are most effective, if you talk about a topic where there's a legislative solution and maybe potentially say what you think the legislative solution should be. And that would be helpful to us because we can't solve every problem out there, but we can solve the problems which can be answered through statutory changes. And so those recommendations probably are most germane to this task force, and you may want to consider that in your public comment. Again, you can say anything you want in your public comment as long as you use good language and it's not in any way discriminatory. But other than that, we want to hear from you. Did I cover all the housekeeping things here, Tom? Oh, the short bios, what the other things, and some of y'all were able to get your bios to us. If you haven't, please get your short bios to us. That short bio will be included in the report. So that's going to be published there and also be put onto our website. I think we handled everything that, as far as the housekeeping nature, if you need to use the restrooms, you go out this door, turn to the right and make it another immediate right, and the restrooms are there. So let's get started. And the way we plan today, and we've, as I mentioned at last meeting, we had to come up with, obviously, some initial scheduling for meetings. And and we debated this, my gosh, we don't want to impose on the task force, programs that already we want the task force to, drive the agenda. But at the same time, some prep had to go into things. And so we decided in this meeting that maybe it's best that we all be open to hearing how the process works. Because I know we have all different segments in it. Even as a clerk, I'm not familiar with, certainly from the A to Z on guardianships, I'll be the first to tell you that because there's so much involved with it. And so we thought we would hear from an attorney's perspective who practices in many different counties and has experience in this area to give us an overview of the laws, of the practice from a lawyer's point of view of a guardianship. We also want to hear from the perspective from the court on what they see as their role in the guardianship process. And finally, we have a panel from the clerks on our role in working with the judiciary in the process of guardianship. So that's how we drove the agenda for today. Then our next meeting, and again, we had to do some planning to move things along, is going to be dedicated to hearing case studies. The case studies will be, and Anthony has been gracious enough to put that panel together, and he was given the direction, and we agreed, that with the emphasis on looking at the shortfalls at those case studies of problems that have happened in guardianships throughout the state of Florida, and you've read them in the paper, and why they existed, and is there a statutory solution which may have prevented that from happening? Okay, so that's the idea there. Again, it's just not to tell a bunch of war stories and we all go, oh, that's awful, and sit and do nothing. The idea, again, is to say, hey, this happened, and maybe if we had this procedure in law or this statute or this best practice, it may have prevented that from happening and how we can implement that. So that's I think a robust discussion there. And then Tom Hall and Kimberly will be the next program, and there's been a tremendous amount of activity nationwide with guardianships, and a lot of legislation passed in a lot of different states. There's also been some past reports. There was a report done by the courts in 2018, very good report with some statutory recommendations on there. The court always is a little bit distinct, and Tom can share this with you, and is always hesitant to ever push a legislative agenda because of the separation of government, of powers. And so really it went to the legislature, but it really was not an emphasis placed on the report. There was some court rules changed, and I'm sure Judge Rodriguez knows about those court rules changed. But it really, the legislative recommendations in there really had no traction. We're going to take a look at those, and that's what Tom and Kimberly will be looking at some of those. Why reinvent the wheel? If some of those recommendations could have improved the system and maybe prevented some of the abuses which have taken place, maybe we need to relook at those, and they've been already well researched. So that will be the next meeting after the case study meeting. So we don't have meeting agendas beyond that. And that's one of the things, although we have an open meeting policy here, this is not a sunshine body. You certainly can give me or Anthony or Tom suggestions for our future meetings. So we want to hear from you task force members of topics that you think will be relevant to move what our agenda along. So need your cooperation there. Y'all have to help formulate our future meetings through your input. So that's a little bit of homework assignment, okay? And panels, we're good at panels. The meeting format in the future is going to be, most of our meetings are going to be through the virtual means. They're going to be starting at noon to 2 o'clock with the last half hour of each meeting dedicated to public comment in the 1:30 to 2 o'clock period of time. So the first, what we envision is the first hour being a presentation, a half hour of discussion, half hour of public comment. Okay, that'll be the general format. Obviously, we could vary from that. So there's where we are. And as I mentioned, the perspective from hearing an overview of the guardianship system, Vito Ropo has been gracious enough. And let me tell you, this was a lot of work on his part to put this presentation together. We had numerous conversations about the presentation and what we're trying to achieve. He practices in Collier County, but he also practices that's where his home is. Yeah. He practices in several counties. You're a graduate of Ave Maria Law School down there in Collier County, in beautiful Collier County. And I want to express my gratitude on behalf of the task force for your willingness to give us this overview. Please welcome Vito Ropo.
Thank you, Mr. Burke, for giving me this opportunity to address the task force. I think what you guys have put together is incredible. And the backgrounds and the experience between everyone on this task force, certainly, I think we're going to get some great results. So, Mr. Burke came to me, he explained what the task force was, what the goal for the task force was, and I've been tasked with sort of introducing guardianship to anyone on the task force or anyone in the public that doesn't quite know how it works from beginning to end. And I've been actively litigating guardianship cases for about 7 years now. I've been involved in guardianship cases all through law school, so it's been about 10 years for me. I've represented wards, I've represented family guardians, I've represented professional guardians, interested parties in all types of proceedings. And I've been personally appointed as guardian ad litem in several cases as well. I've not served as a guardian, but I've represented many. I've put people into guardianships, and I've also been active in getting people out of guardianships. Philosophically, I believe that guardianships they're great. We need them. But there are a lot of pitfalls that go along with those as well. There is a dark side, and that's what we're all here to address. We're all here to figure out what those problems are and propose ways in which we can solve those problems. A little bit of background. I did graduate from Ave Law, and so I'm a native here to Collier County, which we have our clerk here. I first got into guardianship out of necessity. And while in law school, my wife, her brother passed away in his 30s. He was the sole custodian or had sole custody of 2 of my nieces, and the mother was out of the picture. And after he had passed, we didn't know what to do. I was in law school. There was no courses. There was no professors that taught guardianship. There really wasn't, 10 years ago, there wasn't anything, or there was very little out there. And we didn't know what to do. While I was in one of my courses, luckily I sat next to a very nice lady who worked with a guardianship attorney in Collier County. And she introduced the concept of guardianship and explained it to me. And at that time, she had talked to her boss and asked, explained the situation and asked if that was something that me and her could work on and get a guardianship for these two minors, my nieces. And he agreed. He did it pro bono, and we worked with him to have my brother-in-law become the guardian of his two nieces and my two nieces. And that's how I got into guardianship. I knew nothing about it. I was 22. I never heard of guardianship before, and there really wasn't much out there. After that, I knew this was an area of law that I wanted to get into, and that's when it began. That's when I started learning everything I could about it. And in fact, I bought a course book, I think, from one of Stetson's, one of their LLM programs, and just read it myself through law school, just to self-taught myself. I started going to trials with local guardianship attorneys. Our clerk Kinzel would know Mr. Pivacek and Mr. Weber, and they introduced me, and they sort of taught me through the process. That's our regional counsel and our public guardian. So that's my background. That's how I got into it. Ever since then, I've been litigating guardianship cases. I've been representing families, professionals, wards, and really working with people all throughout the process. So what is guardianship in the state of Florida? In its most rudimentary form, guardianship is a process by which a person or an entity takes the position of being legally responsible for the care of someone else who is unable to manage their own affairs. In a lot of ways, it's like what a parent is to a child. They are responsible for that child. There are some differences, but that's the concept. It's not complex, and us as human beings, we've been taking care of those who aren't able to care for themselves for all of our existence. What is complex is the way in which the law addresses that decision-making process and the way that the law holds the people that have those duties responsible. And that's what we're here today to talk about. That's what we're here today to address. And I'm going to be introducing the process from the beginning to end. A lot of us are lawyers here. I didn't want to just resuscitate the statutes and read through them. This is something that I put together and really in a way that I would explain to a client of mine if I had a client come in, or if I was teaching someone what guardianship was. I didn't want to get into these statutes per se. It's kind of boring, really. So we will cover a lot of that ground. But the first thing I wanted to talk about, let's see if I can get this to work.
Us, obviously.
Clicking the wrong button.
Open. Chris, do we have another one? Okay, here we go.
Oh, we got it. Okay. Awesome. There we go. All right. So,
By the way, while we have this little interruption, we do want this to be a exchange. So if you have questions, don't keep them till the end. If you have a question of something he just said, please do ask your questions, okay? Task force members.
absolutely. I'm happy to have a discussion. Actually, I'd rather have a discussion. So when I started putting this presentation together, the first thing I wanted to talk about was different guardianship terms. There's very specific terms in the way people use these terms that not everyone might know. And I just wanted to clarify and go through a couple of the important ones so that we're all on the same page. Obviously, guardian, first term, It's an individual, professional organization that's appointed by the court to exercise some or all of the rights of a ward. Pretty straightforward. That's what the guardianship process end result is, appointing a guardian and then the administration through that guardian. A ward is an individual who had been previously determined incapacitated or voluntarily submits the rights to a guardian. There are two ways that we really talk about guardians. We talk about guardians in the sense of person and property. They are distinctly different. A lot of times they're combined, and we'll get to that in a second, but they are distinctly different and a lot of times are referenced as different aspects of guardianship. So if someone's the guardian of the property, that means that they have, they're the guardian over some or all of the ward's property, their assets. So their bank accounts, their homes, their cars, different things like that. If they're the guardian of the person, that means that they exercise the rights over the ward's individual person. Their decision-making on where to live, what medical treatment to receive, whether that ward can be married, different things like that. Now, in terms of referencing guardianships, we differentiate between two different kinds, a plenary and a limited. A plenary guardianship is one which the guardian exercises all of the rights of the ward, all the rights that they're able to. A limited guardianship is one that is anything less than that. So if the ward retains the capacity for any rights, then it would be a limited, it wouldn't be a plenary. Plenary is over everything. So incapacity or incapacitation is when an individual has been judicially determined to lack the ability to exercise some or all of their rights. Could be property or could be of the person. And the examining committee it's a panel of 3 experts appointed by the court to provide guidance to the court regarding an alleged ward's ability to exercise their rights.
One question.
Sure.
Back there, hoping not to get this off track, but the limited versus plenary. I have one attorney that insists that if it's a limited, the reporting requirements on the guardian are very different simply because of that. How different are they?
Generally, if it's limited, you're only reporting what the guardianship's limited to. So if you see this a lot in voluntary guardianships, if the court appoints you as guardian over certain assets, which could happen, then you would the reporting requirements would only be over those particular assets.
So it should be simpler.
Yes.
Than plenary.
In theory, yes. Yeah.
This attorney insists so I'm not sure where that's coming from, but okay, thank you.
Sure. I'm happy to talk more about it afterwards too, but yeah, your reporting requirements they're limited to what you exercise your rights over. Sometimes, I've seen, as an example, cases where someone might retain the right to make their medical decisions or retain the right to decide where they want to live, but the guardian decides the rest. When the guardian files their annual report each year, they're not going to comment on the medical or where they're living because that's not subject to the guardianship itself. Okay, so I'm not sure where we left off. The elisor is another word for a court-appointed attorney who has represented the alleged ward, both in a guardianship and incapacity proceeding. They're court-appointed. And a conservatorship is another way of saying guardianship. So it's interchangeable with guardianship itself. We use the word guardianship here in the state of Florida. Other states use conservatorship. We're not going to use it today, but I just wanted to include that. Okay. So a couple concepts here that I want to make sure we have an understanding of. There's incapacity and incapacity proceedings, and there's guardianship and guardianship proceedings. They are two separate things, and they're two separate tracks. They're two separate cases. A lot of times they get lumped together. I may even lump them together sometimes, but a lot of times when we're talking about these things, people combine the two and it's not very clear. I just want to make sure everyone understands that incapacity and the incapacity proceeding, it deals with the question of whether someone can make decisions, whereas guardianship and guardianship proceedings deal with who will make the decisions. Once a guardian is appointed, the case continues under the guardianship proceeding, and that's the administration of the guardianship continues under the guardianship proceeding, and the incapacity proceeding really just sits there. It doesn't have anything further on. So I just want to make sure everyone understands they're two separate things. They're two separate case headings. Generally, in the state of Florida, I've seen that the incapacity proceeding is designated as an MH case number, and the guardianship and guardianship proceeding is designated as a GA. Sometimes they're both GA, I've seen before. Just depends on how the court runs, or they number their cases.
Quick question, what is suggestion of incapacity or suggestion?
I'm going to interrupt you. Make sure that you have the microphone right in front of you,
Sorry.
because of the YouTube, people can't hear unless the microphone's right in front of you. Thank you.
Would a suggestion of capacity be handled in a guardianship proceeding or in an incapacity proceeding?
I believe I've only ever seen them filed on the guardianship proceeding themselves.
Right.
Yeah, the incapacity proceeding, if it finds incapacity in any way, pretty much transitions into the guardianship proceeding, and then everything's addressed in that case. But when they're started, they're two separate, distinct cases. Okay. So in beginning to learn what guardianship is, the question that we tackle with is, why form a guardianship? Why do we need a guardianship in the first place? And in the state of Florida, there are various mechanisms of control over one's person and property. Now, when you have capacity, any of us that have capacity, we are in control of what we do and how we do it. We're in control of our body. We're in control of our assets. We have a bank account with our name on it. Do whatever we want with that bank account. So I have self on here. It's at the very top. We control ourselves as long as we have capacity. Now, with that control, there are two other, there's ways that we can delegate that control. And we have trusts and we have powers of attorney. So in a trust, it's an organized entity. I don't want to get too much into trust, but it's an organized entity that someone who has capacity can create, and they can name themselves or another individual in control of that organization or of that entity. You can then put property into that entity, and whoever you name in control of it now has control of that property. So that's the trustee, and it's someone who's in charge of the trust. So that's a trust. Similar concept with power of attorney. While you're in control of yourself and while you have capacity, you may elect another manager, or we call them agents, to to exercise your rights. So the power of attorney could be limited, or it could be as expansive as you want it to be. A lot of times people will name individuals as their agents so that they can assist in the event they lose capacity. We call that a durable power of attorney. A durable power of attorney still exists if you become incapacitated in the future. And it's you electing the person that's in charge of whatever you want them to be in charge of. So it's very expansive, or it's as expansive or limited as you want it to be.
Mr. Ropo, can I ask you a question?
Sure.
Why is it in guardianship proceedings, at least in all the cases that I've researched or attended hearings, power of attorneys are thrown out? My father in 2003 got dressed, put on a suit, went to his attorney's office. He knew what he wanted, and he signed off. He paid his attorney to have his advance directives drafted, and they were thrown out in a probate court. Why is that? Do you recommend people getting powers of attorney or no?
So there's a lot of reasons. They do often get thrown out, and I'm actually going to touch on that a lot
Thank
more
you.
later on. So I don't want to sidetrack too much on it, but there are a lot of reasons for powers of attorney being set aside or not used, and in turn we go to guardianship instead. It does happen, but I'll address that here.
Thank you.
So when I say power of attorney, I also mean power of attorney for finances, and we call them healthcare surrogacies for healthcare decisions. They're two different documents, but they both fall under the power of attorney category here. So then we have guardianship. I put it at the very bottom because it's the most restrictive. We have oneself, we have documents that place others in control that we have chosen, which is trust, powers of attorney, and then we have guardianship at the bottom as the most restrictive. And guardianship comes into play when there are no other least restrictive means available, which is why it's at the bottom. Either they don't exist or they fail for some reason. I call it the safety net. It's a catch-all when an individual is no longer able to care for themselves and they don't have a trust or a power of attorney or any other estate plan document set up to care for them. You inevitably end up in a guardianship. So, okay. So who are the wards? Who are these that we're talking about? And who are we trying to protect? And there's three major categories. There's minors, there's adults, and then I divided another section out for the disabled. It's a different process if someone has a developmental disability, but it's real similar to adults. So minors, since they're under the age of 18, they're incapacitated by law. There is no incapacitation proceeding in a minor guardianship. There's simply a guardianship. And like we talked about before, there's generally you see two types of guardianships for minors. You see a plenary guardianship. A lot of times it's when the parents can no longer take care of their children. Many of the times it's when a parent passes away. Someone can take plenary guardianship over minor children, much like my brother-in-law did, and which is really how I got into this. The other thing that you generally see with minors is personal injury settlements, or if their parents pass away, estate proceeds coming through personal injury cases from their parents, or even just assets from their parents. So we typically see plenary or we see guardians of the property. And I'll get in, I want to touch on minors just so that everyone understands the process and how the Florida law works with minors. And I have another slide on that. But essentially, this is what you mostly see when it comes to minors. Adults, it's any adult that has had any right removed by the court in an incapacitation proceeding and has a guardian over them. I mean, it could be one right or it could be a whole bunch of rights. It could be limited or it could be plenary. And then we have the disabled. So the disabled, there's a separate Florida statute. And if a disabled individual has a developmental disability and lacks the decision-making ability to do some, but not all of their decision-making tasks necessary for their care, the court may appoint what we call a guardian advocate without an incapacity proceeding. So there's a way, if someone has a developmental disability, to again skip the incapacity proceeding, but it's very limited to certain situations. A guardian advocate in those situations report annually, just like a standard guardian would. There's the same reporting requirements.
So
Any questions about that?
So what happens when a juvenile transitions to being an adult and they're under either a plenary or a partial guardianship? What happens at that?
So if there's a guardianship established while they're a minor, that's an interesting question. I haven't dealt with that specific issue in practice. I'm not sure if a separate case would have to be filed or a petition could be made in the current case to transition it to a guardian advocacy.
I'll just add, I had one that we purposely set it up that it would end when he was 18.
I'm sorry, it would.
I had one that it was solely because his parents had died, and we set it up that it would end as soon as he turned 18.
Yeah. A lot of times, when the children turn 18, you simply notice that they've turned 18 and you file a petition to dissolve the guardianship. You know, a lot of times, when parents pass, there's, unless the parents had a lot of assets, there's Social Security or Social Security that the children receive of some form or another. And there, you can get waivers with the guardianship board not have to account for just the Social Security income because it's not really substantial. And the courts will just dissolve them real quick after a notice has been filed with the court itself.
Excuse me.
Sure.
To the extent that it's helpful, a final accounting would need to be prepared and served on the minor who's then turned of age at that point, and the petition for discharge. The minors can waive them, however.
Yes. Yeah. Yep. I guess it would, in that sense, it would be a dissolution like any other guardianship. It would be a final accounting and then the petition for dissolution.
If it is a child who also has other disabilities or, incapacities, infirmities of that sort of thing, then a petition to determine incapacity would be filed at that time if another guardianship needed to be established. But you would go through the full process.
Do they stick with the same case site, or do you have to open up a whole nother case?
I think it's easier probably for the clerks to open up another case.
Fair enough.
But there would be a separate incapacity filing, and that would be a new case file number in most.
And a new fee.
Unless it was a guardian advocacy. And in that case, you could actually, it's a much simpler process because guardian advocacy is a much less invasive process for someone who's an adult with a developmental disability. But they would have to be qualified with Prader-Willi syndrome, with some sort of developmental disability. And then they could qualify for that less invasive process. That was 393 is the statute on that.
Yep.
No adjudication of incapacity is necessary.
Mm-hmm.
Right.
Usually they will still require the medical evidence though from a doctor or a PCP or something.
Yes, but usually it's much like sometimes we'll use the IQ rating from school records. And that's usually sufficient for the court. There's not like a strict standard like we would see in an incapacity proceeding. So sometimes if we don't have school records, we might ask just the family doctor, to submit some medical testimony. And that testimony has to say that the person can do some, but not all of the activities that might be required for daily living.
Yeah, it's a much easier process. I've done several of them. It's a lot easier, but I like the guardian advocate process. Sometimes it's a little difficult on the the some but not all decision making. I've had issues with that in a few cases, but yeah, I think, and that's why I wanted to split it in this slide too, as to save it, because there is a separate process for the guardian advocacy too. So I appreciate that though. Thank you. Okay. So I wanted to talk briefly about this just so everyone understood. I don't know if there's a whole lot of problems with minor guardianships as they relate to property, but I just wanted to make sure everyone understood this so that they understand how guardianships work for minors that receive money in one form or another. So I have this chart here. It's pretty straightforward. Any amount of money up to $15,000, the court is not required to approve the settlement or approve that the minor is going to receive that money. A guardianship's not required, and a guardian ad litem to review the proceeds or review the accounts is not required at all either. Between 15,001 and 49,999, if the net amount given to the minor is 15,000 or under, court approval is necessary, but guardianship is not required. In this range, a guardian ad litem is not required, but it may be appointed by the court.
Are these figures statutorily prescribed? Okay, so this isn't going to vary by county to county or circuit to circuit?
No, this doesn't vary at all. These are the statutory figures as they are. They're actually contained in a couple different statutes, and I just put them all together here for purposes of making it a little easier. But if the net amount to a minor is in excess of 15,000, meaning that a lot of times if an attorney settles a car accident or settles a personal injury case, there's medical fees, there's attorney fees, there's a lot of other fees that come out of the settlement. If the net amount that goes to the minor at the very end of all that is in excess of $15,000, court approval is necessary and guardianship is required. A guardian ad litem to review the amount and review, or I guess be appointed to represent the minor is not required, but may be appointed by the court. And any time that the settlement amount is greater than $50,000, court approval is needed, guardianship is required, and a guardian ad litem is required for review and to represent the minor. There is a carve out that the guardian ad litem is not required if there's already a guardian and the guardian's interests are not adverse. Okay. So I wanted to give a few examples and give everyone an idea of who generally petitions the court for guardianships or for incapacitations and guardianships. And I wanted to start here with family, neighbors, and friends. And there's two main reasons that most family, neighbors, and friends petition the court. First and foremost, to care for a loved one who does not have least restrictive means available. If mom or dad, let's say mom has two children. She doesn't have any powers of attorney or trusts created. Mom's very cooperative, but she has dementia, and as time progresses, it gets worse and worse. She listens to her children for years and allows them to help her and works with them cooperatively. One day, she stops listening and refuses to work with her children and refuses to accept their help. The children, without their mother's cooperation, really have no choice other to file an incapacitation proceeding or a guardianship proceeding. And they do so that the court and the judge can appoint a guardian over their mother and then can manage their mother's affairs, manage her person, and manage her property. Another big reason for family, neighbors, and friends to file guardianships is to protect a loved one who they believe, or I'd say perceive, to be exploited by another. For example, let's say mother has two children, same example. This time she has nominated child A as her agent in a power of attorney. Mom has dementia and starts to go downhill, and child A takes over her finances and starts managing her property. After some time, child B notices that mother's home has been signed over to child A using the power of attorney through some sort of quick claim deed for minimal consideration, $1 or $10. Child B asks mother about it. She doesn't remember ever signing a deed or ever giving anyone permission to transfer her home to her other daughter. When child B contacts child A ignores child B. Child B, in a situation such as this, would file an incapacitation and a guardianship case with the court and allege that child A may be exploiting her mother. It's a really common situation, and it's done a lot, and it's a mechanism for child B to inquire as to the situation and figure out if child A really is exploiting their mother. So, and in that situation, the court may revoke, as an example, may revoke the power of attorney for misbehavior. I say perceived exploitation because child B doesn't really know at the time they file these things. They don't really know what the intent was or whether there was a legitimate estate planning purpose for transferring that property to the other child. So those are two real common reasons that family, neighbors, and friends file guardianships or initiate guardianships.
I have a question on this. So
Sure.
I just want to be really clear on this. So basically, if I can go into court and file for guardianship for Tom, my good friend Tom here, is there anything preventing me from doing that? And then how does the court look to say, do I have any? It seems like the court's hands are almost limited because I mean they don't have an army of people to go do research. But like we've seen instances in Pinellas County where a realtor who wanted the list of clients' property filed the guardianship paperwork. So it just seems very odd to me that anyone, you've said neighbor, friend, but it's really anyone. There's zero restriction on who can file this.
Any interested person.
Any interested person, and it almost, we just see so many instances of, there's several children. They're all around. They think mom is fine, and all of a sudden, but one files and all of a sudden, it seems like they get a lot of the authority or power right there by filing. So I guess I'm not sure if there's any solution to that, but it just seems like it's ripe for potential problems. And just the formation of the guardianship seems like almost like the biggest key point in the problem here.
It is. I agree with you. I don't know what the solution is. I mean, we're here to try to figure that out, but it is a problem. Any interested person can file a guardianship, and they file the guardianship making allegations under oath. I mean, this is when they file these petitions, the allegations that they bring are serious. They have weight to them. And I think sometimes the courts are a little too trusting to those petitions, or maybe a better way to say it is the cases are very nuanced and fact intensive, and it takes a lot of time and effort to get to the bottom of what's actually happening in a case and whether or not that person was right for filing the guardianship or whether that was an improper filing. And I'm going to touch on that even a lot more later in this presentation. But I hear the concern. I do agree with you. And I think that we need to find a way, maybe this task force can find a way to address that issue.
Do you know, and I know Tom and Kimberly, do you know of any other state that does it differently as far as the initial filing is concerned? And again, in my example of me filing paperwork against Tom, it almost puts him in a victim standpoint by just me filing paperwork that's saying, I believe Tom's incompetent, and here's some things I put in a petition saying why I think it is. And there's I could have a profit motive for it. It could be all different reasons why I have it.
Sorry, go ahead.
I just want to address that there is a bad faith provision in the incapacity statute, so that if it is filed in bad faith, then of course the petition ultimately would get dismissed, and the costs relating to the attorney for the board and the examining committee could all be charged against the person who filed in bad faith.
Yeah. And Sean, have you seen that happen very often though?
Not very often.
Yeah.
I've never seen it, the bad faith filing statute.
I've seen one.
Right, and honestly, quite quickly, I do believe that the petitioner should be vetted, especially if it isn't a family member, because we have seen, someone, just a complete stranger. A realtor is in Pinellas, and we all know that case. And at a deposition, they were questioned and admitted at the depot, no, they weren't close friends, didn't know what language, native language that the AIP spoke. So I do believe for such a catastrophic thing as putting someone in a guardianship, that the petitioner should be vetted. And even if it is a family member and it's found that the petitioner, had bad intentions, then everything should be dismissed at the get-go.
And I think, to your point on the bad faith issue, I think the real problem is that, I mean, even if we went back to the example that I had before, what if child A, who was the agent, your power of attorney for their mother, what if she went to a doctor and that doctor gave the green light that mother could take child B out of all of her wills, could take her, and she executed a whole new estate plan that completely eliminated child B.
Can I ask on that?
Sure.
And just speak in the microphone and speak loudly, please.
I mean, we get scenarios like that fairly often in my office, and they're probably the most difficult cases we get, because I'll tell people I have the right to misspend my money.
Yeah.
Because it's my money. And if I want to waste it all, I can.
Can I
At what point do I become incompetent?
Yes.
I can speak to this issue just from a legislative perspective. The new law that became effective on July 1st actually addresses changing someone's longstanding estate plan if you are, in fact, unduly influencing someone to change someone's longstanding estate plan. That's actually a crime of exploitation at this point. And while we want to rely on medical professionals for advice as to whether mom can make a medical decision, testamentary capacity to execute a will is a different standard, right? It's a totally different standard. And so, these are very difficult issues. And I agree that there really have been a lot of cases filed in guardianship proceedings where the petitioner was acting in bad faith and perhaps didn't have a bad faith ruling either from the court or the process broke down. Certainly that's something that I believe we need to look at. However, Florida has some of the best safeguards in the country related to guardianship proceedings. We have 3 examining committee members that sit on our examining committees. We have an attorney that is immediately appointed to represent the interests of the ward. And attorney ad litems potentially need to do a better job of representing their clients. And I do think that an education process where we advise attorney ad litems that they need to do a better job of representing their clients right away is very important. I would also just let everybody know that the filing fees alone are like, what, $650? We got 100 clerks here, right? I mean, it's like a lot to file a petition for incapacity. And also, we know that when you file a petition for incapacity, it's a sworn under oath statement, prosecutable. So, I mean, all of these safeguards are in place. And I agree that there is a problem, that we are not doing a good job of administering. But frankly, the way the guardianship statute is set up, it is a very vetted process. You can't be a convicted felon and be a guardian in the state of Florida. So I'm not sure the statute is problematic. I'm wondering if the administration of the statute is something that we need to start looking at.
I must respectfully disagree with you. There should be term limits on the examining committee members. We know in Orange, Dr. Sawyer has been doing it for 20 years. In Collier, Dr. Erico, a gynecologist, has been on the examining committee for 25 years. Besides that, yes, a court-appointed attorney is appointed, but they do not get paid unless their client is put into a guardianship. So basically, you're behind the 8 ball from the beginning. If your court-appointed attorney is not getting paid unless a guardianship
is established, that doesn't seem fair to me.
That's not accurate.
How is it not accurate?
Because the statute provides that if a court-appointed attorney actually acts in good faith, they actually do get paid.
They always,
Whether or not an incapacity proceeding is.
I get paid regardless.
well, that is, I've never seen a court-appointed attorney, well, few and far times that have fought tooth and nail for their client. And I won't give you examples, but we know that that is, or I believe that is definitely the case. And the filing fees, yes, the attorneys pay for it, but we know that the ward, when they become a ward, they pay for that filing fee in the end.
Okay, Dennis Moore has a question, who's part of this task force and is joining us remotely. Is his question able to be asked through WebEx? Go ahead, Dennis.
Ken, thank you very much. Can you hear me okay?
Yes, sir.
Okay, Mr. Rupp, this is a very robust conversation, and I think that gets to a lot of the nerve here, if you will. In my view, are you going to address possibly the standard for incapacity hearings, as well as the due process rights that are currently afforded to those that are subject to those petitions?
I'm going to touch on it in a little bit. This is more of an introduction into it. I don't know if I have that particular issue in a slide, but I do have some of these issues that we're talking about. I have at the end of my presentation just some thoughts. I've talked to several attorneys, some board certified in guardianship, and put together a list of some topics I just wanted to introduce as a starting point for discussion. I call them vulnerabilities. And, I guess when I get there, we can maybe readdress it. If that's all right.
Yes, I thought that's what you might say. I think again, this being the first presentation on the subject, I think there's a lot of people chomping at the bit to get into those weeds, and I'm sure we'll get there. But I appreciate that.
I know some of this introduction stuff's a little boring. I just want to make sure everyone understands we're on the same playing field when we get to that point.
We're going to help you not make it boring. Okay.
I'm enjoying this conversation.
And this is good.
Boring.
The only thing I would ask folks, and just for order in the room and for conversational purposes, if you would just wait to be recognized as chair, I'll recognize you and we'll be glad to recognize you for your questions. And we're really trying to, during this part of the conversation, is more questions and then maybe experiences. Zane, you have you're recognized, and Sean, you're recognized.
Sure. So I would just like to, based on this slide.
Microphone as close as can be, please.
I don't want to pull it up or anything. All right, here we go. Just while we're on this slide, I just want to flag for the record for future conversation and or debate. I think it would be important if this task force takes a really hard look at how nursing homes, hospitals, and ALFs are utilizing petitions for guardianship. I think it's kind of an anomaly. We don't really know how and in what situations they are being used. And I think it's imperative that we research that and get a better understanding in this specific setting, what's happening. So that's all. Thank you.
Sean?
I don't know exactly how this works, but I'm hoping that we can note that these are issues that we should follow up on as a task force, because the issue of who can file a guardian is not really, guardianship petition is not really clear. The incapacity part of the statute is clear on who can file. The guardianship part is more silent in that regard. And then the bad faith provision that I mentioned applies to the incapacity side and doesn't necessarily translate to the guardianship portion. So we should look into that. And then the last thing is, Ms. Hogue is correct that there is a glitch in the statute as to payment. If the person is indigent, the attorney, court-appointed attorney can get paid either way. But if they are not indigent, there's case law out there that makes it clear that the court, unless the court found bad faith in the filing of the incapacity petition, cannot charge that fee to the ward, to the person who was the subject of the proceeding. So there is no one that can pay unless we get the petitioner to agree that they would pay the fee to the court-appointed attorney. So to some extent, they could have an all-day trial and win. And if the alleged incapacitated person decides that they don't want to pay because they felt that it was wrong that Ken filed the case against Tom, then we have a problem. So it's something that has been known, it's been brought to the legislative table before, but never gotten anywhere, and that issue should be resolved.
And I'm actually going to touch, I was going to touch on that issue with, further in the presentation, because I agree with you. And I've talked to a few attorneys that have litigated on behalf of wards and have gotten them out of guardianships and weren't paid. So, okay.
We have one more question.
Oh, sure.
From Anthony, your comment.
Yeah, no, I just wanted to get back to the petitioner, but first I wanted to concur with Shannon. Our examining committee process looks good on paper, but it is a broken system. But to understand the petitioner, you have the statute and you have case law, and both of those is what makes up the guardianship process. I do know of some case law that requires personal knowledge of the petitioner, but I don't know if it's controlling enough. So I'd like the task force to consider that as well, that the petitioner has to have personal knowledge to allege what they're alleging. And by the way, while we're at it, why are we calling it the alleged incapacitated person? Isn't that kind of like saying the alleged murderer? Aren't we, creating some prejudice right at the get-go? So I'd like the task force to take a look at that as well.
Right, and if I.
Hillary, just remember, we're going to be recognized for
Right.
this. You're recognized. Go ahead.
Thank you so much. And if I could just mention, Magistrate Cadigan in Hillsborough, an alleged incapacitated person on the docket is listed as a defendant. So, I mean, I think that's something that should be recognized. And I do agree with Mr. Palmieri.
One thing I'd like to add to Shannon's comment is I do think Florida has one of the better systems in the states. I've seen recently an Indiana guardianship where the court granted a full guardianship over an individual based on one sentence from the nursing home doctor in which she was then located at, who he had actually, the doctor had visited the individual, said everything was good, and then 2 weeks later was asked to comment or to give an opinion on a guardianship case, and on the opinion cited, oh, I saw them 2 weeks earlier, they're completely incapacitated, and a totally different report. So, looking at what other states do, I've seen it, at least in Indiana. I can tell you that Florida has a way more comprehensive system than that. I still think it has flaws, but it is a lot more protective than a lot of the other states. So I completely agree with that.
Would you, on this slide here, what is the motivation of a nursing home, hospital, and assisted living, and and I don't mean to sound like I'm casting stones here, but where have you seen abuses in this initiation of guardianships?
Sure. Ken, why don't I give a couple of examples of some things I've seen and how this comes up. So let's say an elderly lady was at a assisted living facility, and she was put in there by her niece, who is the trustee and her agent. The niece moves her into the nursing home, signs all the contracts and everything, and begins paying the nursing home for their services. And anytime that nursing home has a question, they go to the niece answers it, and it's a good relationship. Everyone's doing good for a couple of years, and then all of a sudden the nursing home has a question. They call the niece, she doesn't answer. Now we have a month or a nursing home invoice that's unpaid. 2-3 months go by, the nursing home is going, okay, no one's contacting me. What do I do with this person? I have an unpaid bill. I have the person who's in charge just completely, call it ghosted us. They're just not talking to us at all. What do we do in a situation like that? I mean, the answer is guardianship. They have to file a guardianship and allege and correctly alleged that the person that's in charge is no longer making those decisions. They're no longer caring for the person that they were supposed to care for. And the court then will appoint a guardian, and that guardian will look into the situation. So that's an example of how maybe an assisted living facility would need to file a guardianship so that they can figure out what to do with that individual who was brought there under great circumstances, but then the situation went south. Another situation I've encountered with the hospital, say a hospital, let's say a hospital has a patient that comes in, and the family brings the patient there. They're being cared for at the hospital, but then the family stops returning phone calls or stops visiting. The hospital may decide that they've fully cared for this individual, but this individual is not capable of just letting go. They can't do that. It wouldn't be good practice. So the hospital, they may file a guardianship in that case so that someone can assess the situation and figure out the best course of action for that individual.
When they do that, when a hospital, for example, files a guardianship, do they normally suggest who the guardian should be, or is it totally up to the court without any input from that hospital or nursing home?
I think that the hospitals generally have guardians they work with. A lot of times I think there's some good reason for it. And then there's, I don't know, there's some good reasons in that the hospital is not aware of this patient's financial situation. They don't know whether this person has money, whether this person doesn't have money. And sometimes the hospitals will pay guardians like a flat fee to take the case and then to work the rest of the case pro bono. Sometimes the guardian ends up finding out their assets, sometimes they don't. But I've seen hospitals do that. A lot of times the hospitals can't refer the cases to the public guardian because they're full, or there's a long waiting list, and they need something done now, so they end up hiring private guardians to do that. That's what I've seen.
Zane, you're recognized.
Yeah, just along this line of hospitals, and the reason I did bring it up earlier is there were multiple reports, and this is all reports, so I'm not saying this is fact, it's alleged, out of Tampa, out of Orlando, where there was a scenario of patient dumping by hospitals and having kickback schemes with the nursing homes. And so that's why I said we really need to understand how this is being used to try to identify what, if anything, can be done to prevent the bad actors from doing things in the future.
And just real quick on that too, I've seen hospitals where they'll assist in the creation of powers of attorney for people that are in the hospital, and then they'll file guardianships and never mention the documents that they themselves helped create. I've personally seen that, and that's a serious issue too. But
Right, and I've seen, I mean, the highest that I've seen, and I hope I'm recognized, Ken, thank you, is, I don't know if it was Leon, it doesn't really matter what county, that the flat fee to get someone out of the facility was 15,000, but I really don't understand. Someone's put into guardianship, but the hospital is paying the guardian. When does it end? I mean, does the hospital keep paying for the guardian and it goes through the court system, the fees are approved, but how long does the hospital keep paying?
I don't know. The only ones that I've seen is the hospital will pay a flat fee of say 2,500, and then the guardian's expected to take the rest on as pro bono. I mean, that's the only example that I've seen. Maybe others have seen.
Karen, you're recognized.
May I suggest for the task force purposes that we keep kind of a running list of things that we want to make sure we address? And I'd like to propose that we have a recommended process specifically for nursing homes, facilities, and hospitals that have these abandoned patients, if you will. What the best process is and making that recommendation.
Thank you, Karen. It is noted. Tom's taking notes. Karen's taking notes, just like our last meeting, and we will produce minutes or notes from these meetings, maybe not minutes. And it will be, and we will have ones which obviously have piqued the interest of the task force as follow through. And Tom's going to comment since he's the person putting it together.
Well, and I had the thought sitting here that we're probably going to send you homework in between. When we get these things about what are hospitals doing and all that and understanding it, we'll probably ask people, how do you think we should go about that? You know, that sort of stuff. So in between meetings, we'll be sending you stuff like this to keep that going. So we keep track of it.
Hi. I can speak for our nursing homes and domiciliary. We would never seek a guardianship for anyone. When we have an issue like that, there is a Florida statute on proxy. I was trying to look it up so I could give you the citation, but you can have everything from a spouse or family member down to the social worker that can help the person get what is needed without appointing a guardian. I would keep hospitals from approaching guardians because that's a plain conflict of interest, and no attorney should really be taking such a case and then fail to represent that they have drawn up paperwork that could be used against a person later. How could they do that? It's against our oath as attorneys. And one other point I wanted to make, when doctors make determinations of incapacity for purposes of healthcare, that does not have the legal weight of incapacity. So it should not be interpreted as a legal incapacity. It's only for the healthcare purposes. And then there's other people that can be appointed. And a strong recommendation that we would make is to perhaps get some type of citizen group involved in this process, because judges have so much to do. They really cannot go out and pursue the facts. Remember that the person who's going to be the ward has a whole life, all the dynamics of being a living being. And there's no way that 3 members of an examining committee that might drop into the home on the weekend to do their evaluation and bring it back to the court can understand how that person is a full person. So I know it's very fact intensive, but remember, this is somebody's life that you're altering forever. And it's probably worth figuring out some way that we can bring more people into the process that are disinterested so they can really explore what are the best interests of the ward or potential ward.
Shantae, did you have a question? Mara?
Yes, I would just like to say, most of the referrals that we see have gone through that process where they have looked for a family member or friend or someone that's willing and able to serve as proxy. And if they're unable to identify anyone in those categories, that's when they go for guardianship. And we have to remember that facilities, as well as hospitals, are audited by their accreditation. And if they have a patient that can't give informed consent, they do have to have somebody that is assigned to be making those medical decisions. And that can prompt them doing that search and then ultimately ended up with a guardianship.
And those are all the cases that I've seen too, is when there's no family is communicative or they can't locate any family.
So the medical proxy statute, which is 765.401, specifically relates to medical decision-making. It doesn't have any authority over financial decision-making. And there is a hierarchy of who gets appointed. And it can go as low, so you go through the family members, and it can actually go down all the way down in the statute to like a social worker that works at a different facility. Like it can't be a social worker that works at that hospital making medical decisions. You can actually have like a swap program. I know in Gainesville, Shands and North Florida swap social workers to be the medical decision maker for that person, but it only relates to medical decision making. It doesn't relate to any kind of financial decision making.
All right.
Discussions.
All right. So what happens when guardianship and incapacity has been filed? A few things happen. These are just the basics, but essentially the petitioner files 2 petitions, an incapacity petition and a guardianship petition. The incapacitation or the petition for incapacity alleges the facts that are believed that to lead to the person not being able to make their own decisions or not having capacity. And the petition for guardianship alleges that there are no least restrictive means available and that a guardian need be appointed. At this time, the court immediately appoints an attorney for the alleged incapacitated individual. So we have a better term for that. And they appoint an examining committee. They appoint 3 individuals to examine the alleged ward.
Can you talk more? Because the examining committee is another topic I know that has been brought to me as a clerk for that how are these individuals vetted? Like Hillary mentioned.
I'm going to get to just a second.
Good. Okay,
Sure,
then
it's a couple more down.
Okay.
Sure. Okay, so the petitions, we sort of covered this already. Petition for incapacity, it identifies the facts that suggest the ward no longer has the, or the alleged ward no longer has the abilities to make decisions for themselves. And the petition for guardianship, go ahead, sure.
Sure. Could you file a petition for incapacity without filing that petition for guardianship?
Yes.
Okay, so they're not required to be filed in tandem.
No, and an example of that would be sometimes if there's a trust and the original trustee, someone believes that they're incapacitated, it could be like the beneficiaries of the trust and they want the trusteeship to move to a successor trustee. Someone may file a petition for incapacity to essentially force that trustee to resign and have the successor trustee appointed. So there are some circumstances in which someone may file a petition for incapacity, but not a petition for guardianship. Okay. Some other documents that are typically filed at the petition stage. There's the application of guardian. When someone files a petition for guardianship, they generally will request a specific individual guardian be appointed or organization. And if they do, at the time of filing the petition for guardianship, they will include an application of guardian. It's basically an informative document that the proposed guardian fills out to provide information to the court that is relevant to them being approved and is relevant to their duties as guardian. One thing maybe the task force can bring this up at a later date. I don't believe there's a uniform requirement for this application. And I found that certain counties have different things that they want included on the application.
I'll just bring it up. Can't quite get why, I'll say at least in Pinellas, that there is a proposed guardian that's like the hospitals proposed this one. You know, you, Mr. Ropo, might have your go-to. If there's supposed to be the wheel, in effect, the rotation, how is that even happening when there's always a proposed guardian who's usually appointed to that case? And it's not because they have extra special powers. They've just, you know, have the prerequisites to being a guardian, the 40-hour course, and being with OPPG.
I'm gonna hold off on that question, the answer for the judicial panel, because they're the ones who are appointing the guardian.
Perfect.
So it's probably more appropriate that he can incorporate that as part of his response as to how guardians get appointed by the court.
Another document that's typically filed at the petition stage is the oath and designation of agent. The document is a 2-part document. One is an oath by the proposed guardian that they're going to carry out their duties, and a designation of resident agent, which is in the state of Florida, every guardian appointed needs an attorney to represent them that's located in the state, and that's a confirmation that a licensed Florida attorney does represent them. A lot of times, I wanted to throw this in there too, going to the powers of attorney, there's a petition to set aside powers of attorney if the petitioner does not believe that they are, that a petitioner believes that they need to be set aside for whatever reason they may have. And in the state of Florida, this is it's supposed to be a separate request that the petitioner makes to set aside a durable power of attorney that is in current use or is currently being exercised. The initial filing of a guardianship actually sets aside any durable powers of attorney that are essentially, I say, not blood related, but it's spouse, parent, child, or grandchild specifically. And so if the agent is a spouse, parent, child, or grandchild, a separate petition needs to be filed. If the agent is not a spouse, parent, child, or grandchild, you simply have to notice the agent of the guardianship proceeding, and it essentially suspends that power of attorney until the court can address it.
Jane?
This may be opening a can of worms, but just for understanding, and any of the lawyers, I would love to hear. So when legally in Florida, when we refer to spouse, does that have to be like a legally recognized marriage? And I ask that because as AARP representing older individuals in Florida, a lot of older individuals will end up essentially pairing up with a widow or a widower to either for financial reasons, whatever the case may be. They never legally marry for a various amount of reasons, but yet they operate as a spousal unit. So in this situation, then it would be my understanding that they're not blood kin. However, they act as a married couple other than a piece of paper that gives them that legal definition. They would not be recognized as a spouse in one of these proceedings.
Correct.
Okay, so maybe we could look at that. Like I said, it may be too big of a can of worms for this group, but just want to flag that.
I've had that issue come up in a proceeding quite recently in Collier County. And, the attorneys involved, we worked through it from a practical standpoint and somewhat recognized the partner, the life partner, as being in the position of a spouse. And it worked out, but I don't, legally, they're not. And I can see that becoming an issue.
There is a process for interested parties. And so basically a petition would need to be filed to designate that partner as an interested party. I can tell you in the guardianship proceedings that I involve, if there's a partner like that, we're going to notice that person. But having them be recognized by the court, I would think, and of course I can't predict what courts do, but in general, if someone is a life partner and they ask to be recognized as an interested person in those proceedings, then the court will acknowledge them, and then they get notice of all the proceedings. They also have the ability to come in and object to things that might be happening in the guardianship process.
There's a rule of probate, sorry.
Go ahead, Judge.
There's a rule of probate that addresses interested parties, and it may be as simple as letting the clerks know who you are and that you are an interested party. And an interested party is defined as someone who is likely to be affected by the outcome. So if they are a paired up couple and they are likely to be affected financially, that's the definition of an interested party. But there is a rule of probate. I can't find it just now, but I know that there is because I teach a class on it.
JD, then Tom.
On the previous slide, Mr. Rupo, I was trying to see if you got any input on the historical reason for the guardian needing an attorney to represent the guardian. Is that simply to interact with the court in the filing of cases? What's the historical purpose of having the guardian need an attorney to represent them?
That's a good question. I don't know where that came about historically. I don't know. I'm not quite sure.
Because quite frankly, that's one of the concerns I have in some of the cases that we've dealt with is an attorney taking that literally and representing the guardian in a dispute with us when we are, as the clerk and the auditor, are looking out for the interests of the ward and questioning a guardian over some things, and the attorney stepping in to be counsel for the guardian in that instance. I know that there's been some issues in the past. And so it's really my goal to make sure that everybody in the system is there to represent the ward's interest, not some other player's interest. And so there may be a reason why that's there. I just don't understand what exactly that reason is.
I know it's not a statutory reason, but it's in the rules of probate, which is a Supreme Court rule.
So that's a concern I have.
Can I weigh in here?
Yes, please do.
I think there's case law on this, and I think the Attorney General developed an opinion regarding this issue. So when you have a guardian who is not an attorney, generally they engage counsel because they cannot represent the interest of the third-party beneficiary of that appointment, which is the ward. And the information that I am aware of indicates that the attorney for the guardian owes a duty of care to the ward, the intended third-party beneficiary of that appointment. So, in my world, you can't really represent the legal interest of the ward if you're not an attorney, unless you have an attorney that is representing you. So I'll put that out there, and that's my understanding of that situation.
Tom, and then
Well, a couple of comments. The one about history, if it's part of the probate rules, we can probably fairly easily find when it was amended and there's an opinion and it would give what the reasons were at the time they did it. We can do that. But I wanted to ask a question. So if you have a life partner, not legally married, but you get disinterested party status, if you have a durable power of attorney and all those things, it gets wiped out automatically then, right?
If the lifelong partner has a power of attorney, then they're recognized and they have to be noticed under the statute.
Right, but I'm trying to, he said that or maybe it was you that said, it's immediate, that power of attorney is vacated until the judge decides otherwise.
Well, so my understanding, and I may be totally wrong on this, and pardon me if I am, but we changed the law in 2018 so that basically in order for a power of attorney to be suspended upon the filing of a petition for incapacity, you would have to notice the parties and say, we want to have the court enter an order suspending the power of attorney. My understanding, and Sancho, you can probably speak to this, and I was trying to look at the statute, but I can't, so I haven't had this issue come up recently. But my understanding is that otherwise, the agent under power of attorney continues to be able to operate. So if there are bills that need to be paid during the pendency of the incapacity proceeding, that agent can continue to pay those bills. And it's only upon requesting the court to suspend the agent under power of attorney's authority that the court will then do so. And so is that what you know, Sanjay?
It used to be that it was the family member that was serving as the agent of the power of attorney that would not apply. But if it was another person who was not a family member, then that power would not be suspended pending the incapacity proceeding. And because they would get notice, because they were, an agent under the power of attorney, they would be entitled to be heard at the time of the incapacity hearing.
But so that the judge would have to enter an order saying that power of attorney is no good anymore.
Right. Currently, the letters and the orders that are issued would indicate whether or not the power of attorney or any other advance directive, if, for instance, if there's a healthcare surrogate designation applies, whether or not those are going to remain in effect.
Or a portion.
Or a portion, exactly.
Yeah. Okay.
Michael, you recognize.
Well, this seems like.
And microphone, please, Michael.
One of the biggest problems we've run into is a family will come in and say, my mother's incompetent. We just found out that her house is under foreclosure because she hasn't been paying any bills for months. We need a power of attorney. And we have to tell them, you cannot get a power of attorney. You have to file for guardianship. But to do that, you got to hire an attorney, which is going to cost you several $1,000s. You got to file with the court, which is going to cost you a filing fee, and they can't do it. And then you're going to have to get an attorney to fight on the foreclosure. I could fill Shannon's day with pro bono cases very quickly. I mean, we have some pro bono attorneys, but nowhere near enough to cover all the people that badly need a guardianship under situations like that. And I don't know the solution, but that's something I really want this whole committee to keep in mind.
Putting it down on our work list. Back to you. Go ahead.
Okay, I just have to say this right now because I think it's important that we all keep in mind the exploitation injunction proceedings and the fact that we now have an exploitation injunction statute. So when we believe that an agent under power of attorney is exploiting someone, we can go into court ex parte and we can ask the judge, freeze our vulnerable person's assets down, and then within 5 days have a final hearing to address those immediate issues. Because, you know, if this is a real problem where we have someone obtain a power of attorney unlawfully, and then the money is gone by the time we get to guardianship. And one of the most underutilized tools that we have in Florida is the exploitation injunction. On July 1st, agents under power of attorney can now file exploitation injunctions without establishing a guardianship proceeding. So then we've been able to go to the next level, which is to really protect people when they've said in advance that they want an agent to be their financial decision maker.
And a member of this task force, Representative Burton, was the one who authored the original exploitation bill and that got passed. And, and you're right, as far as its usage, it is not, and it's a, it is a very technical one too.
Thank you. And the new bill that went into effect on July 1st, basically it just inherit, the portion that, you know, advocates are focused on is that it's all about the family members, that they will be disinherited if they're found to do anything nefarious, you know, nothing to do with the for-profit professional guardians and exploitation, similar to the guardians that have been arrested that will be sentenced in Palm Beach, Linrod Douglas. So, you know, it sounds good, but in reality, it's just going after family members and they will be disinherited. But the other players, the for-profit guardians and their attorneys who back them up and do the filings for them will not be disciplined in any way, shape, or form. Thank you.
All right. How is the ward's attorney selected? So the attorney selected is either regional counsel, if the ward's alleged to be indigent, or a private attorney on a rotating wheel basis. The attorney serves as counsel for the ward in both the incapacity and the guardianship proceeding. And the attorney appointed serves the ward until either 1, there is no incapacitation, 2, least restrictive means are utilized of the guardian instead of the guardian, or 3, a guardian is appointed and the court approves the initial reports, the inventory and the initial report of the person, and 4, the court could substitute that attorney and then the appointed attorney would no longer serve the ward. Sometimes in complicated guardianships, the court-appointed attorney will serve long past the initial filings of the guardian, and they'll represent the ward pursuant to court order longer than that. Sometimes they're also reappointed, but for the most part, those are the limitations on the attorney that's been selected. Mr. Burke, this is what you wanted to talk about here too. So, what is the examining committee? There's the state of Florida, there's 3 individuals that are selected for the examining committee. 1, it's a physician or psychiatrist, must be part of the examining committee. And 2 members must either be a psychologist, a gerontologist, a physician, a psychiatrist, advanced practice registered nurse, social worker, or any person with an advanced degree in gerontology, or any person who by knowledge, skill, experience, training, and education, or in the court's discretion, can advise and give some form of expert opinion. I had put a little comment on there. It's a little vague with the way that there's sort of a catch-all in this, but that's the statute. This is what the examining committee is, and that's how it's comprised.
So can you get this that skill by being on an examining committee for 20 years before they put that in there?
I mean, based on the way it's worded, I think that you would qualify as an expert at that point. I guess it'd be in the court's discretion to determine if.
It would depend.
Yeah.
Is that a court decision? About who?
About
About who, if there's ever a challenge to the person, it's a court decision to knock them off?
there are ways to go ahead and basically what you wind up doing is you move to strike that individual.
Yeah.
And then you bring that before the court. And it is not in any statute or rule, but it is a footnote in a 5th DCA opinion that basically shows how you handle the striking of a member of the panel. Then you bring it to the judge's attention and the judge will either strike or not strike the member of the examining committee.
Correct me if I'm wrong, but I don't believe there's any data. And again, we get back to the data question, which came up at our first virtual meeting, about maybe with these examining committees, any data about the examining committee members throughout the state. The clerks can tell you we're right involved in something that through the statutory reason, and I'm complying with a mandate to report all criminal data. We have to report 130 elements of every arrest that takes place either between the sheriff, and the clerk to the FDLE, so that people can look and see is there a fairness issue around the state, as far as sentencing, as far as within race and geography and all those types of things. And that data is going to be able to help with that. And I wonder, like with this, again, with the examining committee, is one examining committee have like a 90% rate of showing incompetency and another one have a 20%? You mean, things like that, maybe that doesn't mean, it just brings anomalies to the forefront to say, gosh, maybe something needs to be looked at in this particular examining committee when they are so skewed compared, but we have no data like that I know of currently. And I guess my question, am I correct that there's really no data on the examining committee statewide that anyone here knows about?
I can speak to that.
Shannon,
Not that I know of. And I will also say that I practice guardianship in a lot of different areas of the state. So in the 8th Judicial Circuit, the chief judge.
Just for the rest of us, the 8th is which counties?
It's like Gainesville, Alachua,
Good.
so north central Florida. That the chief judge appoints someone to select who can serve on the examining committee. So they have to make application to the chief judge or to someone that the chief judge selected. And then that becomes the number of people that can serve on the examining committee. In Flagler County, it's a different process. And in the 5th, which is Lake City, they have a different process. And in Tampa, when I came to Tampa and did a guardianship matter, I learned that the examining committee members, including physicians are paid a flat fee of $300 to examine, which sounds like a lot of money, but if you're a physician and you're so you have to examine the person, you have to talk to their physician, you have to be present for an incapacity proceeding, and you're paid $300, guess what kind of doctors we get on those examining committees? And so it is very
dedicated doctors for those doctors listening.
Right. No offense. They do a great job. Actually, the case we had, they did an excellent job for the $300 that they were paid. But it's different across the state. And I think you've hit exactly a problem here, which is some examining committee members are really good and they get paid appropriately. Other examining committees in other circuits, there's a flat fee. And it's very challenging to find physicians and members to serve and to do their service effectively within the confines of the pay that they're getting. So I do think this is an area that deserves some data.
I think she's right that there isn't any database because we've tried to look into it, trying to find qualified experts for our examining committee throughout the state. But the statute actually requires that the chief judge appoint the list each year. That's in 744. So ultimately, it's the chief judge's responsibility, but how it actually gets carried out in each circuit could vary. And then that list of examining committee members, I just want those of you who may not know, is the pool that you could choose from, but each case has a case-specific committee of the three members, and where Judge Rodriguez was speaking about how you would challenge the examining committee member in one particular case. You can do that in that manner, but if you wish to try to say that the individual isn't qualified to be on an examining committee at all, you would have to reach out to the chief judge under the statute to ask the chief judge to take steps to potentially remove that individual from the pool.
And one thing that, we have to consider when and certainly Senator has to consider when legislative recommendations get made, is that we have a variety of circuits, some in very rural areas with a lot of small counties, which trying to form a examining committee might be much more difficult than in a urban area like Hillsborough County. And so, I don't want us to just take an example that we have because we know it and build a statutory recommendation. We have to make sure that broad-based with the state, it could be implemented everywhere without a, tremendous effort. The resources are there. Anthony?
I just wanted to note, for Tom's benefit, that Florida Wings, and WINGS stands for Working Interdisciplinary Network of Guardianship Stakeholders, looked at the examining committee composition, narrowed the focus on retention, the members that we had in the state of Florida, recognizing that, we really couldn't afford to lose the ones that we had. But I would encourage the task force to take a look at the work that was done through the Florida Wings as well.
We will.
And Mr. Burke, to get at your point about the data of the examining committee, just going to the next slide, the way that they prepare and file their reports for the court, it may be pretty difficult to get all the data points because they quite literally go through their reports sometimes and will identify which rights they believe the ward has and which rights they believe they lack. So they're, if we had some sort of data input method, we may be able to really drill down which examining committee is retaining which rights and so on and so forth. So here's
Hillary.
Thank you. And I just like to say in just dealing with, the assessments that are done, I know that a few of the questions, I don't know if I could be able to answer, and that someone's rights are on the edge just because they can't spell the word world backwards, or they can't remember 3 items 5 minutes later. I think maybe there has to be a little bit of an update on what the prerequisites are for deeming someone incapacitated, when a lot of our fellow Americans are living quite independently. Their spouses are helping them, their family members. If there's exploitation, of course, that's a complete different situation. But the fact that a lot of someone's freedoms all depend on simple questions. Name the presidents in your lifetime. Do you really need to know how to spell world backward? Is that going to be catastrophic in the sense that you are going to lose their rights? And I am not a lawyer, and all I know is in my experience the last 4 years, these examining committee evaluations are just, it's just, to me, watching them or listening to them, it's just so sad. People are begging to stay at home and to be with their family. And a lot of times, most times, they're taken away and put into a guardianship.
Judge?
Common sense is what you are begging to include.
Yes, Your Honor.
And sometimes common sense is not that common. But be that as it may, one of the components that we also have to take into account, and perhaps develop training for these examining committee members that will also take into consideration cultural competence. You mentioned spelling world. Well, what language are we talking about here? Do we have a group of individuals that we have recruited to be on, if we have to, on examining committees that are able to speak to the individuals in their language, as Sancha mentioned, and to understand the subtleties of their culture?
Yes.
And I think that's extremely important. To the extent that the judiciary relies upon the lawyers to bring those things out, we have to rely on the lawyers to do that. Nobody has handed us what I'm fond of saying, a judicial Ouija board to be able to, divine where we're going. So the whole idea, if I can basically strike a note here, is that we are really all in this together. As citizens, as experts, as folks that basically have a passion for what we do. And I have always back before I was a retired judge and now just a plain lawyer with experience of walking in those shoes for a long time. I can tell you that my joy is to be able to recruit doctors, retiring doctors, to figure out if they will go ahead. But we need to come up with some kind of an educational format, so that they'll know what they're expected to do, and we can basically benefit throughout the state. But again,
Yes.
Cultural competence, education, recruitment, those are three prongs that are absolutely critical if we're going to do something about having a quality of decisions for those of us who have to decide capacity or not, to be able to rely on.
Tom?
So it sounds like there's no medical definition for incapacity. Am I right about that? Or
That is correct. There is a ton of work on incompetence in the criminal side, but the civil side, it's
so
more.
So it's evolved into a legal
fluid.
standard of some definition.
Yeah.
Okay.
Go ahead, Jane.
For clarity's sake, on the examining committees, do the individuals that are a part of the pool and thusly become the examining committee have to be actively licensed? Or, for instance, is it a doctor that has to have a current license, or can it be a retired doctor, a retired ARNP?
A retired doctor may still have their license.
Sure. And I'm thinking of also Florida obviously is a fabulous state for people to come once they do retire from their other states. So if a doctor retires to Florida that may have an active license in Texas, could they potentially, if this is something they choose to do, become a part of the pool? So I just don't know the answer, but want to throw it out there.
I believe so. I think you only have to be a medical doctor.
Right. That's
or
what
meet criteria.
Yeah, the criteria is statutory. I don't think that the word license is in there.
Licensing.
Great. I want to respect, we do have a lot more slides here. Let me just finish here. There's two big issues. It seems like we've identified big issues. Is how do a guardianship get initiated, and this examining committee. And so I know we're obviously going to have more robust discussions on both those topics. Those are obviously interest areas and problem areas that it looks like we all are in agreement need to be addressed.
I'm sorry, this is my life, guardianship, and what has happened. This is what I do every day of the week besides yelling at my 12 and 15-year-old children and taking care of my 90-year-old father who miraculously hit the lottery and is out of guardianship. Cynthia Van Vliet. She was a guardian in Pinellas County and Hillsborough. She was removed from all of her cases in Pinellas and Magistrate Cadigan. I think she's no longer a guardian in Hillsborough.
Correct.
She is a member of the examining committee. She is an examining committee member in quite a few counties. I've tried to reach out to some of the clerks to warn them in the, I believe, 5 counties, and I was basically blown off. I know that some people can only do so much. That is a disgrace that she is on the examining committee roster. And B, with all due respect, there are good guardians, but I don't necessarily think that they should be members of the examining committee. Because even if they don't get that ward, if they're put into guardianship, well, they're one closer to maybe being getting a new case. And again, thank you for letting me speak as much as I have.
But we agree that the evaluation committee needs to be looked at. I mean, I think everyone in the room looks like they have some agreement with that.
Sure. So this is just some thoughts that I wanted to put out there. Some things that up to this point that I've noticed from different court jurisdictions about how the process is not uniform from county to county. And I just wanted to throw some of these out here that I've recognized. The first one is that the rotating wheel of attorneys, in a few counties I've experienced that the petitioner who prepares the petition and files it for guardianship actually also prepares the court order appointing an attorney and selects the attorney that they want. So I've seen that. I've seen that in a few counties. Just wanted to bring that up. It's an issue. Emergency temporary guardianship. A lot of times people will file petitions for these. Some courts were appointing emergency temporary guardians without hearing, and some were not. There was a recent case in second DCA, actually based out of Collier, that said that you need to have a hearing on that. It was last year. I have magistrates on here. Some judges hear the guardianship cases themselves. Some judges will submit everything to magistrates. That's just an observation. The preparation of the initial documents, the initial order appointing examining committee, and the initial order appointing the attorney, and even the notice of final hearing. In some jurisdictions or some counties, they'll require the petitioners to prepare those and submit those to the clerk. And in some counties, they will prepare them all themselves and send all of those documents out themselves. Filing fees is something that I've recently experienced. I think that there's a disagreement in some of the counties where if the ward is indigent, can the court waive the filing fees if the petitioner is not indigent? Some clerks and some courts have allowed the fees to be waived, and some have not. Some have charged the petitioners the filing fees, even if they're filing in good faith and trying to help out someone who is indigent. So that's an observation that I've made. And then the appointment of guardians. Let's see. So I guess I remember I put that on there. So appointment of guardians, I mean, some courts will only consider the guardians that are on the petitions themselves, and some will also consider guardians that weren't put forward. I've seen both. All right, how is a guardian selected? Who can be a guardian? So a Florida resident, anyone over the age of 18. If not a Florida resident, must be related by lineal consanguinity to the ward, legally adopted or otherwise close family relative. What are the limitations? There's a lot of limitations. I put them all on here, but can't be a felon, can't be incapacitated yourself. You can't be ill or incapable of undertaking the duties of a guardian. You could not have been found guilty of abuse, abandonment, or neglect against any individual or a child. And you can be.
Got a question?
Oh.
You used, yeah. Okay, you used the word found guilty of. Is that a criminal court guilty or a dependency court finding?
I think both.
Any. If it's a sexual offense,
I don't see sexual. I see abuse, abandonment, or neglect. And in dependency court, nobody's found guilty.
right.
It's a judicial determination of that.
But almost everyone that goes to dependency court is found to have abused, abandoned, or neglected their child, or they wouldn't be.
That would disqualify,
Yes.
except on in some exceptions that I'll talk to you about on 39-701.
Okay, how does the court select a guardian? Usually the petitioning party puts the guardian on the petition, the one that they've selected themselves. A lot of times it's the petitioner themselves. It could be the guardian that a counter petitioning party selects. Sometimes I've seen petitions that are very ambiguous. They just ask for the court to appoint a guardian, a professional guardian or some sort of company. And there's various factors. I have the statutory factors that are listed that the court considers. I won't go through them all, but the court considers all of these factors when selecting a guardian that they're, at the guardianship hearing.
Can I ask a question? On those qualifications, how does the court know that? How would you know they've been convicted of a felony or been whatever the other things that disqualify?
We run a criminals, our court monitor basically is charged with running a criminal background check and a credit check. So we know, property, we know what's going on.
And you have that every
single one.
Anthony's recognized.
So guardians go get their fingerprinting, and based on the ORI number that is submitted to FDLE and the FBI, it comes back, the results come back to the clerk. The clerk has a duty to hold a repository of those background checks and make them available to the court.
And
that's true in every circuit.
That's the statute.
Okay.
Then Ken, then that background check does not include dependency findings. If it was in another county, you do not know that ever happened.
That may be true. Just to give you additional information, it's a level 2 background check that's run nationwide through NCISC.
Michael, maybe my question to you is, why is that important to what you're pointing out? So like why is that a vulnerability?
Well, to me, it is from both sides. First, I've spent 20 years in dependency court, so that's immediately what jumped out at me in the statute. First, we have a lot of parents that are in dependency court because their child is disabled. They weren't able to take care of the child when they were younger. They work things out. They get their kid back. 10 years later, the child's 18, needs a guardian, and at least technically, they're not qualified. They are not allowed to be the guardian. I think officially, nobody knows that case happened and they are becoming the guardian.
Because that's not a criminal offense.
Right.
That's your point.
Yeah.
Okay.
And so,
I'm getting you.
yeah.
So the background doesn't catch it.
Right.
When
On the other hand,
statute disqualifies.
Now, the proposed guardian does file an application that's a under oath declaration, but obviously they can lie on that,
I understand. Thank you.
All right.
Okay, guardian compensation. So in order for a guardian to be paid for their services or their costs, they have to file a petition with the court. The court considers all the factors here: time required, difficulty, likelihood that acceptance precludes other employment, the customary fee, the nature, the results obtained, time limitations, the nature and length of the ward, or relationship to the ward, and the experience of the guardian themselves. How does this actually work in practice? So in most counties, they petition on a quarterly basis. Monthly is sometimes considered to be too burdensome, so they ask, or the courts require, that it be done on a quarterly basis. And they file, the guardian through their attorney files a petition for compensation. And in that petition, they indicate how much they've been paid total for that guardianship, how much they've been paid in the past, and how much they're currently requesting to be paid. That petition will include a breakdown of the charges and the time spent on the various activities as guardian. And that petition is under oath, and the guardian swears to its accuracy and truthfulness. If there are interested parties on the case that have filed requests to be noticed on that, the guardian serves all of those parties. They get served with the petition for compensation. And the way to think about it is that petition in and of itself could potentially be a mini trial. If an interested party objects or the court wishes for the matter to be heard, the guardian will go in front of the court and put forth evidence of the time that they spent and what they did during that time period.
Hillary, you're recognized.
So in the 68 counties,
67.
67, I'm sorry, what is the, how does a guardian get paid? So Polk County, there's a guardian who makes $150 an hour. $150 an hour. Then we have guardians, I believe when they start, they get $40 an hour. When do guardians get a raise? That's a mystery to me.
I think it varies per county where they are. Some counties have, Lee County has an order in place that dictates how much a guardian can get paid based on their years of experience. I'm sure there's other counties out there that do something similar. But in counties that don't have that, it's simply, I mean, I think it's up to the judge's discretion.
And Hillary, that may be, well, our judicial panel coming up, that may be a good topic for them to hit on too there.
Thank you.
I think it'd be very appropriate.
If you'll raise it.
I will, thank you.
JD.
So my question would be, because you mentioned that there may be a all-day kind of hearing on the compensation piece. Should the attorney representing the guardian have a role in advocating for the guardian in that hearing or before the court?
Yeah, they do. Yeah.
Should they is my question.
That's a good question.
Very good question.
Go ahead.
Yeah, I just wanted to make a quick comment. I think this guardian compensation is something that the task force may want to take a deeper dive into. It's more complicated than that because most state registered professional guardians that I know also carry a large pro bono caseload, and you have to factor that in on itself. We have a robust public guardian program that serve the indigent persons under guardianship, but there's also a need for more guardians to take those types of cases. So what winds up happening, and the court will ask their professional guardians to consider taking a pro bono case. Now, no professional guardian that I know will say no to a judge, so they wound up taking the pro bono case. And so when you're looking at the resources necessary to fund the public guardianship program and what the state's needs are, you also have to consider that we really don't know what the state's needs are because of this situation that's been created with the court asking the professional guardians to take pro bono cases.
I'm going to recognize JD. I also want to point out that the study that the court did back in 2018, which is quite comprehensive and which we're going to borrow from, that's a nice way of saying plagiarize, is that they dealt, a good amount of that dealt with fees. And we're going to take a look at that section and see what they have developed of that we could share with the task force to see if it's relevant. But Anthony pointing this out, I mean, it's you won't see it published anywhere, but we know that the guardianships with money are paying for the guardianships without money, and that's a terrible system of having to subsidize the folks who built up some wealth in their life to charge them to pay for the other folks who are indigent. But that's the way, that's the judge's hands tied. He doesn't have some other pot of money. You say, here, guardian, I'm going to pay you out of this pot of money. It's not there. And maybe that's the answer. There should be some other pot of money to pay for the indigent guardians. JD.
You already said.
Oh, okay. Ma'am.
Just quickly, also something to consider, the legislature created its own guardianship task force in early 2000. We have a report, that's something that they dealt with too. So comparing what their findings were might be helpful.
I don't have that report. Would you get that too? Thank you.
It's in a 3-ring binder, but I'll be happy to get it.
I think we covered this one. Okay, I just wanted to talk briefly about the guardianship trial. I don't want to get into the contested ones because those are conducted over, and they can be real lengthy trials. Typically in uncontested guardianships, there's a final hearing set that's set at the initiation of the filing of the guardianship. And the incapacity and the guardianship cases are heard at the same time. The incapacity case is heard first. And generally, if there's no dispute over the examining committee reports, those are entered in as evidence of incapacity, and the court rules on that issue. Once the court's done ruling on that issue, it turns to the guardianship. And, first, if there are any alternative means are presented. And then if the court needs to still move past that, they determine who the guardian is and then issue a ruling on the guardianship itself and appoint a guardian. So, all right. The guardian's powers. The main document that gives an appointed or court-appointed guardian the authority are the court letters, the letters of guardianship. It's the main source that gives the guardian the specific powers over the ward. Here's where the court's going to delineate whether this is a plenary or a limited, and if it's a limited, it will state exactly which powers the guardian can exercise. Generally speaking, there's a lot of them, but the guardian's authority are to retain and hold assets, to protect those assets, pay the costs of those assets and reasonable living expenses. They deposit or invest the assets, pay for the administration, hire professionals, and decide the medical and personal care of the ward. There are a whole list of things that a guardian, even in a plenary guardianship, is refrained from doing without court order. I didn't include the statute there if anyone wanted to look. The big ones are to acquire or dispose of property, to perform or to enter into unnecessary contracts, or necessary contracts. It's really contracts. Although sometimes a guardian will enter into certain contracts that deal with day-to-day living without court order. Leave property in an unproductive manner, to borrow money, to prosecute or defend claims, to pay funeral expenses, make gifts, create or alter estate plans, and signing DNRs.
Has that signing DNR, I know in our circuit that has changed. It now has to go through a judicial review. Is that uniform throughout the state?
Yes.
Okay, just one. So they can sign the DNR, but it has to go, before they sign it, does it go through the review? How does that process work? Shannon, if you want to answer that.
Sure. So you basically have to you have to get medical testimony. If it's a crisis situation and you need it like tomorrow, like I think many of us have heard about the case that happened in South Florida where someone did not have a DNR in place and they were resuscitated 17 times before the order was entered. And so, of course, we want to try and rush those cases through, but normally medical testimony will be required and have a full hearing in front of the court where the court can actually hear the testimony. In the cases that I've had, we have the physician appear by Zoom and then the court inquires about the need for the DNR and then the order is entered. But if you're on a rapid, our courts and all the courts that I've heard about are very receptive to getting it in front of them as quickly as possible. And so it can be done on an emergency basis.
And when did this statute go into effect?
Just this last year.
Okay, so and I don't mean to editorialize here, but is it working, do you think?
I think it is. We've done a lot of education on it in the elder law section. I know Reptile's done a lot of education on it. So yes, it's been, everybody seems to know what the forms look like and how it needs to happen. And I think it's been happening pretty effectively.
And anecdotally, again, I know our judges actually have gone to the hospital before.
I love that.
So, I mean,
I'm going to disagree.
Okay.
So you can have a situation that rapidly, just like any human being can have a stroke or a heart attack or something of that nature. And getting the documents ready, getting doctors that are actually willing to testify is very difficult. And it's been my experience on several occasions, like you stated, that someone ends up being brought back multiple times while we're trying to get this done. And it's actually causing harm. We're physically harming and causing pain while we're waiting to get this through. So I would like to see this on our agenda, mainly just to give some kind of exigent circumstance where potentially a hospital ethics committee, or when all of the doctors and everyone involved agrees that it's in the person's best interest. I would just like to see some provision for that.
We'll put this on the agenda.
Thank you.
I mean, obviously, this has been a topic of great interest in the state. So I do think if the statute needs to be tweaked some to improve it, we want to look at it.
Okay. The return to competency, this came up earlier. The suggestion of capacities, the filing that one would make, their guardian, ward's counsel, an interested party, really anyone can file a suggestion of capacity. And that creates or puts into motion the court appointing a physician to file a report within 20 days. Once the court does that, parties have 20 days to object. And if there's no objections and that report comes back positive for the rights that are being sought to be restored, the court then restores those rights. There's an objection, there's a hearing, and it gets litigated at that point.
You want first? Well, let me ask first. Can a ward who's been declared incompetent file their own suggestion of capacity against the guardian who has authority to file anything for them?
They can.
Okay.
They can. I mean, I think there's difficulty in it. The ward's going to have a great difficulty trying to figure out how to do that in some cases, but they can file it. And I believe the statute actually says they can specifically file it.
And second part of that is me as an attorney who represented the ward, I've been discharged. Long before this happens, I'm gone. How does a ward, can a ward find an attorney to do that?
The statute allows it, I think.
Okay.
In practice, how would a ward trying to have their rights restored, who's maybe in an assisted living facility, how do they file a document with the court asking for capacity back? I think that's maybe something we can look into, but I don't, practically speaking, I think it'd be very difficult.
Hillary?
It's tough. I mean, I asked a guardian who has been a guardian for 30 years, and she said, in my 30 years, I've only seen 2 people get their rights restored. Jan Garwood, who was in a guardianship in Seminole, contacted me through Facebook. She said, looking for recommendations, not for a restaurant or a hotel, looking for an attorney to get me out of guardianship. And thank God she had a phone smuggled in, because, a lot of times there's no visitation rules in effect. And one of the things I think that we, as people who are out for the betterment of the guardianship system in general in Florida, is we have got to do something that, and I will gladly come forward and volunteer, we have got to ask every single ward, every single year, would you like to get some of your rights restored? Whether they can or can't, that's another story. But that isn't happening. And within a year or plus, I've assisted at least 3 wards of the state get their rights back. And it's a phenomenal thing. And besides that, when someone gets their rights back, restored, as few and far between as it is, we've got to give them a plan. Because what's happening is when people are getting their rights restored, they're thrown out on the street. More than likely, their homes have been sold. They don't know where their property is. There's no accounting, and a lot of them don't have family. So they are basically there without any money, and they don't know what to do. And it's a very tough situation. So even if you are a prisoner and you're released from jail, you're given $50 to get yourself going. So again, we've got to do more.
And Hillary, this is something too, I hope, and not that maybe there's not a better model out there, but Kimberly and Tom give us a report on maybe what some states are doing. It would be interesting to see if they have any, more robust program for people terminating the guardianship and also some type of transition into success. Because that is a problem.
And if I can make a.
One moment, please. Anthony's recognized first, then you.
No, I was just gonna try to comment after Michael. There's a disconnect there. Constitutionally, people have the right to counsel, right to legal access, but these people have lost the right to contract. We were taking bets on who was going to mention Free Britney first. So that was one of the issues, my understanding in Free Britney. She doesn't have the capacity to hire her own legal counsel. So, yeah.
Thank you. I would add to that, we get a lot of calls from people who are under guardianship, and I think we're only hearing from a very small subset of people who found our phone number online and were able to reach us. There's likely a lot of people who probably could get their rights back, but have nowhere to turn and don't even have the right to get an attorney to represent them. It's a really tall order to expect someone to file a suggestion of capacity on their own. We sometimes assist clients with doing it, but it's really difficult, and it would be good if the attorney who represented them in the first case could have follow up and contact them. There's probably a lot of ways that we can address this, but I think it's one of the biggest issues is making sure that when someone has had their rights taken away, you don't just throw away the key and they're never going to get out. That's a really terrible situation.
And Viviana, you're an attorney, correct?
Yes.
Part of, the charges task force obviously make legislative recommendations, and how we can take some of these items and do they lend themselves to legislative recommendations? Do they lend themselves to some type of best practice that should be embraced across the state, but in some form like that, where the judge can say, "Are you observing this best practice that's out there?" I hope you and those who are smart on this panel could help us with figuring out where do these fall into. And again, we're not a court rules committee. Our friends we may have some segment that says courts, maybe y'all need to examine some of these items, but we don't want to get into the court rules because that, as those attorneys up here know, that's a very convoluted and very tough process that has to be treated differently. So I think we almost have to look through and say, where does this fall statutorily? Best practice, maybe some type of other regulatory or refer to the courts. JD.
I think there are some statutory changes that we can make. And just one last comment is we also run into the issue where sometimes the guardian will tell us, you cannot talk to my ward. And then how am I supposed to help them? And it creates additional hurdles for us. I mean, obviously we'll try to make sure that their right to counsel is honored, but that happens.
Thank you. Sure does.
So this may be something that maybe the judge can handle in his section is how formal or the formality, how formal it has to be the request for the suggestive capacity.
I'll answer it to you right now. When I was on the bench, all I got was a letter from the individual, and based on that letter, I picked the statute. I appointed the examiner or the medical, the doctor and we just.
And I think that's a question. If that's a sort of thing that happens statewide, as long as there's a ability for a less formal request, and if that's honored, I think that's good.
It happens in Hillsborough. A letter from the ward will initiate the appointment of an examining physician.
I'm going to go Michael and Kevin. I'm Karen. You're not Kevin.
Well, I just want to add the practical side is the person most likely to tell the ward they have this right is the guardian, because that's who's taking care of them. I do want to add though on the Brittany thing, the statute, at least for initial guardianship, is very clear that the ward has the right to their own attorney. And I tell all my clients, if you don't want me, I'm fine. You tell me, I'll get out. And you have the right to get somebody else. I don't know if that right continues through the entire time of the guardianship.
There is a case.
Okay.
There's a case called In Re Fe, and In Re Fe basically establishes the fact that and either an incapacitated person that we would call a ward, or a better nomenclature for a ward is a protected person under guardianship. It describes the individual as opposed to the word board. But absolutely, that should not be.
But Judge, how do they hire them? If you're incompetent and have no assets.
Then you basically write a letter to the court. And the court will go ahead and appoint either counsel from the office of conflict attorney, because if a person is indigent, they would be the ones to represent. But yeah, in re fey, F-E-Y.
So I don't think we would have a hearing like Brittany had. I don't think that would happen.
Karen,
We have seen situations where
put the microphone right in front of you, please.
Sorry, we have had situations reported to the state level about different courts handling the formality of that suggestion of capacity differently. So while I think we've got some representatives who are handling just a letter as being sufficient, I don't think that is a statewide policy by any means.
Good, Judge.
Maybe that needs to be one of the recommendations that in the statute, as well as perhaps in the rules, that the court will go ahead and deem any request, whether formal or informal, such as a letter from, again, to kick in this suggestion of capacity. Because I mean, there is a requirement every year in the annual plan to consider capacity and to consider the regaining of rights.
We're going to take an intermission for lunch. We do have, although we've used 2 hours for this presentation, we have a half-hour built in for extra time. This is important for him to finish his presentation, since it's such a nice presentation. He's doing an amazing job.
I don't mean to interrupt you. I'm actually on the last slide of the fact base.
Okay, we're going to finish one more slide.
Okay. I don't mean to interrupt.
No, go ahead.
I have like 2 minutes left and then, okay. Well, that's all right. I mean, I have my notes. So the last slide was simply on dissolution. There we go. The rights restored. So guardianship's dissolved now in 2 different ways. You can have your rights restored, or it can be upon the death of the ward themselves. If someone has their rights restored, the former guardian immediately loses the ability to exercise any rights over the person, but the property is still in the former guardian's name, and there has to be a final accounting and a dissolution of the guardianship and a turnover of that property to the ward. And I think this is where one of the concerns and one of the problems is, if a ward has their rights restored, they're now expected to handle everything themselves. And if the guardian still has their name on all of the accounts on that day that the rights are restored, there's a process by which that property gets transferred to, the individual that had their rights restored. And I don't believe right now we have a good solution to that, because the former guardian is going to say, I need everything in my name so that I can close out the guardianship. And if the individual that received their rights now contests anything, guardians don't want to give up all of the assets, because they want to make sure that everything's there and properly accounted for and whatnot. But it creates a problem, because the individual that just had their rights restored now has nothing. And I don't think there's a mechanism that we have in the current law to address that issue. And then, of course, upon death, if the ward passes, the guardian notifies the court. They have a time limitation of that. And then they wait for the personal representative to be appointed. Once the personal representative is appointed, they go through the process of finishing up the final accounting and turning the property over to the personal representative. So that's the end of the formal presentation.
Did we save this for a little bit?
Either later or next time or whenever, because that's gonna. Okay.
Thank you, Mr. Ropo.
But we are going to provide him more time after lunch to finish the presentation on the vulnerabilities, because I think that's a good section there. And we do need to talk about that. Logistically, folks, we are going to take a half-hour break for lunch. For the task force members, your lunch will be brought to you. So you just can sit there in your box lunch. And also for the panel members, we have lunches for y'all. For any member of the public who's here today, the cafe here at the college is open. It's a nice cafe. They have nice fresh food out there. So you're certainly welcome to enjoy that or whatever you want to do for the next half hour. But we're going to take a break for a half hour. Anyone again who has a comment, wishes to make comments during the public comment forum, please give get a card from Kimberly there, who just raised her hand, and she'll give you the form. Okay? Thank you, everyone. We'll recess for a half hour.
I'm not.
Right. Like, you know, read, online, like, read, you know.
Yeah, I was on it earlier, but now maybe everybody knows.
But that's like.
And their business.
We certainly appreciate that. And hope you enjoyed it and continue to eat as you, we're finishing up here. Again, I want to thank Vito for his preparation for today. It's amazing the amount of work that he had to put into this presentation. And he's going to I know we allocated 2 hours. We did a lot of talking ourselves, and we're going to give him, he's been gracious enough to give us another 20 minutes to finish up his presentation, then we'll move on to the other presentations. But one thing I do want to point out, and again, I'm very grateful to my colleagues in the Clerks Association for their willingness to be involved in this very difficult issue. And the person who deserves probably the most credit is the person who served as our president this past year of our association. We just changed officers, as so many do, July 1st. And that was a clerk from Clay County, Tara Green. And it was Tara's vision that we have this task force, and she had it approved by her board of directors. And that's one of the reasons that the association is sponsoring it. And I know you're Senator Bradley, you're somewhat familiar with Clerk Green, since y'all hail from the same county. And she was, I know, reached out to you to be part of this task force. So we're very grateful to the wonderful clerk from Clay County, your home county, and Tara Green, and make sure you bring greetings from the task force back to her when you see her.
We are lucky to have her in Clay County. She does just an amazing job. She's a great county leader, and I'm glad that she brought me on board.
And just a good person all around, isn't she?
There's no doubt about it.
Amen to that. So let's finish the presentation. Vito, thank you again for your tremendous work.
Thank you again. Okay, so let's see if my presentation. The final part of my presentation, I wanted to talk about some vulnerabilities with guardianship, at least some perceived vulnerabilities that I've experienced while practicing. Let me just see if I can go through. Okay. And I broke these vulnerabilities into 3 different sections, just to easier categorize them, but initiation, administration, and termination. We've talked about some of them already, so in lieu of time, I'll try to go through them a little bit quicker. So first one I wanted to talk about was notice. It's the initiation of the case. Right now, as the current law is situated, whoever petitions and sets the case for final hearing is required to provide notice to all interested parties and to next of kin, or any parties that may be reasonably affected by the guardianship, such as people who are in powers of attorneys and whatnot. Right now, the way that it's worded is it needs to be reasonable. In other civil law, they allow 20 days notice, formal notice. Someone has to knock on your door, serve you a complaint and a summons that says you have 20 days to respond to this. In guardianship, it's generally done by certified mail to the last known addresses. And I believe that this is a vulnerability in the system, that there lacks a crystal clear notice requirement and a list of everyone that must be noticed in order to have a final hearing. Now, I understand that may be problematic if you can't find family members or where those family members live. So maybe there needs to be a carve out or some sort of mechanism that the judge can rule upon. But one important thing to note here is the first party to file is not necessarily the party that's acting in good faith. You don't always equal the party filing in good faith, and we need to make sure that all the parties are noticed properly and given enough time to respond to what's going on. It's not allowing me to click through. The batteries are dead. All right, well, the next issue or the next vulnerability is I put timing, lack of awareness. A lot of people, a lot of family members and a lot of people that are involved in guardianship don't quite understand or perceive what guardianship is. So if there's a family where there's two children and one of the children, child A, files a guardianship over mom and dad, child B might not understand or have any way to comprehend what guardianship is. They get a letter in the mail, by certified mail that says that there's this proceeding going on. But I've often found that clients will come to me and they'll say, well, we didn't realize this could all happen so fast. We really didn't know what it was. And now, after the guardianship's been granted, we had no clue it was going to change mom, dad, or loved one's life so drastically. Had we have actually known that was happening, or had we been given formal notice on this, maybe we would have done something differently. So it's a common complaint that I hear. And I do think that possibly addressing the notice issues, we'd also address some of the timing issues and the lack of awareness on what guardianship is and the repercussions of an actual guardianship. Not to say that the repercussions are bad, just that they change one's life. So, all right.
Just say next slide, though.
Okay, next slide.
Get the thing fixed.
Okay, so I put this one on here, and I think someone over here made this point. Counsel for the ward or protected person. Right now, the court appoints an attorney for the alleged incapacitated individual, and there's not a whole lot of clarity around the substitution of counsel. A well-trained judge, I think they could probably navigate this issue pretty well, but it leaves a lot of room for improvement. And while the individual is not yet determined to be incapacitated, we need to be real careful with allowing them to decide the representation that they want, the attorney that they want. So I think that is, while we have some court-appointed counsel that are willing and voluntarily give up the position and substitute in without difficulty, there's a lot that don't. So next slide, please. I have here open proceedings. There's a critical balance between, in my opinion anyways, between a ward's privacy rights and the right to an open proceeding. And a lot of times, all too many times, the cases are often closed without any real reason to be closed. I've had requests for closure based on the current law, both granted and denied. And there's sort of a split in the way that some judges, I believe, handle this, at least in my experience. And some judges allow wards and wards only to close the proceedings, and others allow the guardian or the guardian's attorneys to close the proceedings on behalf of the ward. I think that this is, we can look at, have to look at the Britney Spears situation. I was watching a commentary, and in that commentary about her whole situation, they were talking about, well, we know a lot of things about the Britney Spears proceeding, but we don't know everything. We're not in the courtroom when it's closed. We don't know what's being talked about. And, there could be some legitimate reasons that she's in a guardianship based upon what they say in court. Now, I disagree with it myself, but there is still things that are discussed in court that we as a public don't know. And that's the whole point.
Thank you. It's a big concern. Criminal trials are open to the public. Yes, there is HIPAA concerns and financials, but all too often hearings are closed for absolutely no reason. And, we can go to, let's just use Judge Shenko, who was in the 20th Circuit of the Middle District. Someone asked for the hearing to be open. The opposing counsel wanted it closed. Judge Shenko looked at the rule, Florida Probate Rule 5.540, where it specifically says that all hearings under chapter 744 and section 393.12 Florida statute shall be open unless the alleged incapacitated person, adjudicated ward, or person alleged to have a developmental disability elects to have the hearing closed. And that must be done by the alleged or the incapacitated person. Too many times the attorneys go in, whether it's the court appointed, and they automatically waive the either ward or the alleged incapacitated person's presence in court. I mean, we have wards that they have written and said, look, I want to be in court. I want to let the judge know that I want to go back home with my mother, and their presence is waived. And when you call the rule, you quote the law. I've had attorneys, threaten me with a felony because I want either the person to be the ward in the hearing or to have it open. A judge in Broward was kind. Someone said, we want this hearing closed. And the judge says, hey, wait a minute, Ms. Hoke is here for one thing and one thing only, just to make sure that everything goes the way it should. So I know there are two sides, but justice requires transparency.
Tom?
Yeah, I was just going to note that last year, I'm on the Rules of Judicial Administration Committee.
Yes.
Last year, that committee proposed a rule, change to that rule that would have made it much harder to close any court proceeding, which would have applied to those cases as well. Having to give notice, having to even hold a hearing, even when all sides agreed, because that's one of the ways that, not necessarily guardianship cases, but some other kinds of cases, that's one of the things that was being abused. The parties would just all agree to close it. So then the judge wouldn't hold the hearing that's required under the Barron case. So they recommended changing it, but there were a lot of objections and the court didn't pass it. They've sent it back to the Rules Committee. And that Rules Committee is going to be taking that up again.
And Tom, is opening or closing of court hearings, and I know there's certain statutory ones that say they allow them to be closed, like the waiver of parental notification of assertion. But can the legislature mandate courts be open in session? Is that again, because we're looking at legislative recommendations, and is that within the purview of the legislature?
The court has ruled in a couple of cases it's not. It's in the court's province about whether the court cases are going to be closed or whether the documents are confidential, et cetera. So, for example, the one I'm familiar with is juvenile cases. There's a statute that says they have to be closed, but there's also a rule because the court had an opinion that said you can't close it by statute, and they passed a rule closing them. So that's one of those things that will definitely be something that we would have to make a recommendation to the court system about how they'd handle that.
Judge?
The one thing that I would mention as far as transparency is concerned, first of all, the background of all of this is Article 1, Section 23 of the Florida Constitution, which provides for an individual's right to privacy. So if we are really going to follow the legislative intent of being or treating our vulnerables with dignity and respect, that's one thing we need to do. And we need to, what it is basically one of these, a balancing act.
Right.
You will always have an audio, or if it's an electronic transcription, or if it's a court record, you always will have a transcript. That might help again with some of your concerns about transparency.
Yes, and I'm always going to call you Your Honor. Yes, Your Honor, but that is not throughout the state. Are there audios and videos? So
There should be.
There should be, yes. And
Because that's what
also,
the rules require.
yes, and I also do believe that the alleged incapacitated person should have a say. This is so important.
I totally agree.
You can do no wrong in my book.
During my time on the bench, I did not, unless the individual was totally incapacitated,
Correct.
nonverbal, and I had that on the record.
Yes.
I would not allow the waiver of
Thank you.
appearance, particularly also in Chapter 393, cases when you're dealing with guardian advocates. I wanted to see, I wanted to hear. It's only
Yeah.
common sense.
Michael?
You would think.
I had a totally different direction, so if you want to go to, I did not.
And make sure you have the microphone close. And
I think you addressed annual reports that are required for basically the life of the ward. Is an attorney, does the guardian require to have an attorney to file those reports?
I think the attorney's required to be on the case, but I've had clients file them themselves, so I don't.
Because one of the biggest problems faced in my circuit with Tallahassee Second Circuit is guardians don't file them. I think partly because they can't or don't want to pay the attorney every year, but they just don't. The judge doesn't want to remove them or punish them because they're taking care of the ward and there is nobody else. And so they've been really stuck as to what to do.
Anthony had a comment, then Shannon.
I was just going to say that, many feel that the due process rights of an alleged incapacitated person are transferred upon the adjudication of that person as incapacitated and transferred, those due process rights are shifted to the guardian and to the attorney. So anytime there's a contested matter, the ward's assets are being used to defend those actions. So I think this committee should look at that issue in terms of, in terms of leveling playing field, and in terms of, ensuring that there's a check and balance system, that if the playing field isn't level, or if the proceedings are sealed or held confidential, that there are sufficient checks and balances to stand in the shoes of that person. You can't both diminish monitoring and diminish clerk auditing and also seal the cases.
Okay, so first I just wanted to say that you don't need to have an attorney to file annual reports unless it involves assets. So unless it's financial. So if they're just filing annual reports in like a guardian advocacy, there's no need for an attorney to be involved in those filings. And actually the clerks, I think in every circuit have the report forms. So people can fill them out and file them without the need of an attorney. And I know for most of us, we get out of the case after it's established and give instructions to our clients on how to file them themselves. On the other issue, I just have to go back to the process that we're putting people through when they're going through an incapacity proceeding. And that is incredibly difficult. We have someone who's been alleged by family, friends, people they know to be incapacitated, which means the ELISA, the court-appointed attorney, is going to go and read them a petition that says, you forgot to turn the stove off, you're incontinent, you fall down all the time and won't get medical treatment, you're not washing yourself, all these very private, very embarrassing things. And then we're asking them to appear at a hearing and there may be strangers there. And no offense to Ms. Hogue, I know she's an excellent advocate, but if it becomes an open forum, that means everyone in the world can hear about the fact that they've, been in their diapers for 3 days. It is not a good process. And frankly, the privacy rights of an individual going through this process really need to be protected. If we're going to balance the right to privacy versus the right for someone who doesn't know the person, I really think having access to transcripts after the fact, filing a petition saying we want to make sure things went well, that may be a way to address this issue, but letting an incapacitated ward go through this process with the least amount of public involved, in my opinion, is really important for us.
Hillary?
And that's all fair and good, Ms. Miller, but I mean, you, I believe, are on the committee to seal all guardianship records in full. I believe, and that is the worst thing that could ever be done. I am who I am, and fellow advocates We are very respectful people, and we do this because we care about the elderly and the disabled. And it's not because we're going there to get information. We are going there, and we're not going in groups, but we are going there to make sure of one thing, that the proceedings go as they should. Because too many times in different situations, they have not. And I don't know, the bill wasn't filed this year, but we know about the bill to seal all records concerning guardianship in the Sunshine State. And that is not acceptable. And it's not. It has nothing to do with getting the specifics on someone who is going through, you are correct, the worst situation in their life, worse than losing their spouse.
I'll just add that when we get calls at Disability Rights Florida, and when I talk to people who are under guardianship, none of them have ever told me that they are worried about their privacy. What they have told me is, I want help. I want someone to listen to me and help me get out of this. So I understand the interest in privacy, but I wish that some of the people talking about privacy were as concerned about all of the other rights that that person has lost, which are equally important. And I think being present at a case where your rights could be removed is really important. And I would also just note that there's nothing undignified about having a disability and needing to wear a diaper and needing support. It's only how society sees that. So it also requires us to have a different perspective about what it means to have a disability, and what isn't embarrassing. So I'll just note that, and I think that that's something that I'm sure we'll have a lot of conversations about, because it is a balance, but I worry that we're weighing that the concern about the person's privacy may be a veil for something else.
Judge?
I see where you both are right, okay? There are those individuals who, for whatever reason, their desire and their wishes for privacy must be observed, as well as those who have the right to waive their constitutional right to privacy, to come to you to advocate for them, because there's nobody out there that's going to do it. So the balance is, let's take a look on a case-by-case basis. And if it's somebody that wants to absolutely hold on to their privacy rights, because their definition of dignity is not one that can be or should be subject to someone else changing it. But honor them, and then honor the folks that want to come to you and waive those privacy rights. I think there's room for both. I think that's, I guess, the balance.
And Judge, I like the way that you framed it of, let's ask them, because I think part of the issue is that we're not asking them, we're asking their guardian. And that's where it gets dangerous. If we ask the guardian, well, what do you think about their privacy? And we don't ask that person, it's their right.
I can't respond to that directly, other than to tell you that that was not my practice.
Yeah, I appreciate that, Judge.
So I think back to something that Anthony said as well as a judge and all that one is.
Oh, microphone, please.
I'm sorry, is that the ward doesn't lose their due process rights, and that can't be transferred to somebody. You can't transfer a person's due process rights to a guardian. And so it sounds like in the judge's experience, he gets an affirmative waiver if the ward's going to waive their due process rights, as opposed to somebody else waiving it for them.
The guardian stands in the shoes of the individual that's been adjudged incapacitated, but there's always room to accommodate, and there's always room to ask. I mean, it's the smart, it's the kind, it's the right thing to do.
Right.
Part of having a task force with many diverse points of view, and we intentionally wanted that, is to bring up the different perspectives. I mean, that's what enriches a task force working together to try to come up with some solutions. And I hope we, in nothing, I think, in our comments should be in any way that diminishes the the perspective of someone else. That's what we always say, we're bringing the perspective. That's what we have on our little name cards in front of us. And so anyway, I just be mindful of that. We want to make sure we're respecting each other's perspective. And I think we should give each other the credit that the perspective that each of us are bringing are how we genuinely see things through that view. So just a little friendly reminder on that. Go ahead.
Sure. All right, we touched on this one earlier. The issue, there is an issue, and there's sort of a glitch, I think is what we referred to it earlier in the system, where when an attorney is appointed for a ward and there's no incapacitation, no guardianship found, it doesn't necessarily mean it's in bad faith. And if the alleged incapacitated person who's who's been now judicially determined to have capacity, has a court-appointed attorney, they didn't necessarily consent to having that attorney represent them and have no contractual relationship with that attorney. And really, I think the problem is if an attorney works really, really hard at getting someone out of a guardianship and then has this, pretty substantial bill for having to have done that, who pays them? This is actually a concern that was brought to me from a couple other attorneys that I spoke with in preparation for this. They've been through that situation where they've represented a client, got them to be found to have capacity, went through the whole process, and never got paid on it, never got paid for that work. So it really comes down to, and to structure a framework of vulnerability, but it's a lack of incentive in a lot of ways for an attorney that's been appointed to represent a ward to get them out of the guardianship.
Mr. Robo, what do you think? I mean, I guess I shouldn't be able, and I hope, Ken, I'm okay speaking.
Yeah, that's fine. Please help.
It's such a huge thing because we see time and time again where the court-appointed attorneys are not fighting for the betterment of their clients. I've seen it in my dad's case. And then when the person tries to substitute counsel, there's pushback. And you have to go to the appellate court and fight it. So I do think, and the court-appointed attorney, they work really hard as well. So I do think it's a big issue.
Big issue.
All right, this is Judge Rodriguez, Honorable Rodriguez.
No way, Jose.
I'm sorry?
No way, Jose. It's fine.
He pointed this out or had mentioned it earlier. Not being able to see the person in court, not being able to see their composure, see their facial expressions. Yes, they have the right to remain silent, but there's a lot more that goes on here than just, speaking or testifying. And a lot of times I find, and I believe that attorneys and sometimes doctors in certain cases will waive the appearance of individuals or alleged wards or alleged incapacitated wards in situations where not because the ward or alleged incapacitated person doesn't want to be there, but that it may be too hard to get them to the hearing. Now, I think that's changed a lot in the last year with virtual attendance. But I think that it's a failure of justice sometimes for the court not to see the ward, to speak to the ward if the ward's willing to talk, and to possibly ask them what their opinion is on a matter. So I think that this is, while in practice it makes sense to allow people to waive the appearance, I think it's done way too often.
Tom, I'm going to ask you no questions just for the remainder of this report, just because we need to move on time. So we're going to just let him finish his report, then we'll move on.
Sure. I'll go quickly here.
Thank you.
Another one is the initial inventory. And, I think anyone that has to audit or go back through cases can appreciate this. But the initial inventory is very, very important in guardianship cases because it establishes the status quo throughout the entire length of the guardianship. And, there's not a system by where there's a lot of checks and balances in the preparation of that initial inventory. And there's a lot of different opinions as to what to include in the initial inventory. In some cases, guardians will include every single little item down to, how many forks they have in the home. And some where they don't include really any personal property, but they'll instead put a number on what they think the personal property might be valued at. The issue is there's no real way that the court has, of course, there can be objections to it, but there's no real way of determining what exactly an incapacitated individual had, which is, I think there was, a criminal case filed in this county just a couple weeks ago on this exact issue. It's very difficult to figure out what someone had before the guardianship, especially if they're found to be incapacitated and don't have a way of inventorying it all themselves. So emergency temporary guardian, during the administration. So sometimes the court appoints an emergency temporary guardian to bridge the gap until there's a final hearing and the possible appointment of a plenary guardian. Now, when the court appoints these emergency temporary guardians to prevent imminent harm from happening, and a lot of times they give, in most cases, when they appoint the emergency temporary guardian, they give them all of the rights or that a plenary guardian might normally have. Sometimes there's limited over an alleged incapacitated individual. In my opinion, and what I've seen is these emergency temporary guardians sometimes last 6 months to a year. And it almost becomes a guardianship in and of itself in some cases. And, I think that a lot of us can do a better job in scheduling final hearings and setting limitations on how long these emergency temporary guardians can last in cases. Put this on here, disposing of property. So the sale of real property is an issue. And it's an issue that I was working with Mr. Burke on prior to coming here. And there's some ways that we can work to fix it, but essentially, if a guardian is going to sell a piece of property that belongs to the ward, there's certain safeguards that we can put in place, or there are best practices that we can put in place that don't currently exist. For instance, as an example, if a guardian is going to sell a piece of real property on behalf of a ward, it might be diligent, or I believe it is diligent, to make sure that property is listed on the open market. It's listed in, an MLS system and not just sold off the market without a realtor. The market bears what price is going to be, the highest price that's going to be fetched for a property. And in a few guardianship cases that I've noticed, and, I think in more than just the one, but it happens where they list these things for a few days and sell them. They don't really give them time to entertain offers or to introduce bidding wars to things and really bring that value up. It's not always the guardian's fault. Sometimes realtors will underbid things knowing it's in a guardianship case, or they'll underlist things. They'll sell really fast. You might get a full price offer, but if we don't keep that on the market and see what the market actually bears, we don't really know what the value of that property is. And I think it's especially important in guardianship cases because a lot of times the property's not in tip-top condition. The property has, degraded to some extent because, we're in guardianship, someone who's incapacitated or partially incapacitated. And we need to be real careful with valuing that degradation of the real property, which is why I think, listing a property listing it on an open market, an MLS system with a realtor, and entertaining offers for a certain period of time, and then taking that best offer you get and presenting it to the court for sale. All right, and then termination of guardianship due to suggestion of capacity. We touched on it earlier. I'll go real quick. Essentially, when someone regains their capacity, then what? You're essentially left and put out on the street, and you're waiting for the final report. You're waiting for the guardian to hand over all your money. It could be a few days, it could be weeks, it could be months. It could be litigated and take a really long time. There's no system or mechanism in place in the current structure of the law to deal with this issue. So in closing, this is the last slide I have. These cases, these guardianship cases, they're very complex. There's no simple solution. They're very nuanced and very fact intensive. And I think really proper training of the clerk, the judiciary, and attorneys, I don't have attorneys on there, but attorneys as well, and possibly putting this to some of these cases on complex dockets where they're given a little more attention and can allow the court to really parse through the complex facts would really help in these situations. And we touched on a lot of different things here today. That's all I have. I appreciate the opportunity and welcome any other cases.
You can see the work that he put into this, tremendous amount of work and preparation. And we are very, very grateful for you taking the time to be with us today and the hours that you put into this PowerPoint and all the preparation, making sure we get the most pertinent information. I am going to end with one question, and again, I don't want to in any way a pejorative against any guardians, but the initial inventory that a guardian does, are there any safeguards? And I was raised Catholic, and so we have at least have a prayer say that ended, well, you avoid the near occasion of sin. And that meant that you were kept honest by making sure you have good processes there, and I just wonder, like, if a guardian does the initial inventory and they go into a house, and let's say, oh, I know Dad always kept some money in the house, or keeps money in the house, well, maybe it was 6,000, but the guardian only puts 2,000 down, because is there anyone there accompanying the guardian to ensure that that's 6,000 found and not 2,000? And again, I don't mean, but that's just, I'm in the auditing business in the county. When you have temptation like that, it's just too strong. So like, is there any safeguards there, I guess?
No, it's just a sworn statement of what they've recovered or what they've received. Now, there is for safety deposit box that there's a system there where a banker is required, I don't know if it's one or two, but there's bankers that are required to be with you when you open it, and they have to inventory every item that's in there and file that documentation with the court. So there's uninterested third parties at that creation, at the creation, or I'm sorry, the opening and then the creation of that inventory list. So there's mechanisms in place in some areas,
but not in the house. And so that's something that probably our task force should look into, because that is a vulnerability which people have often said, I thought this, but then the inventory is showing something different. Shannon?
I was just going to say, I know with a lot of the guardians that I work with, we always have a witness. When I say when you're inventorying the house, bring a witness with you.
But there's no requirement.
No, but that
And
may
it's not uniform throughout the state. I don't mean to.
No, but that may be an easy fix,
Yes.
as to have someone sign off on what you.
And maybe an independent witness,
Disinterested witness.
Disinterested. That's, there we go. Thank you again. Let's give them a big round of applause for wonderful work.
Okay, well, I have the pleasure of bringing up our next panel, which is Guardianship, a Judge's Perspective. And we have General Magistrate Kimberly Baselli from the Florida 20th Judicial Circuit, which is Lee and just in Lee County. And a gentleman that needs no introduction, the Honorable retired Judge Jose Rodriguez. But thank you very much for being here.
Good afternoon, everyone. I think we kind of split our time in half, so I'm going to go first and then
I speak very fast.
Judge Rodriguez is going to go second. All right, thank you. I think the panelists all have a printed copy. So I just wanted to introduce myself generally. I am in Boselli. I have been presiding over guardianships, including I am in the civil division in Lee County in the 20th Circuit. For over 5 years, I've been presiding over guardianship. I generally handle all of the initial cases for guardianship in our county. If an objection is filed, then obviously I wouldn't preside over, but those are rarely filed. So I end up hearing almost all of the guardianship cases in our county. I do want to just give a caveat because I am governed by the Code of Judicial Conduct. None of my statements are intended to be policy statements or anything like that. I'm just speaking as to what I have seen in my time, given the laws in place as they currently are, and my duty to apply them as they are written. So with that, I will go into my statements, and my slides have a lot of information on them. So I'm sorry for the the small print. I don't know where I'm pointing this at.
Good work.
Okay.
There you go.
So they are very small. I apologize. And I'm not going to say everything in there, but you can always refer back to them if you need to. But I'm intending to cover the general standards. I'm going to try not to repeat anything that Mr. Rocco has already addressed in his statement. So just starting off with the emergency temporary guardianship proceeding, that's under 744.3031. That is a standard or a proceeding that is used usually on a short-term basis, although as indicated by Mr. Rocco, there is a hearing required. I think it was clarified a year or two ago that you do have to have a hearing. Court-appointed counsel is supposed to be there. And then is there imminent danger to the person or the property of the alleged incapacitated person? The notice requirements are different because it is intended to be a short-term hearing. In my experience, I have this set on my docket usually within a week. As long as the court-appointed attorney and the petitioner's attorney and I am available, we go ahead and get it set for hearing on pretty short notice. So you're not going to have time to give notice to all of the next of kin and all of the interested persons. The statute does not require notice to all of those persons for the emergency temporary guardianship proceeding. The court, in addition to appointing a guardian or emergency temporary guardian, also has the ability to enter any injunctions that may be appropriate under the circumstances. The presence of the ward, or AIP, at this stage they are still the AIP, can be waived, and there's supposed to be at least 24-hour notice to the counsel for the AIP as well as the AIP, unless the petitioner demonstrates that substantial harm to the alleged incapacitated person would occur if the 24-hour notice is given. So that is sometimes utilized, but there's an evidentiary basis for waiving that time period if it's appropriate under those circumstances. That only lasts for 90 days. And the intent is that you should be having a hearing. If all of the time periods in the statute are being followed, you would have your final hearing within 45 to 60 days of when the petition is filed. The statute says that it can be extended for an additional 90-day period if the emergency circumstances still exist. Now, that issue has come up before me, and I interpreted "and" as an indefinite article to mean multiple extensions if the emergency continues to exist. Now, I know there has been some case law that came out since I've addressed this issue that has found that it is one extension, which would imply that you can only have 180 days. So I think that may not be uniform. District, depending on the DCA that you're in or your interpretation of the statute, but that's something that might be clarified, whether it's intended to be one or whether it's intended to be as many as necessary. And I will talk later about circumstances where ETGs sometimes are necessary to be extended longer than maybe just the initial 90-day period. So at the end of on this page, there's the common issues that we often see, or I often see. Is it really an emergency? Is this something that really needs to be addressed within the next, immediately, and then I can't wait 45 to 60 days when we have the reports back and all that? Is it really necessary as to the person and the property? Or maybe it's just one of those, maybe it's just one right. And it really, there's a legal authority that it should be narrowly tailored to what the emergency is. So I always try to narrow them in that way to what is actually an emergency. Are there advanced directives? Now, sometimes, technically you don't have to consider less restrictive alternatives until the incapacity stage. But for me, it's relevant because if there is some kind of advanced directive that would allow decisions to be made during the pendency of the proceeding that, depending on if it's suspended or not, which is also later on in my slides, that might, if the only durable power of attorney that exists is suspended by operation of law, then there is nobody there to pay bills. There is nobody there to take action. And sometimes that can create the need for, at least in part, for an emergency temporary guardianship. So I think that was, I'll talk about the suspension a little bit later because it's in one of my other slides, so I won't get into it too much. I have seen one other just kind of I don't think it comes up too often, but I have seen parties try to use emergency temporary guardianship for children, which I don't really think is the appropriate venue. I don't think it's the appropriate proceeding because it's only when an incapacity petition has been filed and children are presumed to be incapacitated. So I don't think it's appropriate, but it is not that clear. And I have seen attorneys try to use it to get an emergency guardianship. So that's something that might be able to be clarified. And I've also seen just guardianship in general try to be used by parties to try to take custody over children over the objection of the parent, which again, I don't think is the intended use of guardianship, but I have seen it. And to the extent that that could be clarified, I think that would be could be helpful just to eliminate that as an entire category of cases that sometimes pops up. And it was mentioned earlier in some of the discussions about this injunction for protection against exploitation of a vulnerable adult under section 825.1035. This is a proceeding that can be filed when you have, it's similar to a domestic violence injunction. And it is, if there is no guardianship case filed, it can be heard in the domestic violence court. But if there is a guardianship petition pending, then it has to be heard by the guardianship court. It can be heard ex parte, so you don't, unlike the emergency temporary guardianship, you don't have to have a hearing. So the court can do that in chambers, but you have to have a hearing within, I believe it's 15 days, which can be extended for good cause. It's intended to be heard on very short notice with service to the respondent to have that full hearing. There's a lot of remedies available to the court, which I'm just because of the time limits, I'm not going to go through all of them, but they are listed in the slide as to all of the remedies that the court can use. But it does include prohibiting contact with the person there is evidence that they are exploiting the AIP, freezing assets, things like that, which are intended to protect, again, the AIP and their assets. It's usually more directed to assets than necessarily the person. The next one is considerations and appointment of guardian, similar to 744.312. So one thing that we always look for first is a pre-need designation. So this is, and we'll get, so if incapacity is found, then the court determines whether a guardian is necessary. In determining who to appoint, first you would look to, is there a pre-need declaration? Did that person say who they want their guardian to be in the event that they become incapacitated? I find that that's not very often done. So, but that is something that you look for first. And if they have made that declaration, then the court should follow it unless it is contrary to the ward's best interest. And that's not just not in the best interest of the ward, but contrary to the ward's best interest, which there's some legal authority that suggests that's even higher standard than just best interest. So in the absence of one of those, the court can appoint any person who's fit and proper and qualified to act as a guardian, whether related or not. You don't have to be related. The court does have to give preference to somebody who is related by blood or marriage, has educational experience, has capacity to manage financial resources, the ability to meet the requirements of the law. Court cannot give preference to a person based solely on the fact that they were appointed as ETG, which is emergency temporary guardianship, guardian, if I hadn't clarified that before. The court should also consider the wishes expressed by the ward. Now, I will note that those wishes are often expressed through their attorney, but the court does have to consider those wishes. If the minor is over 14 years old, then the court has to consider the preference of a minor. Any person designated as guardian in any will in which the ward is a beneficiary, the wishes of the ward's next of kin, if the ward cannot express their own preference. An emergency temporary guardian who is a professional guardian may not be appointed the permanent guardian unless the court makes specific findings. The court has to find that one of the next of kin of the AIP or the ward requests that professional guardian be appointed, or that may be waived if the court makes specific findings that they have special talent or specific prior experience. So that would have to be an express finding made by the court to have that professional ETG act as the final guardian. Common issues that I see in these cases are, so you get a lot of current spouse versus children from a prior marriage. You get children fighting each other. You get, and a lot of times when it's children fighting each other, then that creates the issue of maybe it's better to have a professional than the children who are fighting each other and don't trust each other under the circumstances. And then there's always the issue of conflicts of interest of any of the parties, but professional guardians, family guardians, anybody. This comes up a lot when you have a power of attorney. So let's say the AIP did execute documents in favor of child number 1, but they have 2 other children, and then children 2 and 3 find out that child 1 has allegedly been doing bad things with the power of attorney. So, separate from the less restrictive alternatives issue, there's who should be appointed, and you don't really want to appoint this person if it's been proven that this person has done bad things against the ward's best interest, take property, give away property, things like that. The court has to consider whether it would be appropriate to appoint that person as guardian if those actions turn out to be true upon the evidence presented at the final hearing. And then I just wanted to know that sometimes, and that can change too. So who you appoint at the adjudicatory hearing, maybe there is no family member who's willing to act at that time. You can appoint a professional guardian, but then there is a family member who later steps up and says, no, I'm willing to do it. I wasn't able to before because I had things going on in my life, but I can do it now. Then that can be transitioned to a family member as a non-professional family guardian at a later time if they're then able to serve and willing to serve. So who may be appointed guardian? I know Mr. Ripple already went through some of this. If you're a Florida resident over 18, and there are limitations on judges being guardians other than for their relatives, but that probably doesn't apply too often. Non-residents, you have to be related within a certain amount of consanguinity or marriage. There's a list. I won't repeat the list. There's a long list of disqualified persons. I know there was some question before about sexual type of acts, and it's very long list. So if you have, and there's references to other statutes, so it's a lot of crimes that could disqualify you, even if they're not found. So felonies always, and even misdemeanors, if there are certain types of misdemeanors, there's a lot of reasons why you could be excluded. Creditor of the ward. If the ward owes you money, you cannot be their guardian. That's one that I ask about a lot at hearings when facts come up about maybe loaning money to the ward to pay some expenses or paying bills for the ward or for the AIP prior to adjudication. You're going to want that money back. That makes you a creditor. So that could be disqualifying, or it could be the type of thing that you can disclose on the record and the court can still approve the appointment despite that potential conflict. So
There's no requirement as far as education or?
there is one of the things the court has to consider, and I think it was on the prior page, is who is qualified or what the court has to consider. It's whether they have educational, professional, or business experience relevant to the nature of the services sought to be provided. That's on the second bullet point on the considerations and appointment of guardian. It's number 2.
So maybe how does it work?
There's an education requirement, 8 hours.
So after you're appointed, there is also an education requirement that like family guardians are supposed to take. I see that a lot of times those are waived. I tend not to waive them because
You're a good person.
Well, it's a new job that they've never done before most of the time, especially with family members. And, you have an attorney representing you, but they're not there in your home day to day, making these decisions and spending the money. And I find that the family guardians truly benefit from having that education. And it really, because I see it on the back end, like orders to show cause down the road, that it's better for them to have that education early on. Now, one thing I would just add is, as far as I know, there's no Spanish language education. And I see a lot of guardian advocacy cases, which again, I'll talk about later. And they don't have to be represented by counsel and they have to file annual reports, but some of them don't speak English and they don't get, I've had petitions to waive the educational requirement because it's not taught in Spanish. So if there was a way to get that translated into Spanish, that would be helpful for those pro se guardian advocacy cases.
I guess my question is more on if you were, how did they do this analysis of what you have here as required for a professional guardian? How do y'all make those type of determinations?
For what a professional guardian has
Yeah.
to do, well, that's, as far as I know, governed by OPPG as to what, these are normally, OPPG determines who should be registered as a professional guardian.
Okay, but then you have a set of professional guardians, and then you're assigning a professional guardian to this case because they meet these types of standards here. So how are you matching?
So usually the educational and training is not an issue with the professional guardians because they've all gone through an extensive training course. It's usually the educational issue comes up more with the family guardians and whether they have the education and training to be able to do the requirements of a guardian. In our cases, and it was something that was mentioned earlier about whether you use a rotation system for the appointment of a guardian. As far as I know, our circuit does not use a rotation system. And if the petition includes who they want to have appointed. That could be a professional, it could be a family member, it could be any number of people, but it's in the petition. So I would consider who is requested to be appointed, as well as if there's any counter petitions filed, if there's a family member who files an application to be appointed, I'll consider that. But so in weighing, if I have it before me, I have a professional, I have a family member, or maybe two family members, then I just have to weigh under the facts and circumstances of this case. Does this case need a professional guardian? Does this case only need a family guardian? Which family guardian is qualified to serve and would be able to serve and does not have a conflict of interest? So it's really a case-by-case, fact-intensive inquiry.
And maybe you can go more into that, case by case, fact based, because, these are the questions we get from citizens. It's like, why is my brother's guardian from Polk County when we live in Pinellas County and there's plenty of guardians here in Pinellas? Why did the court pick someone from Polk County?
So I do see that occasionally, and I think those are more often filed when you have like the ALF, the hospital, or the nursing home initiating, and then they have a guardian that they have worked with, and who are guardians of other patients, or not patients, but residents, and they can visit the resident at the same time that they're. So there's an economy of scale, I guess, maybe, and having the same guardian. But when I am hearing it, I hear what they're presenting to me. So they present in a petition, this is the person we want appointed. And unless there's an issue raised with regard to that particular person being appointed, or, if there's a family member who steps up and says, I want to be appointed instead, then I can say, okay, family member, I can appoint you. I would normally go with who is recommended in the petition. Although with people out of town, I have found that it's, either it's not necessary to appoint somebody out of town, or I specifically put in the order or the recommended order that they can't charge for fees for traveling from wherever they're located to visit the ward at their residence or their location.
I guess just that issue tends to be one that perks up often.
I'll say in Lee County where I preside, most of the guardians are local. They're mostly Lee County. Maybe you still get some people from Collier County, which is the neighboring to the south, or Charlotte County neighboring to the north. But most of our people are local. Occasionally you'll get some people out of a little bit farther than that, but again, it's not common for us. So I can't speak to the rest of the state.
And when you get a request for a particular guardian, do you have any information as to how many guardianships they've ever had in there, how many they've closed, any audit findings they've had in the past, or?
I don't have that level of detail. When I became a magistrate in 2015, shortly after that, I asked, because the clerk's office maintains a file on every guardian, but I didn't have easy access to that. So thankfully in Lee County, they were able to set up files for each professional guardian so that I can go into their file in our circuit, in our system, and pull up their bond, their registration confirmation, their background check, their credit check, and the clerk's office does a great job of.
But for that particular
For
county.
that particular, well, that's the guardian's information. Now, in their application that they file on every case, they're supposed to list every guardianship that they have. Now, I don't go look up every guardianship that they have and that's listed there. So I have the information to know that they're currently qualified. They currently meet their requirements, that they're up to date on all the expectations that we have of background checks and credit checks. We do get notification if there's a complaint filed or if there's something pending with DCF, they provide us copies of those in a case that that person is guardian already appointed. So we may not know that in a case that they're a proposed guardian, but if they're an existing guardian, we do get notified of that as well.
And I just asked this too, because again, in reading newspaper articles, which I hope they're factual, but it was mentioned, especially in the Orange County case with the do not resuscitate, the judges, I didn't realize she had that many guardianships.
And there is no limit on, as I read the statutes, there's a limit on public guardians that they're only allowed to have 40, I believe, but for professionals, there is no
But you would
limit.
think that, there should be some disclosure of that to the judge as how many guardianships that particular active guardian.
That is in the application. The application does obligate them to list all of the cases that they currently have. But I don't know the status of all the, other than that they're pending.
Right, in the application that's filed in the incapacity proceeding, they have to disclose every single guardianship, including the case numbers.
It's
at least in our
application for appointment of guardian. So in our county, we have those filed in the GA case. But yeah, I mean, it's filed in the GA case with the oath and the application get filed with the petition normally early on.
And that includes ones around the state.
It's anywhere, any case, and I think it even includes past cases. I don't think it's just pending. I think it's any case you've ever been appointed a guardian.
JD?
Real quick, I think we're touching on the data management, data collection kind of thing that we probably we need to talk about in depth, but I wanted to touch on something real quick from a data collection point. You mentioned waiver of the training requirements for family appointments, and you said that you take that very strongly, which we appreciate. I have found in my area that not as much. They don't take that as much, and so it gets waived a lot. And so having at least a reporting component to see how many times that's getting waived statewide may help us, because I know that it's like you said, when you review cases that became a problem later on, you look back and see if it was waived and you find that it had.
I think it used to happen a lot when they're represented by counsel because, well, they're represented by counsel, the counsel will tell them what to do, but that doesn't always happen. And again, I don't know that attorneys are giving them a handbook at the beginning of once you're appointed guardian, here you go, here's what you need to do. And then without that instruction, the guardians are, the guardians are kind of on their own to know what to do. And then they have recording requirements. You're supposed to keep your records for 3 years after discharge.
Right.
And people show up at orders to show cause saying, I didn't know I needed to keep that receipt. I don't have that anymore.
And I think that's when you look back and see that.
And then I say,
they
oh,
got
your
waived.
educational requirement was waived and, so, and then in the meantime, counsel was discharged and they were supposed to get new counsel and they never did. So I've learned over the years that usually, and there are times when there is a good reason. If they've been a guardian in another case, maybe it wouldn't be necessary to have them take it again. Or if there's siblings and, maybe you just take it in one case, but not the other, so that you don't have to pay the fee twice or things like that. But normally, it's something that I take very cautiously.
Karen, you had a question?
I just wanted to ask if the internal file that the clerks are keeping on the guardians individually, does it also track if they are delinquent on other cases with filings?
So our clerk's office, and I can only speak to Lee County, they have a chart that they keep up to date and they send me a copy maybe once every 6 months. That'll show me they're highlighted in red if they're missing something. And they send deficiency notices to those guardians on a periodic basis. I don't know exactly how they set that up to remind themselves to follow up, but they do track that. And it's not in the case system, but it's in a separate document that I get that shows me if they're current.
But again, Karen, that's a county by county thing. If there's no, if a guardian has guardianships in multiple counties, you're not seeing that type of thing.
And I had to ask for that to be set up. Like that wasn't already there in place when I started. And I said, well, how am I supposed to see those guardian's file if I don't want to go to the clerk's office every time to look it up. So thankfully they were able to set that up electronically.
So just to be clear, so if you get an application or a petition and it said recommends a guardian, if that guardian has had like 25 complaints against them before, you won't know that.
I would not know that unless the court-appointed counsel points it out, or if I happen to know that. I guess I could, if it was filed in another case, because again, I handle a lot of the cases in Lee County, I could be aware that an issue is pending against that guardian. I can think of at least one circumstance where I found out about a complaint against a guardian in one case, and then I had a hearing with that guardian in another case, so I knew about it. But generally, no, I would not know that. All right, so the suspension of power of attorney, again, I'm just going to go through this briefly since it was discussed already a little bit. So the suspension does not automatically occur if the power of attorney is in favor of a parent, spouse, child, or grandchild. But if you're one of those four things, then they have to file a verified petition to suspend it. And there's like A through E grounds that the decisions are not in accord with the AIP's desires. Power of attorney is invalid. You'll see that sometimes they executed a power of attorney 3 years ago. Everybody agrees they were probably had capacity 3 years ago, but there was a new power of attorney executed 6 months ago. Did they have capacity 6 months ago? That's a question of fact, usually. Agent has failed to discharge his or her duties, or incapacity or illness renders them incapable of discharging the duties. Agent has abused power. So this is an example of if child one has taken the power of attorney and transferred property for no consideration, that's an example of where you could have it suspended even if it's in favor of one of those close family members, or that there's danger that the property may be wasted, misappropriated, or lost. That's the same standard for an ETG of the property. So the statute does say grounds for suspending a power of attorney do not include the existence of a dispute between the agent and the petitioner, which is more appropriate for resolution in some other forum or a legal proceeding other than a guardianship proceeding. I don't know that that's been litigated or defined as to what exactly that means, but that's how you could get those suspended even during the pendency of the incapacity. The next slide is 709.2109, which is, again, this is where it's automatic. So automatic suspension for anybody else. So, niece, nephew, friends, strangers, those would be automatically suspended pending the incapacity adjudicatory hearing. So unlike the power of attorney, though, the healthcare surrogate document is not suspended. So unless otherwise ordered by the court, a proceeding to determine incapacity does not affect the authority of the agent to make healthcare decisions for the principal. So there is kind of a disparate treatment in those two documents. It is something that we have to address when we have ETG hearings. Do we have these advance directives that need to be addressed somehow? Sometimes they're automatically, power of attorney can be automatically suspended, but the healthcare surrogate's not. Is there a reason to suspend that pending the final hearing, or should we just let it stay in effect? It would depend on if there's even an emergency as to the person. Those are fact issues that would have to be decided on a case-by-case basis. I mentioned common issues. Suspension of a power of attorney may provide basis for an ETG. Again, if the power of attorney is not in effect and the power of attorney had been used to pay the ward's bills, those bills need to keep getting paid. So there might be a need to have an emergency guardian appointed for the property only pending the final hearing. So, and then whether to suspend the healthcare directive, which I already talked about. So procedures to determine incapacity, that's under 744.331. We've already talked, and Mr. Roper talked a lot about the notice. So you have to have notice to the next of kin and interested persons. That includes holders of powers of attorney, healthcare surrogate document, or any healthcare surrogate document. Court must appoint counsel for the AIP, and the AIP may substitute private counsel. There is a question that I've had come up many times, maybe several times, where counsel for next of kin wants to substitute as counsel for the AIP. My general ruling on that is that it should be their own attorney. The AIP should be solely represented by an attorney and not an attorney for another party as well, because of conflicts of interest or potential conflicts of interest. And the statute does say own attorney. So I think that In re Fay case also says that it should be their own attorney, but I still get attorneys arguing that they have the right to counsel, they want to hire me, I should be able to substitute in for them, and I thus far have denied those without prejudice to filing a petition to substitute their own private counsel who will only represent them.
They can waive the conflict.
I don't know, the statute doesn't talk about waiving conflicts. I mean, do I have to have an evidentiary hearing to figure out whether they can waive the conflict? Does the AIP have the ability to waive the conflict if they're incapacitated or they're allegedly incapacitated? It creates a lot of issues with regard to can that be waived, which is why I always, or generally, I don't want to say always, I generally err on the side of
And back to
finding it should be their own counsel.
back to the notice. Is that governed by the probate rules? I mean, this is not a probate proceeding. is
The
it?
notice to next of kin?
Yeah.
It's under 744.331 expressly says next of kin. And I don't know if it's the statute or if it's case law that talks about other interested persons, because people who hold powers of attorney, people who hold healthcare surrogate documents would be entitled to notice of that. So that's been, and I didn't put it in my slides, but the Veterans Affairs Agency is entitled to notice of any cases where there's VA benefits.
Well, I was just going to say, the reason I was asking is because normally notice is a procedural issue, not a substantive issue. And I wondered if if any of the rules committees deal with it. I'm not aware of rules of judicial administration do.
The rule, I don't have my probate rule book in front of me. I would pull it out if I was on the bench. I'm pretty sure that there is a rule that talks about the incapacity procedures that also talks about notice of the incapacity hearing to next of kin. The ETG statute has its own notice provision, which is different than the notice provision for the incapacity adjudicatory hearing. I think by virtue of it being a different type of proceeding, not on an emergency basis. So it was already talked about the examining committee. I'm not going to go into that since it was already discussed a lot earlier. One thing I would point out is there is some confusion over what exactly the members are supposed to examine there. And I didn't put the citation in here, but there was a case that came out a year or two ago that found the examining committee report was insufficient, but it left a lot of people wondering what exactly is necessary. So if that could be cleaned up, that might be helpful to the court, because I've also just recently started getting Daubert objections for people arguing that the committee members' opinions don't meet the Daubert standard. So that's a relatively new development that I've been dealing with lately. So just something that might be worth looking into.
Just for my notes, can you clarify that? Because I was writing another.
The Daubert standard?
No, I know Daubert.
Oh, okay.
But the thing about that, excusing one of the members or what standard they have?
So there was a case that came out a year or two ago, and it was about whether you had to do a physical examination or not, what that examination had to include, if you could waive that requirement or that portion of the exam, and if all three of them had to do it, or if just one of them had to do it. And I wish I had put, what is it?
Yeah.
Is it cooked? Yeah, cooked.
I meant to put it in here and I forgot to look it up, but, and there was I think it was even on rehearing, I think they clarified it, and it was still left some questions about what's required. And so that's something that might be helpful. And they're supposed to do their examination within 15 days and file the report within 15 days. And then the hearing is supposed to be within 30 days of the last filed report. So if all those reports are timely filed and then the hearing is set timely within 30 days, you theoretically have a hearing within 45 days of the petition being filed, because the order of appointment is supposed to be entered within 5 days. So about 45, 50, maybe 60 days, unless good cause is shown. So we had some delays during COVID with getting all the cases set. So, good cause can be shown. If there's not going to be a change in the AIP's condition in a, 10-day time period, most people will waive that time requirement. But it is a basis to object and have a whole new examining committee, new reports issued and all of that if it's necessary. There should be an interpreter for the AIP if they speak a different language. That should be provided for all of the reports as well as the final hearing if necessary, which is why I believe the incapacity petition requires the statement regarding the AIP's language.
Does the interpreter, Chair, does the interpreter have to be an independent interpreter, or can it be a family member?
The statutes and the rules do not address that specifically. I can speak to in the court proceedings, there is rule 2.565 that mandates qualified, and they can either be certified or duly qualified for purposes of the proceeding. I don't believe that that expressly applies to the evaluations or the meeting with, like the court-appointed counsel meeting with our client. I know, for example, we have the regional counsel that is appointed to a lot of our cases has staff members who, if it's Spanish, like they have Spanish-speaking staff members who will usually do that. I'm not aware of funds to provide interpreters for all of those other stages. But it's an issue. I mean, I had one case not too long ago. The AIP was from the Czech Republic, and finding a certified interpreter who could translate for the final hearing, we had to use, like, they could only appear electronically, but they wanted an in-person hearing because the AIP had hearing difficulty, and it was challenging proceedings.
Can I ask you, quick, how about ADA accommodations? There's been some cases where, you know, it's not written in stone. Who pays if someone, an AIP has hearing issues or vision, you know, is impaired visually? Isn't it gratis or does that person or family have to pay for the accommodation?
As far as I know, that's provided by the court system. So our notices of hearing have a phone number that on all the notices of hearing who you could call if you have a need. And so, for example, I know they've had assistive hearing devices provided, and I believe that that's all free. Now,
Would
if it
that be
was
for depositions as well?
that, I don't know. I know that what we provide is at the courthouse. So unless you have the deposition at the courthouse, which sometimes happens, you can reserve rooms to do that if necessary. But I don't think that's expressly addressed in any of the statutes or rules that I'm familiar with.
So one more translation. Do you get documents like powers of attorney and all that in other language that they've executed before they move to the United States?
I cannot recall ever seeing a power of attorney or healthcare surrogate document executed in another language, but that doesn't mean they don't exist. I just haven't had the pleasure. So again, just to try to summarize, there's requirements on serving the report.
Sorry. I just wanted to suggest that we add this issue to our list of things, clear funding for the interpreters and the ADA elements that occur outside of the court. That's the evaluation process with the examining committees, so that there is clear communication, and the court-appointed attorneys, because that's not clear in the law at this time who's responsible for paying, and that there is a pot of money available so that they actually get what they need.
All right, so on the one I'm on, yeah, so they talk about, I'm sorry, I'm on the wrong page. Here's the next one. So this is what the examination must include. Again, I'm not going to repeat it. It's in the statute as to what it has to include, but it also says if indicated. So it's not really clear what if indicated means or is intended to mean. It also talks about what the report has to include, and that's a lot of stuff that the report is supposed to include, including as to each right, whether they have the capacity or not. The clerk has to serve the reports upon the petitioner and counsel for the AIP within 3 days after receipt. And then that's supposed to be 10 days before the hearing, at least 10 days before the hearing. That's often waived. If you get the last one 5 days before, usually nobody's going to object to that. The petitioner and the AIP may object to the introduction into evidence of all or any portion of the reports by filing and serving a written objection no later than 5 days before the adjudicatory hearing, and it must state the basis upon which the challenge to admissibility is made. If timely filed and served, the court shall apply the rules of evidence. So I've interpreted this to mean the rules of evidence don't apply, and you have to consider the examining committee reports as evidence and admit them into evidence, absent that written objection 5 days before the hearing, unless the court finds good cause to extend the time. I will go as quickly as possible. So dismissal of the petition, if at least 2 of the 3 reports find that they're not incapacitated, then the case should be dismissed without a hearing. AIP must be present unless waived. We've already talked about that. Now that has good cause. So it can be waived by the attorney essentially for no reason. There's no qualification on the counsel's ability to waive the presence, or the court, if the attorney doesn't want to waive, then the court can find good cause, is how I interpret that. Maybe there would be a benefit to giving parameters to when an AIP's counsel can waive, but as of right now, I believe they can waive for any reason. Common issues, conflicts of interest. I've already talked about substitution of private counsel, timeliness of the reports. They're not always filed on time. Hearings aren't always scheduled on time. We do the best we can, but with the volume that we have, it can't always happen. So we already talked about. All right, so the rest of it is, I think we talked briefly about the right to remain silent or to testify. The open or closing of the proceedings, as I understand it, is up to the AIP only. It is their decision whether to have it open or closed. Alternatives to guardianship. So that could include powers of attorney, healthcare surrogate, trusts, et cetera. Guardian advocacy can be a less restrictive alternative. They have to be sufficient to address the problems and needs of the ward. So this is an example. You could have a power of attorney and a healthcare surrogate document, but they may not be sufficient because they don't address all of the rights, or they are in favor of a person who has been established to have, abused the power under the power of attorney. So for those circumstances, they're not meeting the needs of the ward, and the guardianship is necessary. I have had, the statute does say that if you're finding somebody incapacitated, the court has to enter, and there's a petition to appoint a guardian, the court is supposed to do that simultaneously. However, if for whatever reason you can't rule on the less restrictive alternatives issue or who should be appointed guardian, I have found incapacity reserved on less restrictive alternatives and the appointment of a guardian to have a further hearing on just that part. And in the meantime, appointed an ETG to act on the ward's behalf in the interim time period. And that is an example of where the ETG might need to be extended multiple times, because when you get a real litigious case where they're doing discovery and they're doing all that stuff, if you can only have an ETG for 180 days, that may not be enough time to get the case ready for the final hearing on those contested issues. I'll skip over the rights. There's rights that you always have, even if you've been determined incapacitated, including the right to privacy and the right to counsel. That was already addressed earlier. Technically, counsel is discharged when the initial plan and inventory are approved, but the statute says they have the right to counsel all the time. So, and this also comes up in order to show cause cases where, allegedly or possibly the guardian might be doing something wrong, but there's nobody acting on behalf of the AIP in those proceedings. And I, as a neutral fact finder, can't investigate and I can't raise issues for people. So it would be helpful if there was counsel at that stage in the proceedings as well, at like an order to show cause type stage, or the guardian maybe not doing what they're supposed to be doing. I know we're short on time, so I can just, you all have the handout. So if you have any questions, I just to see if I had any other notes that you want to address specifically. Oh, voluntary guardianship. I was just going to say that's something that I often see in response to an incapacity petition. They say, oh, I'm not incapacitated, but I'll go ahead and do a voluntary guardianship of my property. If you're concerned about maybe my money's being dissipated, this way it'll all be, in the record. So that's something, but it's only if you're capacitated, and it's only for property, not for your person. And then the guardian advocacy as a less restrictive alternative, that's really only for developmental disabilities and may not always apply to regular, just other types of incapacities. I think that statute is, I'm not exactly sure what to do with the some but not all language. It's for when a person lacks the decision-making ability to do some but not all of the tasks necessary to care for his or her person, property, or estate. And so I've interpreted some but not all to mean that they have to be able to do something. So then we have testimony over what's the one thing that they're able to do, so that they have at least one right to be retained. But that's perhaps could be addressed or clarified. And then just as to alternatives to guardianship, that can always be revisited at any time. Granted, you can't execute a power of attorney after you're incapacitated, but if there's a trust document or there's a power of attorney that is found maybe later that you didn't know existed at the time of the adjudicatory hearing, but it's later discovered, that could be a reason to terminate the guardianship and use the less restrictive alternatives instead.
Thank you.
That's it for now. Thank you.
And also, that's a tremendous document you put together for us. I mean, getting all the authority. Judge?
What I was going to say, the public guardian for Orange and Seminole County, even though they're in different circuits, teaches classes in Spanish. I did 2 of them way back before COVID. They've now gone online. So if you access, you contact them, you should be able to get more information on it. or maybe even link up with them to do that. What's your call? I got it. I think I need to get my steps in. But I have found that being wired usually helps if I move around. And it also happens to keep the interest of folks that I might be putting to sleep, keeping them awake. It's something that I've learned from teaching class. I had as a from our vice chair, Anthony Palmieri, I had the request to go ahead and do. Are you moving that on me? Or did I do that? Basically, a review of authority. What I also added, I added references to some of the rules of probate. And I want to start by saying that my statements are my statements only. I do not represent the courts. I do not represent the Ninth Circuit. I do not represent the Supreme Court. I speak for myself. I am an attorney, despite the fact that I was a judge for 31 years before I retired in January of 2019. I was, since 1991, I was a certified judicial instructor, which meant I got to teach folks who knew everything. And I tried to learn myself. There are some things that we need to go over. You know, Magistrate Boselli got the pre-adjudication and I got the post-adjudication statutes. Some of the things that I want you to remember is that the term adjudication is very, very, very critical here because there are some exceptions. There you are. I knew I was watching and I thought I'd do that. I'm glad I got it out of the way early. An emergency temporary guardianship does not necessarily need or require, it does not require an adjudication of incapacity. Why? Because usually with an ETG, you're waiting for the petition for incapacity to come down, as well as who's going to be appointed as guardian from there on, and not a temporary. However, every rule has an exception. The case that I cited in the material, Jasser versus Sade, is one where the judge actually went ahead and entered an adjudication of incapacity during an emergency temporary guardianship, which is, I think, rare. A voluntary guardianship, adjudication of incapacity is not possible. If you have an adjudication of incapacity, the voluntary guardianship fails. Voluntary guardianship requires capacity and requires that in the petition there be some type of medical information. See, I missed it this time. There's a big old thing here that's playing with me. And the other is guardian advocacy. When you've got a guardian advocacy and appointed under 393, there is no necessity for an adjudication of incapacity. As a matter of fact, it's not even contemplated. So it's basically more for assisted decision-making when you've got a guardian advocate, because you've got some degree of ability to make decisions. And again, the guardian advocate becomes someone who will assist in that endeavor. So for the purpose of discussion, post-adjudication will refer to the time after the appointment of a guardian, not the adjudication of incapacity. What I want you to do is, I'm going to go through the statutes pretty quickly. And what I need you to do is, if you want to keep a look at the exact text of the statute that I'm referring to, you're going to see that you've got the statute number 744-369. Google it, pull it up, and that way you can see word for word what I'm, again, synthesizing for you. The judicial review of guardianship reports under the statute are required to, well, there is a report within 60 days of the clerk's report of findings. In other words, an initial guardianship report must be filed within 60 days of the report of the findings. An annual report within 30 days of the clerk's report of findings. That means the court has to go ahead and review the initial guardianship report after 60 days after the clerk sends a report, sends the findings up to the court. Same thing with the annual guardianship. Okay, let's get here. Common sense. What judge is going to have the opportunity within 60 days of the clerk's report of the findings going up to him, 30 days of the annual guardianship report, the clerk's report and findings going up? Who's going to have the time to review those? I hear dead silence. You're right. There's not going to be a single one. And that's why we've got general and special magistrates. They are and can be appointed to assist in the reviews. A report, when it's not timely filed, the court can go ahead and issue a court order or issue an order to show cause. An order allowing or letting the person or the folks know that, hey, folks, you've missed the time. In other words, why have you not filed the report? Or go a step further to enter an order to show cause why you should not be held in contempt of court for violating the statutory terms. I can tell you that when I was on the bench, this was the most frustrating portion. The number of reports that I wound up getting where lawyers would not, or folks would not file the reports, and having to hold afternoon after afternoon of orders to show cause hearings. And then sometimes we had even lost track because they had moved and they had not bothered to keep us abreast. There was one individual case that I will not forget that finally somebody showed up in court 16 years after there was no report filed. Turns out that on the 8th year, the guardian, first of all, the ward had passed away. It was this person's mother. The guardian was the father. The original guardian was the father. He was basically in hospice, and the daughter did not know what to do. So the only thing that I could do at that point was dismiss the case. There were no assets. There was nothing to report. The report had been made, and I just want someone to appeal that because there was no appellate remedy for that. The initial ward was gone. The guardian, what am I going to do? Hold him in contempt of court? I don't think so. So the next best thing was to let it go and dismiss it. Continuation. The court review has to be to determine whether or not the report meets the needs of the ward, makes sure that the guardian is acting within the scope of authority granted. In other words, is the guardian basically doing something that is ultra vires or outside the scope of the letters that granted the authority to act, and to make sure that the report conforms to the law. Also, an order has to follow from the court approving or disapproving the report. If there is disapproval, there are instructions to the guardian on how to correct, giving time to correct, giving him reasonable time to correct, and then to refile the report. If the report is not filed after the court finds that the report is lacking and the court disapproves, then failure to file the report within the time given by the court will require that the court follow up by either compelling compliance or sanctioning the guardian after a hearing that notifies the ward, council, and guardian. In other words, we're going to tell on you that you haven't been doing your job. And if you don't like that, we're going to bring you into court and explain to us what basis you have for not following the court's order. Objections to report. Hearings are to be set within 30 days of an order to be filed after the hearing. That is, in other words, when the order approving or disapproving or asking the report to be modified has been filed, again, you need, the hearing needs to be set within 30 days. If objection is without merit, the court can go ahead and assess fees. An approved report.
Just very quick question. Who's allowed to object?
And any interested party.
Okay. And who would even get the report to know to object?
A good question. Anybody have an answer? Because
The rule, so 744.3701 talks about for initial and annual reports are
Right.
confidential and they're only to be provided to certain named persons unless the court finds good cause to order it to additional persons. So in the absence of that type of order showing good cause, it would only go to the guardian's counsel. And at that point, there's no more counsel for the ward because they've been discharged after the initial report and inventory has been approved. So, but I think the rule says any interested person. So there's actually kind of a discrepancy between 744.3701 and the rule on objections.
Obviously, the guardian's not going to object. The guardian's counsel is not going to object. That leaves one person.
You do also have at the beginning of the case, any person can file a notice requesting future notices and the court could grant that prospectively to allow notices to be filed and reports to be filed.
that's exactly where I was going. 5.060 of the rules of probate will give you the opportunity to file with the clerk a notice of interested party with your address, with all particular information for notices to be coming to you. Relief to be granted, 744.371. Statute requires or discusses what actions can be taken depending on annual report content. It requires a hearing if the ward's condition requires, quote unquote, further examination. If there's a change in the proposed care, maintenance, or treatment, whether or not it's restoration of rights, if there are any restoration of rights or any rights that can be restored, well, then the hearing, and obviously when there's that notice or that letter indicating that there may be some rights to be restored, follows. That's the hearing hopefully after the time that is given to the doctor to examine the individual. Best interest of the ward requires action beyond what has been previously authorized or indicated in the plan. And again, if in other words, what this means is if it is in the best interest of the ward to act outside and beyond what the letters of guardianship have authorized, then of course there's a hearing to see if that can be, those rights, that can be expanded beyond, again, what was originally granted. In other words, it's kind of a hearing on a modification of the powers based on the annual report. And again, and E is the catch-all. Anything else to protect the interests of the ward. Post institutional commitment, 744.3215 sub 4 sub A. The guardian does not have the right to go ahead and have someone submitted or have their liberty restrained under the Baker Act without first going for a court order. A person cannot be committed to a facility or institution or any license provider pursuant to the Baker Act. In other words, the Baker Act is not available for dementia. In other words, if someone is a danger to himself or to others by mental illness, that applies. But if the individual is acting out or having a crisis due to dementia, that does not fall within the Baker Act. And again, the criteria is whether there's a danger to themselves or other. This allows a person's freedom to be restrained for evaluation for no greater than 72 hours. And by the way, weekends and holidays don't count in the computation of 72 hours being held for, again, evaluation. Dissolution of marriage. You notice that I've added a case there. That case is required reading. It pits two statutes. Actually, It speaks to the guardianship statute, but section 61.052, which basically is in the domestic relations area, precludes the institution or the maintenance of an action for dissolution of marriage until 3 years after the wife or husband has been adjudged incompetent. That's what Goldberg versus Goldberg held, because that is what the statute requires. The reason for that is that there may be a lot of, what's the word, hanky-panky? Hanky-panky going on when you've got individuals who just might have met at the ALF and have decided to, get married. And then something happens to one or the other, and then there's the dissolution because, wait a minute, we're talking about the possibility of inheritance. We're talking about the possibility of someone taking our funds. So what the courts have done, what the legislature in their infinite wisdom has done, is basically they've gone ahead and have a 3-year survivability statute, a moratorium for the dissolution of marriage. I had one of those cases. It was rather interesting. And that's how I learned about Goldberg versus Goldberg and this section of Chapter 61 of the Florida statutes. In Goldberg, there was another statute. The one that I was telling you was in competing. It was the Elder Speedy Trial Rule. Elder Speedy Trial Rule. This is not a criminal case. It's not. But due to the fact that some individuals that are older and frail need to have their cases resolved quickly, there is a statute that says that the courts may accelerate a case deal when they're dealing with someone over 65. To some extent, I resent that. I may not be able to do a triathlon like I used to do 5 years ago, it's like 6 years ago, but still, I think that's why Goldberg establishes, by reading the language of those two statutes, that 61, the marriage dissolution moratorium, isn't that a mouthful? Marriage dissolution moratorium, the 3-year, was mandatory because it said shall. In other words, the institution of and maintenance shall not, in other words, a lawsuit shall not be instituted. However, the speedy trial rule said may accelerate. So the may accelerate portion, or the speedy trial rule, was not mandatory, it was discretionary. So Chapter 61 in the 3-year moratorium won over. So the 3-year survivability statute.
Judge, you're making us nervous with
I know
this.
you're.
Okay.
This is what happens when you're a former Disney tour guide. You can see back here.
Okay, good.
I know, I felt it. Rights of that's the reason I get around.
Safety, welfare, and health.
He's keeping us alert, keeping us engaged.
By the way, there's going to be a quiz no, there's not. I think some of this comes from the fact that I used to be, for 6 years, I was corporate counsel for Tupperware home parties. And yes, I can sing I've got the Tupper feeling. It was required if you were going to move up the ladder. So post adjudication, right?
Judge, I have a question for you. On the items that you presented thus far, and I know you're no longer on the bench, so you can give editorial comment.
I do.
Do any of those statutes need to be changed, or are they, you feel from your professional viewpoint, the ones you've covered thus far are doing what they intended to do?
The funny thing about it is that no matter how you craft a statute, there's always someone going to find a way over, around it, or under it. So at this point, Florida is pretty darn good in terms of what we have said.
Those ones.
So far, so good. It's not till the end when we're dealing with court monitors that I think we need to maybe do some changes. And I know there's quite a bunch of differing views there. But be that as it may, I can tell you that those, the way that the Ninth Judicial Circuit has used our in-house court monitor made it possible in one particular year for us to return $500,000 of money that had been lifted from several individuals to go back to them. So it is, and if you use the court monitor appropriately, if you use it, if lawyers who use it, who know how to use it, are able to get a lot of investigative work done. And from a judicial standpoint, to have an investigator go out and look for evidence, for information that is not being given to you. Because let's face it, a guardianship attorney has as their primary mission to represent the guardian and, by extension, the ward. Let's be charitable and lump all of that together, okay? But who is out there to provide unbiased, unvarnished, unmanaged information to the courts, but somebody who does that investigation? The court's major problem is that, okay, we're required to be fair. We're required to be fair. And in being fair, that means that we cannot jump in, as a magistrate said. You've got to go ahead and at least give the semblance that you're being impartial. And the last thing that you can do is jump in there with both feet and become an advocate for the individual. You're not. That's not the role of the judge. That's not the role. But it is to get as much information as possible. And when you've got one side being represented in one side only, that's what's the importance of in re fe, that you've got enshrined in case law the right to have an independent counsel for the incapacitated, for the person under guardianship protection, the ward. I know I jumped off, that's good. But I know that's the main thing. And postage, these are additional rights that require court action: permission to engage in clinical trials, experimental or biomedical behavioral procedures, to preserve life, serious mental or physical impairment. And I'm telling you, you've got to have the backup documents when a petition like that comes before, because no judge is going to be crazy enough, magistrate, it's going to be crazy enough, if I may, to go ahead and just grant a petition because you just showed up in court and decided to file. But again, the medical information has to be there to allow for the procedures to take place. And of course, consent to termination of parental rights, consent to abortion or sterilization, nope. One of the things that you need to know in that statute, okay, is right there at the bottom of the asterisk. This statute is not intended to confer additional rights. In other words, it is procedural. The statute is not intended to confer additional rights because they don't want to weigh in, they meaning the legislature, does not want to weigh in into into the consents for termination of parental rights and the consents for abortion and sterilization. That's not here. The purpose, I believe, of this statute is basically to go right along with Rule 5.635 of the Florida rules, for the Florida probate rules, which is basically to provide how you follow through with a petition for extraordinary authority, asking for these types of relief. And that is, you have to have an appointed, what? Independent attorney. For the incapacitated person, the person has to have, that lawyer has to have an opportunity to speak to the incapacitated person. The person must, the judge must receive evidence, independent medical, psychological, social evaluation, or if they don't have it, you go ahead and you appoint your own experts. The judge or judicial officer must personally meet with the incapacitated person to obtain its own impression of capacity and afford the person an opportunity to express views and desires. There you go. That's clearly there. Why? Because these are such monumental things that you're asking the court to do, that the court is, in this instance, required to meet, to see, lay eyes on the person. Clear, and the standard is clear and convincing evidence of lack of capacity, not likely to change in the future, and to be persuaded by clear and convincing evidence that the action requested is in the best interest. Again, this is a procedural rule, a statute, or the statute basically says it's procedural, not substantive, and you've got the Florida rule of probate to back up the procedure. Okay, power of a guardian with court approval. Okay, notice in the red, section 744, 441 specifically, sub 2A and B require an evidentiary hearing after a DNR and a preliminary hearing within 4 days, or a preliminary hearing within 4 days after. That's right. That's not right. I think it was too late when I was writing this. But basically, you've got a hearing on the DNR immediately with a preliminary hearing 4 days after. Guardian has to obtain approval for all of the, it just is, there it is. Let me rephrase number 10, the DNR. I knew there was something kind of kitschy in the prior slide. DNR preliminary hearing is to be held within 72 hours. And I know that that's way, way too long in some instances. From what I hear that is happening, at least in the 9th, they're being heard within 24 hours, and they're being heard only in the guardianship division. So they're able to keep up with them. But after that initial hearing or preliminary hearing, another hearing has to be set within 4 days. Restoration of capacity. We talked a little bit about that. Venue, where the guardianship is located. Who can file a suggestion of capacity? Any interested person, as well as the protected person. That is in the statute. Petition includes that the protected person, the ward, has to include that is currently capable of exercising some or all of the rights removed. And the court then appoints a physician for the protected person with a report to be filed within 20 days. The court immediately, and the statute says immediately, I just kind of capitalized it there for effect. The court immediately has to send notice of the suggestion of capacity to the ward, guardian, attorney for guardian, and interested parties. An objection has to come within 20 days after the service of notice of hearing, copies of objections, and medical examination report to the ward, guardian attorney, next of kin, and any other interested party. The court has to appoint what? An independent attorney for the ward. Okay.
Michael, since you have that listed last, when does the court appoint the independent attorney?
It doesn't say specifically. The statute doesn't say specifically.
So is it after all these other 3 things happened?
It's usually in the same order.
I would say
Okay.
all in one. Yeah, it's like most of the cases where we've got a motion to determine incapacity, you also have an ETG petition as well as a petition to determine a guardianship. You've got the blunderbuss shotgun approach.
Whoa,
There we go.
Okay. All right. Move the box.
You don't get away from these.
All right. See this? It's memorable.
Woke us all up, Judge.
There you go. Nothing more than slapstick, I guess. So yeah, if you pull 744, 464, that's the order that they'll come in. This is subsection 3, order on restoration of capacity. The burden of proof is preponderance of evidence. Burden of proof to determine incapacity is clear and convincing, a higher burden than to restore. Order needs to be entered following the hearing, making findings of fact and stating what rights, if any, are restored. If some rights are restored, the guardian has 60 days to file a new report, 60 days from the date of the order. Restoration hearings, the statute basically indicates are to be given a priority and to be advanced on the calendar. How many days? It doesn't say.
Judge, this is the restoration. I want to get back to the whole big question of the examination committee and you as a judge appointing, determining the person's incapacity. How much are you relying on that evaluation committee's report?
Completely.
Okay.
Completely, because what I am looking at is I'm looking at whatever order I entered, right, to be sustained on appeal or that it not be set aside. And what I need to do is I need to make a reference to the documents as I would. I'm taking judicial notice of this report, this report, this report.
And that makes sense, but that's why I guess the evaluation of the evaluation committee
right
is so critical, because obviously a judge should rely on a credible evidence like that, but the evidence has to be credible.
Absolutely. Let me toss something. Go ahead.
So in the absence of an objection
right
filed 5 days ahead of the hearing, that's the only evidence you're going to get.
Yeah, I mean,
and that, correct me if I'm wrong, but that's the primary, the majority of the cases basically are unobjected to, unless it's 2-1 and somebody wants to strike one of the individuals and order re-examination. Let me ask this question.
Thank you.
I hear that somewhere around the state, every one of the members of the committee, the examining committee, go and visit the ward at the same time. Anybody? Is that a practice that any of you are familiar with?
Yes,
They used to do it. They can't.
yes. Now they do Zoom all at the same time, but yes.
All at the same time? Okay, why would anybody have a problem with the 3 members of the examining committee going and seeing someone at the same time?
Sundowners.
Sundowner, exactly, that's one.
It's too much on the alleged incapacitated person.
Well, it might and it might not be. I can't jump, I have to get my exercise other than by jumping to that conclusion.
Yes.
Okay, but here's the thing. What about the possibility that the experts are colluding or are basically in cahoots?
Yes.
Or they don't have let's look at it in a nicer way. Maybe they don't have the opportunity to form their own independent judgment because they are basically,
Exactamente.
you know,
Yes.
Easily persuaded.
Groupthink.
Okay, so I would hope that if you live in a jurisdiction where everybody goes to see the examining, or the examining committee goes to see at once the alleged incapacitated person, that you will bring that up to the judge and you raise an objection to it, because I think that it's critical, because you're not going to you're not going to see somebody acting the way they act, whether they're sundowners or during the day, and you just may catch somebody that gives an enlightening performance for that member of the examining committee that somebody else would not see. So it amplifies the ability to do that. And I suspect that if we were able to add something to the examining committee that they are not able to all go visit, however artful, I know I'm not phrasing it artfully,
Right.
but that they're not all, that they are to see the alleged incapacitated person at different times.
And the statute's now silent to that?
Yeah.
Just within 15 days.
Yeah, but that's it, within 15 days, but that doesn't say anything about going together you know, and I think that may be something that needs to be improved upon.
Judge, I would never rush a judge, but we need to finish the presentation.
Okay, terminating the guardianship. The ward becomes an adult, is restored to capacity, unable to locate the ward during diligent search. Now, what happened here? You mean my ward has escaped? I don't know where he is. I've tried to look, and I can't find him. I looked high, I looked low, I looked everywhere, but I can't find. So why is that in here? I hate to say this, but the probate division basically is an attempt to move fast through the process without, again, forcing anyone to lose precious, valuable rights. The thing about it is if somebody has passed away and cannot be located, a diligent search has been done, then how is the court going to protect this person under guardianship? I had a case where I wound up with a number of articles that showed that the person was thought to have been killed. Never found. Person was under guardianship. After a number of years before I took the division, that guardianship had been filed. I had no choice but to dismiss it. And this was my statutory basis. If it's a property, if it's a guardianship of the property, when the property is exhausted, the guardianship is over. Final report needs to be filed, discharge received. Now, important thing about an order to discharge after the guardianship is over is that, I can't do the light. The sentence right above the red says the discharge, when there's an order of discharge, the discharge shall operate as a release from the duties of guardianship and as a bar to any action against the guardian or guardian surety, unless the action is commenced within 3 years of the date of the order. So in effect, what you've got is you've got a termination of liability and a 3-year statute of limitations to go ahead and go after any additional action from the date of that discharge order. Talked about court monitors. We'll probably talk more about it. And there are emergency court monitors as well as regular court monitors. And
Judge Rodriguez, I had two questions, and I more want to get it on the record for Tom's notes than have a long discussion. But the one thing I'd like the task force to consider looking at is who pays for the court monitor. And in cases in which there is wrongdoing, is there a statutory provision, or can we recommend a statutory provision to, I don't know what the word is, surcharge the wrongdoer either for attorney's fees or court monitor fees?
there isn't, at this point, anything in the statute to surcharge the wrongdoer.
I think, not all circuits and counties have a winter alderman and a court monitor, but maybe looking at a model for a regional court monitor or a circuit court monitor or something like that.
I think that's an excellent idea. The problem, I would say, is please do not add it. Let's not add it to the duties and responsibilities of the conflict counsel. They do a phenomenal job representing AIPs, but it takes it just takes an immense amount of time. But yes, if we were to have a regional employee, okay, or even a circuit employee, no full-time state, county, or municipal employee or officer shall be paid a fee for the investigation or report. And basically, what we wound up doing with the court monitor is when probable cause was found for fraud, before we had 825, What we wound up doing is we wound up referring it to the Office of the State Attorney's Office so that they would go ahead and look and follow through with criminal charges. Unfortunately, they thought it was civil. Civil theft? We have that, but I mean, it's a matter of training. Thank you, John.
Thank you, Judge. We appreciate that. We appreciate you not falling, so. You did a great job.
Although there's lots of attorneys in the room, they might have made some money out of it.
I didn't bring you,
Yeah, but they were all witnesses.
I didn't keep you all away.
Our last panel of the day, before we hear the public comment, is from the clerks. And we are fortunate to have Karen Rushing, the longest serving clerk in the state of Florida. She was appointed clerk by Governor Martinez back in the 1980s and is still the clerk in Sarasota County, a magnificent clerk. Stacy Butterfield, the clerk from Imperial Polk County, and we appreciate you being here. Both are past presidents of our association. Dr. Jerome Jordan, who is with the Pasco County Clerk's Office and heads up their civil division. And we have Michael Healy, who is the general counsel for Lee County Clerk, and Clerk Linda Dockett. So we're certainly glad to have you here, and I'm not sure who's going first. Karen, it's good. Thank you. Welcome, Karen Rushing.
Thank you, Ken, and thank you, everyone here for being so interested in a subject matter that all clerks are interested in. We had a very lengthy presentation for you about how all the documents move through the clerk's office, but after listening to how informed you all are and to the details of what's already been presented, we're really going to move a little bit quicker so that you just have an understanding of some high-level things that I heard some of you ask questions about. So you've already heard the kinds of guardianships that we actually file on behalf of the court. And as you've heard, many of the documents that come in are filed with the clerk. In fact, all of them are. One of the things that you heard the judge just refer to is oftentimes the incapacity and the guardianships coming together. They're in separate files, but they're coming together and being processed very quickly along the same lines. And these documents, I will say, become very important as we use them as the documents related to our activities. We do monitor for the court whether timely filings occur. I think there was a question asked about how do they do that, and do they do that? The CMSs, the case management systems, actually do have data elements that allow us to enter dates, and then those are monitored through reporting as to whether there's compliance. If there is compliance, it's a good thing. If there isn't, there are processes in place that we then move to support the court. So you heard a lot about the 60 days that the plan and the inventories are required to be filed. These, of course, are monitored by the clerk. There is some variation throughout the state in terms of how one monitors. One judge may prefer that the clerk notify the judge and the judge then enters the order. Some judges, since it really is a clerical function, did it get filed or didn't it get filed? We have an automatic process that just issues the order. So in either way, the order goes out asking, order requiring the document to be filed. And then I think you heard the judge say right after that, there's an order to show cause if there continues to be non-compliance, and then it's back in the court's hands for additional steps. The clerk, as you know, has some responsibilities in the early part of the case to examine some of the documents, the plans, and then as we check through these documents, we provide the court whether or not there's documentation to support various expenditures throughout the guardianship. You'll hear more about the details of how we go about auditing, but I think it's important to say that all of these documents and the transparency of them being available are what we use to then go and audit whether or not the expenditures are being made to protect the person in need, the protected person. We do this every day. We do find a lot of potential fraud. And again, throughout the state, you'll see little different models, but I can speak to Sarasota specifically. We partner closely with the Sheriff's Department. Once we make a determination that there's enough evidence to support a conversation with law enforcement, it gets sent to law enforcement after, of course, talking with the court, so the court is aware of what's going on. And then the matter is pursued, and in some cases, especially when it's a veteran, then the federal government gets involved in that level of fraud as well. You'll hear more about that from my colleagues, and I'll turn it over to them. And of course, we'll be here for any questions that you might have.
Good afternoon, everyone. I'm Michael Haley. I'm the General Counsel for the Lee County Clerk of the Court, Linda Doggett. And I'm going to start off talking about guardianship advocacy. It is slightly different than guardianship. From a clerk's perspective, it's a more simple process because we don't need to have an examining committee appointed. We don't need to have an adjudication of incapacity. These are open as guardianship cases. In Lee County, we would open incapacity petitions as mental health cases, but we open guardianship advocate cases directly as a GA case. And it is a simpler process from our perspective. So it's designated for people with developmental disabilities. And in those circumstances, there are benefits to the guardianship advocacy. The big benefit is the access to the support coordinator, which is defined in that Florida statute 393.0663. That is a person designated by the Agency for Persons with Disabilities. That support coordinator can help assist in identifying resources for the protected person. And they're a great help. We've seen a lot of benefit from that agency in our guardianship advocate cases. So the next item I want to talk about is the annual accountings and the annual plans. Now, sometimes they're collectively referred to as a report. When you have your accounting and your plan, those are your guardianship report. The failure to file these can result in sanctions, including contempt, up to removal of a guardian. The guardian can file their accounting on either a fiscal or calendar year basis, as long as they're consistent. I know from my office's perspective, we prefer that we just get it every year in the month following the issuance of the letters of guardianship. It just makes it easier from a workload perspective if they come in on a semi-regular basis. Lee County has approximately 1,100 active guardianship cases. We're not nearly the biggest county in the state. So if you just multiply the amount of work we have across the 67 other counties, I think you can get an idea of exactly how many cases we're talking about, how many annual plans, how many annual accountings that have to be reviewed by your clerk's offices in all 67 counties. So the plan is a forward-looking document. That's what you plan to do for the protected person in the upcoming year. And it discusses the current condition, their current needs, and what we're looking for, what the court is looking for, is the physical, the mental, the social health of the protected party. And the annual plan should address all of those aspects. It does require a physician's report, and the report should contain an evaluation so you can evaluate, so the court can evaluate the current level of need of the protected party. The annual accounting is looking back at the previous year. Now, hopefully, when we're performing a review of the plan and the accounting, we can take last year's plan and this year's accounting, we can hold them up next to each other, and we can see that the expenditures made in the accounting line up pretty closely with what was requested the previous year, what was indicated as being necessary in the previous plan. So if your plan can match your next year's accounting pretty closely, you can avoid a lot of potential enhanced scrutiny. Because when we see expenditures that are out of character with what was anticipated, we do some follow-ups, we do look more closely, scrutinize those things more closely. So the accounting has to include a full and correct account of all receipts and disbursements. So, and that is of all the ward's property over which the guardian has control. And sometimes we get into arguments over what exactly does the guardian have control. But if it's property and the guardian has control over it, it is the position of our office that you should account for all the money coming out, all the money going in, and we should be able to see that on the accounting. As we discussed previously, the guardian is required to keep the records for 3 years. So that would be 3 years after the termination of the guardianship. Accountings can be waived, but they can only be waived if the protected person's sole income source is Social Security and the guardian is the representative payee. So in all other cases, we are going to require an account. Lee County has a lot of helpful forms, and I know that's not just us. I know there are other counties that also have forms repositories that can be very helpful to any family guardians who maybe would benefit from just a well-organized form that is laid out so you know what information needs to go in. We have plan forms, inventories, oaths, orders of appointment, orders approving, petitions, physician reports. I put the link there. You can ask me about it later. I'll be more than happy to provide it. But there are forms that are helpful. And from the clerk's perspective, the more organized the information is coming in, the more easily we can process that. So that's why those forms are very helpful from our perspective.
Michael, I'm going to interrupt you because one of the things you said, and it's extremely important, the accounting and auditing is just done for the assets that are contained in the guardianship. And this is oftentimes a frustration to family members when a person has established a trust outside of the guardianship, before the guardianship was formed, while they were competent, and a large portion of the assets are there, and they may think those assets are being mismanaged. Just because a person's a guardianship does not bring those separate entity trust assets into the guardianship or give a responsibility to the court to oversee those. And family members oftentimes are very frustrated.
Go ahead.
Let's hear the unless.
Okay, the unless is if the trustee, if the trustee of the trust is also the guardian.
Manages or administers the trust.
Right. So if the guardian is involved in the management or administration of that trust,
That could be.
then it comes in.
But it gets awfully messy. It's very difficult for family members to understand that it's not a total jurisdiction because assets were set up prior to that time.
The other exception is if the trust is funded with guardianship assets.
That's different. That's not before.
Right.
JD.
Is there some concern that those things are being commingled or used as an out for guardianships?
Yes. Yeah, it's always a concern that it's outside of our purview as clerks. Whatever's in a trust, if that trust was established before the guardianship, if it has a separate trustee, we just don't have oversight of it. But the same concerns exist. Right? And there are ways to challenge the actions of trustees. They just don't involve the clerks of court.
Gotcha.
One of our primary duties is monitoring the timely filing of reports. We use, as was indicated by Clerk Rushing, we use our case management system to set reminders. So that's with the initial report due within 60 days of signing the letters of guardianship. We need to see the initial plan and inventories. If that's not done timely, then you'll get a reminder. They tend to be friendly the first couple of times and then progress from there. The most difficult, I'd say, one of the largest challenges are the annual plans. particularly if a person is not timely with their annual filings, and then those plans start to stack up on each other. And then we're trying to get hearings on multiple years worth of plans or accountings that can get a bit challenging. So that's every year. Failure to timely file, we send out a deficiency notice. We also sometimes send out requests for additional documentation, depending on what was provided in the accounting. And then we have a final guardianship report. If the protected party dies, it is within 45 days of the service of the letters of administration. Otherwise, there isn't a time frame, but I would say that it does benefit the guardian to have that final report filed to limit their liability. It is in their best interest to file a final. Otherwise, we're asking for an annual report that doesn't exist year after year until they finally tell us. And then other things that we review are just court-imposed deadlines, usually to provide documentation in audit cases. So that is the majority of our efforts are organizing, reviewing documentation, making sure it meets the statutory requirements, sending our report to the court for review, and occasionally sending cases for an enhanced audit review in our audit department. And that's all for me.
Before you go, I want to just add one thing, if I can. So I don't know if everyone knows the complexity of the clerk and comptroller. You know, we're the clerk of the court, we're the county recorder, and then we're the comptroller of the county. So we have the responsibility there as internal auditor. Many of us have certified our offices as inspector generals. And so when we say this second audit, that's what we're talking about. We have the probate people working at that initial level of reviewing documents, and then it gets bumped up to certified fraud examiners to start looking at difficult situations, and then that's where these investigations end up. Sorry about that.
So my comments will be brief. So I've sat and listened to an exhaustive overview of the process. Leaves very little left on my plate to kind of go over. So, but just a few things I do think are worth mentioning. We've talked about a review of the documents that are submitted to the clerk's office, and the statutes are clear. That duty falls upon the clerk. 744-368 paragraph 1 says the clerk shall review the initial and the annual guardianship report. So as you have heard from my colleagues here, that from the clerk's office and from different parties who've spoken today, that's a significant undertaking for the clerk's office. It's one that's taken with great level of importance. We have used, I should have smashed the button. Let's go this way. Got it. Let's see here. See how quick I can learn. So again, the statutes are clear. It's a duty upon the clerk's office to audit these initial and annual reports. The statute then gives us some descriptive language. That's what does that report look like? What does that audit or review look like? Again, it says it's a systematic review of the finance and all of those other supporting documents that you've heard so much about, to make sure that they are in compliance with 744-368, the rule of the court, local procedures, using generally accepted accounting practices. So to accomplish this task, many of our offices, certainly in Pasco County, I know in Pinellas County as well, our teammates use standardized auditing reports. The upside of that process is that every document gets the same comprehensive review and they get a consistent level of scrutiny. And then the findings of that analysis is reported to the court in a systematic and a repeatable process. So again, it helps us do what is a gigantic task in a repetitive process. So we use those standardized reports. As has already been referenced, if the reports are not filed, obviously we have to notify the court of that as well. Generally, these reviews or audits are broken down into three categories: level 1, level 2, level 3. The level 1 is what I am most familiar with. It is what we call, sometimes referred to as the desk review. It is the standardized process that we use. We have often referred to this, particularly when I was in Pinellas County, and certainly now that I'm in Pasco County, we called it an open book test. If you wanted to see what the clerk was looking for, you could go online and pull up the checklist, and you could really get a good understanding of what that analysis looks like. So we use the standardized checklist to go through that process. And again, we use, as attorney here referenced and my colleagues have referenced, we really do rely on our case management systems to track these. There are multiple documents, varying time frames, and different review standards. So our case management systems have really been tailored quite a bit and used quite a bit to manage that. In Pasco County, we use Clarifus and we use compliances to track all these documents that are due, to make sure, one, they have been filed, and if they have been filed, to make sure that we are reviewing them timely and getting those findings to the court. I had a few other slides, but those slides have already been cannibalized by my colleagues that have gone before. So no sense in talking order to show cause or order disapproving or order approving. We've gone through all of those things, and it would be duplicative for me to talk about those next. So I'm going to punt this to my colleague.
Question.
Look,
Just quickly, and we mentioned it before, but have you found difficulty with the fact that what we audit is what's given to us? And then subsequently, other assets pop up or haven't been originally reported, or a family member comes in and says, whoa, what about that house? What happened to the cars? What happened? We're experiencing that, and I just wanted a general consensus. We talked a little bit about it before, but in those initial audits, what's your comfort level that you're getting what's really there?
Well, again, we have to take it on face value. I think there's a general assumption that you probably don't have it all. But again, we evaluate what's in the document to kind of set a good baseline to start. I'm sure some of my colleagues would agree. There's going to always be, an asset discovered later, an account that's discovered later. So I think it's par for the course in the field that we work in. I'm not even sure how you solve that problem if you don't do an upfront investigation, have multiple parties go out and do the marshaling of the assets. Maybe that's a solution, but then that becomes a bit restricted. How do you have multiple people all go out and do this analysis? So I think it happens. I don't know the scope of it, but as you discover assets, there are ways to account for them and make sure they're
And I think you're going to see that when you hear the next presenter on the audits that are really enhanced audits. Because when we get an allegation that there are other assets, believe it or not, we leave the office and go there. So we'll hear more about that.
I was just gonna make a suggestion, and this might be something that we talk about later, but I know for me, when I get a Guardian and we don't know what the assets are, we run a credit report. And a credit report can be very instructive on the alleged incapacitated person to tell us about assets that we otherwise might not have known about. And so I'm not suggesting that the clerk's office should take on the job of running credit reports on wards, but it has become for me an effective tool to locate assets that otherwise were not locatable. And it may be another tool for investigation purposes.
I think you bring up a very good point, and it's an expanding field. I mean, how do you track digital assets? I just think the world is getting so complicated. And we're going to probably do some analysis to figure out how we shore that up. But to your original question, I think it's probably, par for the course. And as we discover new assets, there are ways to make sure they're tracked going forward. But I think that's why
I love investigative tools, but I'm going to depart from there. I just wanted to clarify your definition of auditing was spot on, 744-102 subsection 2, but there's a second sentence to that. And this sentence is very important to what we do throughout the state, what the clerks do throughout the state. And this was a statutory change that Kathleen Passidomo enacted in 2014. And it says that the audit The term includes various practices that meet professional standards such as verifications, reviews of substantiating paperwork, accounts, interviews, inspections, and investigations. So that second part of that definition is particularly important. So I just wanted to make that clarification.
How are you?
I am well. How are you?
Quite well as well. You know, the report that Mr. Diamond did in Orange County was quite glaring, to put it mildly. What, and I'm not talking about the clerks that are in front of me and this nice gentleman, what experience do the clerks that are going over documents, or not clerks, employees, what kind of training do they have?
Well, as we were talking about the two levels, so certainly those that are verifying that the document that's required by law to be filed is filed. They're trained on what the document is, and they know how to count, and they are doing that level. As I mentioned on the enhanced, I mean, all of the clerks that have inspector generals in their office, they're all certified fraud examiners. So they're typically graduates of either an accounting background, CPA, or auditor, and then on top of that, certified as fraud examiners.
Thank you.
I think I am complete.
We want to make room for
I think what Hillary touches on is maybe a very important issue, something that the Statewide Investigative Alliance has been looking at. Typically when we hire into our Inspector General group, we're looking for what Clerk Russian said, someone with that combination of professional certification experience on the auditing and the investigative side. They're unicorns. They're very hard to get that real good round off, that good combination. I would suggest that the task force look at some type of certification for guardianship investigators. The Alliance has toyed around with putting on education and a certification for not just clerks, but court staff and others throughout the state that do this work, do this monitoring work, certified guardianship investigators. I wouldn't mind putting that on our list to talk
I would second
additionally.
if it's subject to a second.
All right, thank you. Great questions. It is 3:15 in the afternoon and you are very attentive and still asking excellent questions. But I'm Stacy Butterfield, clerk and comptroller in Polk County. And I'm going to focus on a few of these slides. There are others in here, and each of the previous presenters, as well as based on all of your questions, you're very aware of some of the concepts that are in these slides. But before I get started, I did want to recognize two other individuals that are here from the clerk's office, actually, that are from just that, our Inspector General office or either internal audit. And that's Lita McHugh, who is the inspector. Lita, raise your hand, and she is the Inspector General in Polk. And Dan Ravello is the Director of Internal Audit for the Charlotte County Clerk, Roger Eaton. So they were instrumental in putting some of this information together, as well as in those enhanced audits that we're talking about. So I will skip through many of these because we've talked about the initial and annual reports, the statutory timeframes, the process, but I want to focus on guardianship best practices. When we started the meeting today, you heard about the 68 clerks and comptrollers. Of course, there are 67 counties in the state of Florida. The 68 is our Orange County comptroller that you just mentioned. But among all of us, as an association, we have collectively worked as a collective body to develop best practices for our guardianship audits, as well as other areas of our duties and responsibilities. But we're focusing on guardianships today. So as you have heard, I think both of my colleagues here spoke about the best practices or the checklist. As a matter of fact, I think, Jerome, you mentioned they're out there. It's an open book test. You can go look at the checklist, but we have not only have we developed these, but we've recently instituted a program where clerks are recognized for those that are following those best practices. And the best practices are simply a comprehensive audit guide, including both basic and enhanced audit principles that we use. Some of the examples in the best practices, you can see the list here, I won't go over it, but some of the things that may put up red flags for us as we are doing the best practices in just what we will call our general category, as Clerk Rushing mentioned, our staff, you were asking about qualifications that are looking, was it filed? Did it have this item in it? Yes, no type answers. But if there's other things in either a plan or likely in the annual accounting that are red flags, it would move it up the totem pole, so to speak, to an enhanced level of audits. I think one of these gentlemen used in levels 1, 2, and 3. So for example, what would be a red flag? Well, let's say that there are monthly payments to a facility. Well, that means there should be 12 of them, right? If there's not 12, if there's more than 12, and if they're a monthly payment to a facility, they're probably of a consistent amount or should be. So one of the red flags might be, oh, a great spike or, peaks and valleys in those numbers. That would be a red flag that might move it up to an enhanced level. That's just one example. So the effort of the clerks as a collective body is to, with the best practices, is to ensure that consistency county to county with the work we do on the audits. Let's talk about the enhanced audits, because again, that seems to be a little bit of our focus. For those red flags or those things that we find that move it up to a higher level, we use a risk-based approach for what we are looking, those things that indicate risk. And of course, we have to use judgment. Those original documents, I think Michael referred to, if the plan and the accounting, annual accounting are consistent, as you move through the guardianship years, so to speak, that makes it less of a risk base, so to speak. But if you see a lot of inconsistencies, last year's ending balance doesn't agree with this year's beginning balance, or if you see things that might appear to just be, I guess I would use the word sloppiness in the way it's reported, that in itself might be an indication of another problem, potentially. So as Clerk Rushing mentioned, as things do occur, whether it's either in the audit or possibly in a minute when I talk about the investigations, we have our staff, they leave their office, they go out, they visit the person, they visit the property, they're looking for evidence. As an auditor, I'm a CPA trained in auditing, and one of the things is physical inspection of something is a higher degree of reliability and accuracy than just looking at a copy, looking at something in a document. So we have gone out, and we do in all of our offices. I'm sure everyone will be shaking their head, and I know the two in the back because they're two of the ones that have been out to make the visits. We look for things like, was there this particular item, this asset? We looked at, in one case, we were looking for a pony in a particular case, a therapy pony. So, I mean, it gets to those types of levels of what it is we're looking for. We may have third-party subpoenas that, of course, through the courts if needed. And we certainly are looking to analyze the financial transactions for excessive spending, those types of things. Let's move on to the statewide investigative alliance that Anthony has referred to.
Before you do that, Stacy, I think it needs to be pointed out to go back to that former slide. These audits, you may ask, who is our audience? Our audience is the judiciary. We can't do anything here other than bring it to the attention of the judge and magistrate. Look, there's a problem. Alert, danger, Will Robinson, you need to do something, judge and magistrate. But I'm serious on that because people think because the clerk often in our comptroller role, when we're producing audits, they're out there in the public, and it's the public pressure that puts it on the county commission or a county government to effectuate some change. Here, it's a little bit different process, and and so our audience, again, we're doing these audits with the intention of grabbing the attention of the judge and magistrate for some type of action. There are at times where with the enhanced audits, especially if they're giving us the authority with the subpoenas and so forth, where there's a confidentiality into that to keep this and they make the determination whether it's made public or not. So, and that may need to be looked at, and it may not been intentional on the part of the judiciary, but those are some things which I know has caused frustration in the community when they know we're auditing something and we're not able to release a report on it.
Thank you. All right, let's talk about the Statewide Investigative Alliance. There are currently 6 clerks that are a part of the Investigative Alliance: Polk, Pinellas, Palm Beach, Lee, Okaloosa, and Sarasota County. And we are recruiting for others, let's put it that way. The question might be why these particular clerks' offices, and that's because they have the experience and expertise in guardianship audits, in auditing and investigative work, and certified fraud examining, and they have the statutory authority, of course, to report to the court, and as Clerk Burke just mentioned. The requirements to be part of the alliance are that the office be a chartered office of Inspector General, seek accreditation, and perform enhanced guardianship audits. The accreditation is an important factor. The accreditation is through the, Anthony, I never say it right, the Commission for Florida
Law Enforcement.
Thank you very much. It's a mouthful for me and I never get it right. But the accreditation program requires both an initial accreditation and reaccreditation every 3 years if you want to participate in the program. And it basically has long been recognized as a means of maintaining the highest standards of professionalism. And it's done through an independent review of the commission. They come in, they look at our records, sample records, they interview our staff. I think there's 46 different standards which we have to adhere to. So it is a pretty rigorous process. The Statewide Investigative Alliance was established in 2016, and we have a memorandum of understanding with the Department of Elder Affairs, and it arose out of an increase in complaints that were being received by the Department of Elder Affairs. And we investigate complaints against the professional guardians. And since its inception, those bullets are related to how many investigations have been completed, the allegations, and all of the information there is since the inception. And I will tell you that we investigate everything. We have hotlines where people can call and they can make their allegation. They can contact us through email. They can write us. We all have various methods that they can contact us, and then we will begin our investigation, and then we report on that investigation.
And Clerk Butterfield, I'm going to interrupt you again and Anthony, correct me, but on this, now these are not under our judicial role. These are outside of the judicial role, when we get these types of investigations. And those reports, once finalized, are made public. Is that correct, Anthony?
They are, just for clarification. So when someone lodges a complaint to the Office of Public and Professional Guardians, the OPPG determines whether it is legally sufficient to investigate. And at that point, it comes to our office for investigation. Once we're completed with the investigation, the investigative report is forwarded, issued to the OPPG for additional actions. So as soon as that investigative report is issued, my understanding it becomes a public record subject to redactions. Or, there's a bunch of confidentiality statutes, and those reports can be obtained through the Office of Public and Professional Guardians.
Thank you. And the 6 counties that clerks that are part of the alliance handle the whole state of Florida, and those investigations are distributed. Anthony gets the honor of distributing those to the very 6 offices.
Ms. Brennan.
I just wanted to clarify, what is the time frame that these numbers represent? Is it since 2016?
Yes.
Okay,
it's the
thank you.
inception.
Yeah, the memorandum of understanding was from 2016, but as you know, the rulemaking process for the OPPG wasn't legislatively codified until June 2017. So I always say 2017, but technically, yeah,
Okay.
yes.
Thank you.
And those are maybe a little bit old. I think we're well over $8 million now.
Shannon?
I just, so it's clerks, but it's not under the auspices of the clerk's office. I'm just trying to understand, like, it looks like the investigative process emanates from OPPG, but it's mostly clerks that are doing the investigation.
They're Inspector General's offices, which are not part of, as Karen mentioned, we wear different hats. We're the county recorder, county comptroller. The Inspector General office is not part of our court operations.
Okay. And then does the,
So Shannon,
Yeah.
Statutorily, the OPPG has the statutory responsibility to investigate. There's lots of statute that encourage intergovernmental entities to share resources, and the OPPG sought out the clerks because of our expertise and our experiences and the other stuff that Clerk Butterfield was talking about.
but are reports going back to judges? So reports are,
No.
some people shaking their heads, yes.
So if there's an issue that's appropriate, we will bridge that to usually the chief judge for the circuit. So we're not filing, if your question is, are we filing these into proceedings? We are not as of yet.
But it's going to a judge that might be sitting on a case where the players.
No, we don't do that. Yeah.
Okay,
Yeah.
I'm just trying to understand, like, this investigation takes place and then it goes to the chief judge who may have a guardian who is suspected of wrongdoing, right?
I want to just add a little clarity. So if I've been assigned to a case, it might not even be a Sarasota. It could be further down the road from me, and I'm looking at that independently. But if we're acting in our circuit on a case that we have, there's communication with the court. I mean, we're working with the court. They have been very appreciative of the fact that we have skills beyond the deputy clerk who's doing that desk audit that we referred to. Because when you move it into the internal audit and those that are certified to be fraud examiners, we worked one where, invoice, and we noticed, this address is different. Well, all the repairs for the protected person were being done on the non-protected person's house. And we noticed that through documentation, through a deeper audit, not just this number matches that number.
Okay.
JD.
So from our perspective, because we're one of the participating offices, where there's a finding where we're investigating a case on behalf of professional guarding on behalf of the department, and our team feels like there is an urgent concern for the ward's benefit, we will contact the court, not the chief judge, the actual court that's handling the oversight case, because it's our thought that OPPG's role is control over the licensed sort of professional guardian, whereas ultimately we're looking after the ward. And so it's been our practice to communicate with the court should there be something that we feel like is an urgent need to know by the court.
But is it done like through the portal so that everybody gets notice of that, or is it done like in an ex parte fashion?
We have a mechanism in place to notify the presiding judge, and that memo is docketed into the case.
So it's available to all
Available
parties.
for all, correct.
That's
I'm sorry, go ahead, Hillary.
Just very simple question for this slide. So basically $8 million, there's $8 million deficiencies and numerous arrests. How many people were arrested? Were they professional for-profit guardians? And who are they? And where does it stand with the criminal charges?
I could just speak to a recent one. It's a family member and it involved a veteran. And so it made its way. First, we notified the court. We had involved law enforcement. It was filed by the state attorney. Now although it has not been dismissed, we have some indication it might be because the federal government is going after the benefits. And so you typically don't have both courts, dealing with the same issue. So the ones that I find the most challenging end up being family members, because there's a lot of anecdotal information that you really have to go dig deep to see if it's the allegation has a way to be substantiated, because we can't just take what one person says over another person without some substantiation. We can't bring that to the court. That's our role for the court, because the court's sitting there making a decision and we're trying to get evidence for the court.
Right. And I guess in what I do, shouldn't there be some sort of document where the public can see who's been arrested?
If they're arrested, it's a public document.
Where could Anthony, could you possibly give me a document specifically with for-profit guardians that are?
I'm pretty sure most of my public presentations has all their mugshots on them, so I'll send it to you.
That would be great. Thank you.
Absolutely, yeah. And just a little clarification, most important part for an inspector general is to be factual and accurate and give you the information that you need to make your own determination. But fiscal deficiencies also include errors. It's anything that's wrong with the thing. So we're not saying $7.9 million in fraud or criminal behavior. We're just everything that we've identified goes in there. And I should also note that these six offices, same six offices have collectively also identified about $40 million in fiscal deficiencies for all the proceedings in their counties. That mostly is family guardians. So, and that makes sense, right? Because out of we estimate that 75% of the proceedings in the state are family guardians, and only a smaller subset are professional guardians. So,
thank you.
But those statistics are just for the statewide professional guardians on behalf of the OPPG.
Anthony, I think statewide, not OPPG, but statewide, we estimate there's about 60,000 guardianship cases active.
Well, we don't know the exact number, but I would say,
Yes, that is.
and
We're not positive of that number because of not a statewide database.
And don't forget, we ebb and flow, and most of our persons under guardianship are at end stages of life. So we have a considerable amount of people that pass away and end the guardianship, and then we have a new cases being, but anywhere between, I would estimate, anywhere between 40 and 70,000. That's a big range, but I'm being safe.
Let's thank our clerk panel for their presentation here. Beth, if you would take your seat, we're going to get started with our public comment, and we have some helpful signs to stay within your time limit. And the first person we invite to come to the microphone right there is Craig Schaefer. And following Craig Schaefer will be Marcia Friedman. Craig, Mr. Schaefer. Helpful. Please. Hold on, sir.
Need a
You
mic.
can't hear him. Is there any way to increase the sound on that microphone for us in the room?
Is it even turned on?
Closer.
Can
you hear me? Yes, better.
Okay, and speak up, sir. Mr. Schaefer, you're recognized if you start your time again.
Florida guardianship is broken by choice. Corruption runs rampant and agencies, including law enforcement, work simultaneously to make sure guardians and facilities are protected and wards and their families have no recourse. Low-income people have no options. Legal aid and the Florida bar offer no assistance programs. No attorney will take up a case even when bodily injury occurs. The guardian is the only person allowed to seek restitution for a ward, and there's no option for the judge when the judge fails to appoint another guardian. My mother has been trapped in guardianship for 4 years. She has not had proper representation due to the inability of herself and family to pay for justice, leading to physical and emotional harm, medical neglect, loss of visitation rights, and threats of loss of housing. After being warned not to make any more complaints, early this year, I was given a restricted contact order. Even when making reports in good faith, I was supposed to be immune from retaliation. Being an easy target to blame, I was falsely accused of jeopardizing my mother's housing over submitting complaints for things I would have been arrested for. She has been slapped, missing dentures and hearing aids, lack of medical care, ongoing infections, uncut toenails, making it difficult for her to walk. My request for a walker ignored, and recently my 82-year-old mother fell and broke her hip. Her room has had ant infestations, cockroaches, no fitted sheet, bed bugs, and her laundry and hygiene were neglected. My mother's disabilities are always blamed, but by the guardian versus her lack of oversight. Even when I have photo documentation, these issues are investigated, yet the guardian is not held accountable. Sarasota's sheriff won't take a report about the guardian, but routinely investigates for her. Adjudication withheld should matter for families having restored power of attorney. The state is too eager to place our loved ones into guardianship instead of helping families through difficult times and leave us with no pathway to restoration. There is no real oversight or protection for wards in Florida. My mother was forced to buy a new mattress over a facility bedbug issue. The guardian made her buy a $1,200 cremation box that claims she doesn't have the money for other things. Last year, I reported an eye infection in a court monitor and was put in place as well as an attorney. No one did anything to protect my mother, and several months later, she had to have her left eye removed. Now a new judge has taken over, allowing the attorney to withdraw, resulting in physical harm and emotional abuse, while ACAP won't hold him or the guardian's attorney accountable. Judicial Qualifications Committee has failed to hold the judge. Mandatory visitation and reporting goes ignored in Florida, and families instead blamed and threatened with no contact orders if we don't comply by keeping our mouths shut about what we see. Sarasota Controller involved in my mother's case, notifying nothing was done. Ann Writings is my mother's professional attorney known for neglect, a guardian known for neglect and abuse. My mother, Mary Spar, Manatee County resident, or case resident of Sarasota.
Thank you, Mr. Schaefer. Marsha Friedman, and then Mitzi Baroda. Ms. Friedman.
Thank you. Oh, I'm tall enough. First of all, I wanted to thank you.
Ms. Friedman, if you get real close to the microphone, matter of fact, you could hold it if you wish.
Okay. Is this good?
Yeah, that's better.
Okay. Thank you. First of all, I wanted to thank you for the opportunity to express my suggestions based on my experience to help find solutions, guidelines, education to improve the guardianship process. Sadly, my reality. My name is Marcia Martinez Friedman. I'm a victim and elder advocate and a co-host radio show for Faces for the past 5 years. My mother's name is Lilia Martinez, vulnerable elder, minority, Cuban, language barrier. My mom was displaying, she was suffering from Alzheimer's and dementia. When I seek guardianship under the direction of Alzheimer's Association, when I was seeking for answers. In June 2011, to protect my mom, Mom had always chosen to live near me, her only daughter, and her other grandchildren and great-grandchildren prior to guardianship. And as my rights as her daughter and next of kin and caretaker, I sadly went for guardianship. I suggest a list of qualified supervisors to be provided by the courts. Presently, there are none in place. So when a judge orders supervision during visits, this way visits can continue to happen immediately on a timely basis without interruption or delays, till all other prolonged timely logistics involved get resolved. Recently, I was able to visit Mom only because she was hospitalized for 8 days. This past June, without any problems. I went to court to have the visits resolved, which has been going for decades and years. And we are still waiting for the visitation to get resolved. Causing suffering, mother is 66 years old. I could get a call tomorrow or any day that she's no longer with us. It is true, my niece and nephew and I don't get along, but this has nothing to do with my mother and I. Family dysfunction should never interfere, used as a tactical weapon to prevent ward from visits. My mother has expressed to the bench multiple times her wishes for our continuous visits, and we visited for 8 days.
Thank you, Ms. Friedman.
Thank you.
Mitzi Baroda is next. And Linda DeWitt follows her.
My family's fraudulent guardianship has been going on for almost 6 years. Just one day after my husband's tragic car accident and death, my lawyer, personal and business, turned against me and my teenage children. Unknown to us, he opened guardianship for our business, property, and estate, and his name is the deceased. We were served on Christmas Eve. Shocking, coming from a supposed friend and business colleague. So much emotional grievance and emotional damage was created, scaring my children and depriving them of any kind of humanity, empathy, or closure. It was replaced with legal battles and trying to isolate them from their only living parent, their mother. After 2 probate courts where a judge abused my children, told them their father maybe he didn't want to take care of them. 6 weeks after his death, I hired the past president of the Bar Association, Gwen Young. You know who's the trustee and guardianship of my children? Andrew Sasso. You know who the CEO of Carlton Fields is? Gary Sasso. Guess who his assistant is? None other than Darby Jones, fiduciary, another lawyer. Shame on all of you. You all know about it. Every single one of you sitting here knows about it. I have contacted each and every one of you, every senator, every congressman from this state across the United States to protect my children. What are you going to do for my children? What are you going to do for me? Do you not see that I can't function anymore? These son of a bitches have put debt against my home that was paid for. Paid for. I contacted Attorney General. She said to go ahead and turn it into Consumer Financial Protection Bureau. Well, I did that. They added another $100,000 worth of debt to my home in 1 month. Last thing, how many lawyers or judges in this room know Marty J. Foster, Leon County, and Monica Leon, and doing business as the Christina Trust through the Wilmington Trust in Delaware, where our money is laundered and stolen? I want my money back. I want my name back. I want my children saved. You're criminals.
Thank you, Mrs. Baroda. Linda DeWitt, and following Linda DeWitt is Lynn Saylor.
My name is Linda DeWitt from Pinellas County and Polk County, my family. Friend of Mitzi, as you see, it's been a tough 6 years for her. This is one of the most unique and damaging issues to be reconciled in our state. All shared testimonies in this gathering and of my colleagues clearly reveal that the system of the law that we formed to protect us is broken and has failed. There's fraud and lack of monitoring and guardianship by lawyers or families and loved ones that we care for, taking advantage of the lax laws and loopholes, destroying lives, and hardworking individuals are sick and elderly, as well as the survivors of the deceased. These people have no known list of where to go or who to talk to without hiring a lawyer or an investigator if needed to gain information. First, checking social workers, ombudsmen are very few in between with the state employment, especially with the COVID era. DCF monitors child issues, that's well known, and our seniors and sick family members only have a fraction of this attention. We all have known that it takes a lot, practically an act of God, to rewrite and change these loopholes in the law and through proper channels. Coming in today, I rewrote my whole statement, noting that there was no much publicizing here, even for this meeting, especially for those with no access to internet to find resources that they needed. For example, each of this panel, in my opinion, should have had a pile of business cards or brochures or something for those who have no access to the internet, for those low income that aren't able to do that, and the elderly that aren't used to internet and computers, or they'd have the youngsters have to do it for them, and that's not really possible. A list of government agencies used to be posted in front of our non-existent our phone books, for access, and have all the government lists and what have you. Maybe our tax dollars could be put to good use with a yearly flyer or a brochure so that they could have that posted right back on their refrigerators again, and people would know who to contact. There's a whole panel here that a lot of people just don't know anything about. So when can all this happen? It takes a while. How long do we have before more of our wards and prospective wards are emotionally and financially destroyed? When will we actually see a change? Is it futile? Are any of our leaders that we trusted and we voted in, are they willing to stand up and really make notations and really fight with our legislator for us in this nightmare? The road is treacherous. As we grow old and insecure and everything we hold dear and work for our lives, children will be taken through fraud and lack of supervision. Until it happens to you. Thank you.
Thank you, Mr. Witt.
Ms. Saylor?
And following Lynn Saylor is Alan Saylor.
Sailor.
Lynn.
Can't hear me. I have served as a guardian ad litem. I have served as an ombudsman, and I have served as a pro bono court-appointed guardian. And I have watched this process since 2004, 2005. The process has had complaints from the beginning. It has had money poured into it, legislation changed. It's had everything possible to make it better, and none of it has changed it. Maybe has made it worse. I'm thinking that in guardianship is truly, at the end, it's a mental health issue, and maybe it doesn't belong in the expensive judicial system at all. I don't know what the answer is, but I know with more guardian attorneys stepping up and being guardians themselves, because what we heard from one of them is the money's not too bad, it's pretty good. So with all these attorneys that want to be guardians now, the attorneys in Florida want full control of all the guardianship laws and our courts. And there are courts, the people's courts. They're not the attorneys' courts. They're not the clerk's courts. They're our courts, and they're for us.
Thank you, Ms. Saylor. Alan Saylor, and followed Karen Kirk.
Good afternoon. My name is Alan Saylor. I'm a businessman here in Pinellas County. My business has nothing to do with guardians or guardian attorneys. I have no financial interest in any guardianship case. However, I do have 15 plus years observing a number of professional guardianship cases. And I don't have the experience that Attorney Ropo has, but I have seen the dark side. And sometimes it resembles human trafficking. I would like to thank you for recognizing the extreme need for significant improvement in Florida's guardianship system. Now, one of the big problems, or the main problem, is the amount of money that's in guardianship. Mr. Palmieri, what's the value of a property in Palm Beach County under guardianship?
We're really not engaging the task.
Oh, I'm sorry, that's fine. But I think we'll find that there's billions and billions of dollars involved. The guardianship industry is a multi-million-dollar industry, but no one knows for sure because we don't see those numbers. So money is a big problem, and how that's tackled and not seen. Also, judges don't provide the oversight that's expected of them. I heard a judge say in court, and I read in the transcript, I'm not going to second guess the guardian. And of course, the Attorney Ropo mentioned, he says the courts are a little too trusting of guardians. Judges don't seem to recognize the red flags from guardians or press them for answers. Problems like changing the ward's long-term guardian, long-term doctors. That's a real issue, and it's a red flag, and they should be questioned. Limiting, stopping family visitation without any documentation or any testimony. That's a real red flag. They need to be pressed on. Inability to locate family members or pre-need directives for wards. We talked about attorneys ad litem. I spoke to attorney ad litem one time and I asked him what his job was. He says, whatever the judge tells me to do. I said, well, who's looking out for the ward? He just looked at me and didn't say anything. I took his look to say that I didn't understand the system. So as you all finish this, and I hope you come up with some really good solid things, I hope you'll consider including these 4 things. 1, an advocate for the ward with no financial interest in the outcome. Court-appointed attorneys get paid. We need something like the minors are guaranteed a guardian ad litem. Require special education for probate judges, transparency, how much are these guardians and attorneys getting paid, and limit the number of wards guardians can have. Thank you for your time.
Thank you, Mr. Saylor. Ms. Turk, and then following Ms. Turk is Rick Black.
You know, I came here hoping that I would want to rewrite what I wrote last night, but after coming here, I feel like everything that I watched today, driving 3.5 hours over here, really shows me really clearly that there's not going to be a whole lot of change. And I would like to be an optimist here, I really would, but we have a really broken system that needs immediate attention. And the oversight of a group of lawyers and judges are probably not going to be the people to do it. But I hope that I will be proved wrong. You know, I really think that this entire community has become one of friendship and political connections. It's become one community alongside the Florida bar. And at the end of the day, it's about who you know and how they're connected. The Florida bar has good lawyers. I'm married to one. But right now, the Florida bar has 100,000 members and 70,000 of them are practicing. Some are judges, some are government employees, and it's a competitive environment where an average salary is just over about $100,000. What do lawyers need to do to get ahead from the pack? They litigate. The good ones litigate, and they get involved in litigation, and they become very, very profitable through the opportunity here in our probate court system. This has been going on for way too long, and there's legal gators in this swamp that are feeding off the vulnerable, and it's happening every single day. And people want to sweep this under the rug, and they want to protect their friends in the Florida bar, and it's about time that that changed. It's a really murky judicial environment, and I know this firsthand because my mother suffered at the hands of this system. She was actually put into referral for guardianship by a nursing home while she was being neglected. My mother died with stage 4 bed sores eating away her flesh, and I got to sit back and witness that. Anthony, you may remember that I pled to you to help me with my mother. And maybe you really wanted to listen, but you couldn't because you couldn't communicate with anybody except for that guardian. That's a problem with this system. A guardian that insisted that I communicate only through a law office that represented both the nursing home who was neglecting my mother and the professional guardian. How this is not a conflict is unreal, and there's so many conflicts that we've heard today. You know, it defies logic, and time again, there has been nobody who's handled this issue. The lawyer who was in the opposing counsel as I was settling the unlawful death suit made a request of me, and I thought this was a very interesting request. He requested that I not discuss corruption in the Palm Beach County court system or the case that his law firm had that made headlines when it resulted in a $16.4 million judgment for a family done wrong in guardianship. As you can see, this lawyer did not suppress my First Amendment rights, and I'm here today. But isn't it interesting that these things can't be discussed? Thank you.
Thank you, Ms. Burke.
Rick Black, and then followed by Rick Black is Douglas Franks.
Thanks, Ken, for your leadership in pulling this task force together and for everyone's participation today. What we're talking about here is exceptions. You have a good process. It should protect the vulnerable. However, we've seen hundreds and hundreds of times in the state of Florida, it does not. Now I lost my notes. My name's Rick Black. I'm the director of SEER. We're a 501c3 and we advocate for seniors and intellectually impaired adults targeted by the predatory legal community in POA, trust, and adult guardianship frauds. We've counseled and researched nearly 4,000 cases nationwide since we began our efforts in 2014. They generally follow a profile, isolate the victim, defame legitimate protectors, and liquidate the estate. Over 90% of the families who contact SEER, when we look at the records, they had legitimate advance directives in place that should have precluded the guardianship. Guardianship has a place, and SEER fully supports them when statutorily adjudicated with a bias to protect the proposed ward and their estate. Guardianship should also be avoided, as it is very risky and expensive to the ward and their loved ones. Every party paid from the estate of the ward works for the ward. Once under guardianship, and the ward is left powerless and often voiceless as their estate is drained. The initial order is a draconian action and too often yields inhumane treatment of the ward. Florida's guardianship system is broken, but statutes aren't the issue. The issue is that too often statutory obligations are ignored by the jurists and the attorneys. Testimony is not taken, material evidence is not considered, records are sealed, and the ward is denied the opportunity to speak or have independent counsel. Probate litigators lie, often engaging in a liar's choir, knowing they benefit financially by it. Why does this happen? Because the system financially rewards all court-appointed parties to create guardianships, and the system has little oversight. The equity court system, probate in Florida, is unwilling to prosecute its worst offenders, the litigators. In a lack of oversight and money for the taking, the criminal element flourishes. Estate trafficking, Medicaid, and medical facility risk mitigation are the main frauds. Litigators know almost anything goes in guardianship proceedings. The appeal process seldom yields redress. No probate jurist has ever been reprimanded by the Florida Judicial
Qualifications Commission for poor judgment on the bench. The Florida State Bar has not reprimanded or disbarred a single attorney for lying or manipulating a probate court proceeding to exploit a client as long as a judge approved it. SEER proposes a carrot and stick. Each proposed ward proposed, not after the order is signed, should have free counsel. That should be provided by the federal government or the state so that these individuals are protected before their rights are removed. And there should be an adoption of a one strike you're out. When a litigator lies to benefit financially at the expense of a vulnerable adult, they should be disbarred and immediately all funds from the estate returned. Thank you for your efforts. You have a big job ahead of you.
Thank you, Mr. Black. Mr. Franks, and then Susan Melendi.
Hello, my name is Doug Franks, and I think Rick just kind of described who the stakeholders really are. I drove down from North Georgia today. This is about for my 3-minute speech. This has been going on for about 16 years. I've been in it for about 11 years since my mom, Ernestine Franks, got put into guardianship. Because of the advocates and because of the hell raising we've been doing, Adam Walser, Mike Vasalinda, and other newspapers have taken up these stories. That is the only reason, let me repeat it, that is the only reason why we are here today. Because the public has heard about this. Now everyone here is stakeholders, and the profit had to come and had to be accountable. How much accountable? Who knows? It may be something where we just simply go through the motions and, hey, we had meetings, we decided some stuff, but nothing really changed. My mother had advanced the directives. She testified in court. She was in court. She had a neurologist give her an examination for 4 hours on Wednesday. Monday, first court, Friday, last court date. Wednesday, neurologist examined her, gave us the document, the report, and it said Ms. Franks had sound mind, in his opinion, and she knew who her guardian was and knew the ramifications. Judge Jan Shackelford ignored it. At the end of the court, she also ignored the healthcare surrogate. She goes, what should we do about this to the lawyers? And the lawyer said, well, we should just get rid of that too. That shouldn't have happened. Judge Jan Shackelford should not be a judge in Escambia County anymore. For what just that one thing, that one strike, she should be out for life. But she's supposed to be for a federal judgeship. The examining committee, this is a big deal. I have videotape of the 3 people that interviewed my mom, and I want to give it to all y'all. I'm going to make it public so all y'all can have access to it, and also the federal government and the new FREE Act will also have access to these videotapes that show what happened and then the lies that were put in the reports given to the judge. So all times that people get assessed, that must be videotaped. That's part of what this new rules need to be. We videotape this and we see if these people are incapacitated. We don't take the word of, again, a committee that could just be in it for making money. All right, so anyway, I'm gonna go through this. All cases must be come to the part where there cannot be any assisted decision-making. There has to be and that's not the right term, but the ability for the person to make decisions on their own. You have to make sure that they can't do that. A complete physical has to be given so that these people don't have UTIs, because any of y'all that have UTI get examined, you are incompetent. You are an Alzheimer's patient. Statewide standards for all counties to follow. POA and healthcare surrogate should not be removed. Statewide scales for how much guardians get paid. My mother's guardian, he only got paid $285. He was an accountant. He deserved more. He's another person that's going to have some interesting things happen to him legally. Guardians must have jury trials. If we have a jury trial in a guardianship case, then we're going to remove all these problems. The records cannot be sealed. All professional guardians must be licensed. They need to have some type of degree that's equivalent to an accountant.
Mr. Frank, if you could wrap it up, please.
Well, that's about it. The only other 2 things are you need to have an ombudsman And I would recommend Michael Phillips, if he's still involved with this, he needs to be on this committee, and also ACA. ACA, I called them, I said, hey, these people have an unlicensed caregiver. They went out and they found out they did, and they charged them $1,000. But the firm had only made about $200,000, and they had to pay a $1,000 fine. No, that's no good. That needs to be changed. All right, that's about it. Thank you for your time.
Sue Melende. Sue. And Steve Hitchcock is next after Stephen Hitchcock.
Thank you, Ken. I appreciate the invitation, and thank you for the panel members for taking the time out of your normal lives to hopefully make change in this area. Unlike some people that have been associated with this is relatively new to me. I've learned the good, the bad, the ugly in a very short period of time. I'm a real estate broker by trade. I own my own firm in Pinellas County, but I've also started a 501c with some people in this room, effective May 1st, to try to foster change, to try to find reform. We were very active in writing the FREE Act that a lot of you know about. We worked on that with Charlie Chris' office. It's also supported as a bipartisan bill with Nancy Mace. And, we've had a lot of good bills. We've had a lot of good legislature passed. We've had a lot of things that we're very concerned about as far as July 1st, that there'll be less transparency, and that's not the direction that we want to go. There's no reason to hide anything that should be visible. And it's not about HIPAA, and it's not about people's personal privacy. The ward or the potential incapacitated person can make that decision. I suggest that there be an affidavit that the person signed the very first day that they're contacted by DCF or a complaint is made to a bank or to a neighbor, that they understand at that point what the 12 rights are that they have at risk. Do they need ADA accommodations? One of the things that we've talked about today, do you have advanced directives? Do you have a family member that you want to have advocate for you? All those things should be explained on one piece of paper to that person at that day, and that guardian advocate stays with that person through the entire process, so that those hearings are not closed when they request that they be open, that they do have a voice, that the judge actually asks them, what do you want to have happen? What are your goals? My mother passed away November 9th, 2019. She was blind and was in a nursing home for 5 years. My parents lived with me for many periods of time when they'd get out of the hospital and would need home health care. It got to the point that was beyond what was my mother's needs and to keep her safe. And my father and I helped my mother for the 5 years of that time. I hired a staff of 4 people, and I was there with my mom almost every day. I take care of my father, and I take care of my mother's 90-year-old sister. I was the person that was tasked as being a potential exploiter. I'm a potential isolator. There's always a family member that lives out of state that has no direct involvement with the care of these people. My parents' attorney was Mary McManus Taylor, and she referred them to David Ellis, who is now a judge. But yet their advanced directives did not stand up in court. Their wishes do not stand up in court. We should be the poster child for what you do to prevent this from happening. And yet my father was still stripped of his DPOA just because I have a nasty brother that lied and had lawyers that would lie. And then still my father's rights weren't restored. And we're going to challenge that. And one last thing, I've taken to the second DCA the language, and I appreciate, Judge, you saying that the person does have the right to substitute their counsel, but we pay and we waste money fighting in the second DCA for language that's so fundamental and so basic because the judges in the courts won't even follow the legislature. So it's not just about changing the laws and the bills, it's about following them and doing the right thing. And let's always make every decision based on what truly is in the best interest of the ward. It's that simple. Thank you.
Thank you, Ms. Melendez.
Mr. Hitchcock has waived his time. Irene Roush. Irene?
Hello, everyone. First, I'd like to give you a little introduction to myself so you will know where I'm coming from. I started in guardianship in 1982, there was no training whatsoever. I thought I knew what I was doing, but I was greatly mistaken. So I started a career-long desire to create training for guardians. I have served 133 courses that I have given up, and I have worked on several study commission for change. I've been an advocate for change for guardianship, and I served on the Guardianship Oversight Board. I also created a 100-hour internship for mentoring for guardians in 1992. I know it will work. My suggestions for change: we have 40 hours of training. We need to increase that to 60 hours. We currently have 16 hours of required continuing education every 2 years. I suggest that be changed to 30 hours to include certain topics: ethics, medical training, financial management. I suggest that the examining committee training be changed from currently 4 hours to 8 hours. And they be instructed on what the implications are for removing a certain right. What does that mean to the individual? I had one person tell me they didn't really understand the right to travel. If that's removed, what does that mean? That should not happen. I suggest that attorneys and judges have specialized training in guardianship so that they know what they are doing and the implications for the ward and the alleged incapacitated person. I believe that we need to have a mentoring program, and I would suggest that it could be for indigent wards, and people who have completed the 40-hour course could be serving as the proposed guardians. I would hope that we could have standardized forms throughout the state, and that we could increase the funding for public guardianship. Currently, guardians, professional guardians, are having at least 30 to 50% of their caseload indigent. I would suggest that we have an inventory witness, and we also look at, okay, thank you, I'm sorry, my time is up. If anyone would like to.
You can finish your thought there, Ralph.
I want to leave one last thought with you about the alternatives to guardianship. That yes, they are wonderful if they work. The problem is quite often there are not individuals to serve in that capacity. And also there is no enforcement. If the person needs to be in a nursing home and the person who is serving as their durable power of attorney or healthcare surrogate suggests that, and the individual refuses, there is no enforcement. They cannot help them. So just keeping that in mind. Thank you very much.
Thank you, Ms. Roush. We're going to be working for our next meeting to ensure that the folks who participate through YouTube are able to make public comment. Today we do, and I'm just going to read these comments into public comment, and we will post them on our site. Luann Fleming, she would like to address why attorney's fees are so expensive while someone in conservative guardianship, these fees wipe out the estate. They leave vulnerable, broke, and forced into a nursing home on Medicaid or Medicare. William Johnson, and he has some suggestions for legislative changes. Guardians should be allowed to divulge private information when necessary to defend themselves. He points out the statute which can be accomplished this. OPPG's disciplinary board should be composed of members who are professional guardians, public guardians, private guardians, clerks, and attorneys. This would mirror just about every other disciplinary board in the state, such as realtors, doctors, nurses. And he points out the amendment that could be statute which could be amended. Court orders approving actions by the guardian, including plans and accounting, should be binding on OPPG. They should not be able to second guess in court. In the cases I have been involved with, an OPPG has found fault in billings that were approved by the courts and approved by the clerks. Why are we paying for audits when OPPG does not even follow the audit results? Also, OPPG should only be able to investigate the case for which they receive a complaint, and the complaining party should have some nexus to this case. This should not be a witch hunt. He points out the statute which can be amended to accomplish that. Sam Sugar, I would like to present to the task force a perspective of the physician court examiner and the issues surrounding that aspect of the system and present suggestions for improvement. Rob Davis, thank you for allowing the Office of Marion County Clerk of the Court and Comptroller to submit this comment. If possible, we would be grateful the task force will consider addressing the following matters as appropriate. Consider drafting standardized forms for use by guardians across counties and circuits. Consider amending appropriate statutory law to delineate when and under what circumstances specific conflicts of interest exist in guardianships setting based on any data gathered by the task force as to commonly observed conflicts of interest. Review and possible revisions of statutes authorizing the court to waive guardian education training and requirements. Gain empirical data to assess the amount of time it typically takes a guardian to perform common activities, possibly using a time study, considering using such data to analyze whether statewide or circuit-wide fee guidelines are appropriate. And that is by Rob Davis. Sheila Jaffe, and sorry if I didn't pronounce your last name correctly, NOW and FACTS has been doing court watches in guardianships and probate cases for over a decade, especially in courts of Judge Martin Colin and Judge David French. And I'm not sure if their thoughts got cut off. That's all I have from those thoughts. So we have read those comments into public comment, and we'll probably try to do a better job technology-wise next week when we have our virtual meeting of figuring how people on YouTube can make their comments. Probably that's some of my fault for not announcing how to get on the website, or not. No slam to our technology folks. I certainly appreciate you. Again, we invite anyone to make comments to the website. The website is Guardianship Improvement Task Force.com. We're not too creative. We made the website exactly what our name is, .com. So that is a good way to post your comments. Again, the members of the task force will be receiving those comments. I want to thank the public that is here today for your interest in this topic. Obviously, it's a topic of tremendous passion on your part. Seems like so many of you have been touched by the guardianship system in a negative way, and that is certainly disappointing. I can't convince you of our intentions and why we formed, but I could say I know what my intention is, and I think that can speak for most of the folks who we invited here. It is to make the system better. And you know, and I don't want to create unrealistic expectations at the same time. You know, the old saying, "How do you eat an elephant one bite at a time?" It will not be a one legislative year solution, but it will be something which we have to keep tenaciously improving the system as best we can with good ideas, and then with thoughtful ways to make sure that it doesn't have unintended consequences, as was mentioned on some of the past improvements that they thought were made. And so I think that commitment is by each of these task force members, and we look forward to our next meeting. Thank you for your attendance here this evening.
I didn't hear it come up at all.
Well, we adjourned, but you certainly can.
I just checked my, I was checking the